Okay, I think we're ready to go. Good morning, everyone. Welcome to the Climate and ESG Legal Risk Management Summit. Apologies for the slight delay. I guess the tube is not our friend today, but here we are. Welcome. I'm Catalina Zugrovescu. I am a director within Pollination Advisory Business, and today I have the pleasure to be your chair. So thanks very much for coming, and thanks very much for having me. I guess in my role at Pollination, I work with financial institutions to really drive their ambition and really unlock the potential of their capital towards net zero, nature positive. But I guess today's summit and today's session is really about grounding ourselves into the realities of the law, the regulations, the policies upcoming, and really using that to drive the ambition moving forward. Tackling ESG issues, climate issues, but also increasingly nature and biodiversity issues. So thank you for your proactivity in coming today on a Monday before Easter. That is really, really needed to really drive the world to what we call net zero, nature positive, and really align to the Paris Agreement and beyond. I hope today's session will give you a few things. I hope it will give you a sense of preparedness in terms of how to navigate a really dynamic environment where the bar is raising for sure. And the bar is getting higher, not just from a legal regulatory perspective, but really in terms of what society is expecting of us. So I do hope today will give you a better sense of preparedness. It will also equip you with tools to manage, monitor, influence, and also enforce ESG risk management, climate risk management, and start to take action on nature and biodiversity risk management. And I also hope you will create the necessary headspace such that you can go to your respective organizations or work with your organizations to really turn ESG, climate, nature risk management, not just in a regulatory exercise, but really into a firm-wide strategy exercise. These are important moments. These are big changes. They do take time. They take time to absorb, to implement. But this really goes beyond the legal requirements. It goes towards firm strategy. So thank you for coming today. We also thank our sponsors, Allen Overy, Pollination, Slaughter MA, as well as our supporters, General Counsel, Sustainability Forum, and GLG. Thank you very much for your support. Just a few housekeeping for today. Fire exits over there and at the back. Hope none of the Oxford Circus things going on here, but here they are. In terms of navigating today, there is an event app. You should have an email with instructions on how to download the agenda, the speakers, all the details are there, so please download it just to navigate for the day. Do wear your name badges so we know who you are, and when we introduce ourselves. And also, please complete the delegate questionnaire, which is on your desks. There is a very interesting and timely bottle of champagne just before Easter. There is a reward for those people that completed. There is a selection at the end of the event where there's one lucky winner. And finally, we thank our virtual audience as well. Thank you for your patience. I hope you managed to get all of the information that you're looking for, so thank you for joining us, both in person but also virtually. And with that, I have the pleasure to introduce our first keynote address, Ana Carolina Salomao Quiros, who will be talking today about the growing importance of climate and ESG legal risk management. Just as a bit of an intro, Ana Carolina is a partner and chief investment officer at August Goodhead. She's an experienced tax and financial lawyer, having studied in Brazil, England, and France. And she deals within her role with investors structuring financial deals that fund transnational and local cases of human rights, consumer protection, environmental damage, and climate litigation. Ana Carolina, welcome.
Good morning. It's a pleasure to be here this morning talking with you today about this very important topic on the intersection of climate and ESG issues with legal risk management. As Catalina said, I have somewhat an odd job title. I'm Chief Investment Officer of a law firm, meaning that I deal with investors and business partners through most of my days, which gives me an interesting perspective. I can observe ESG issues from different lenses, using economics, finance, and law. And if you allow me, I would like to explore this different perspective and bring a little bit of law and economics to the room to discuss that. For those that have gone to economic school or those that have studied economic theories of contract law, it will all sound familiar. For those that have not, which I assume is a relevant part of the room, bear with me, I promise that it will make sense. One of the key theories that students of liberal market economics study is the Coase theorem. Coase theorem is the basis for studying the enforcement of property rights and states that under certain conditions, under perfect market conditions, private bargaining can lead to efficient allocation of resources. In other words, if transaction costs are low and then the property rights are well defined, parties can bargain by themselves to achieve mutually beneficial outcome. Essentially, the theorem proposes that when you are disputing over property rights, parties are better off bargaining by themselves rather than leaving a bureaucrat interfere and help them to solve the disputes. And it would apply even when the disputes are over the externalities caused by the economic activities developed by the parties. So let's imagine a fictional situation with a textbook example. A dispute between a factory that, when developing their activities, produces a lot of noise, so a noisy factory, and the neighboring community impacted by the noise produced by this factory. Coase theorem assumes that under perfect market conditions, these two parties, the industry and the affected communities, should be able to bargain and reach mutually beneficial outcome without government intervention. The theorem proposes two potential scenarios, both of them depending on the economic value of their market activities. So if the market value of the firm's output, if the market value of the firm's production is higher than the market value of the damage caused to the neighbors of the noisy factory, the factory should be able to continue their noisy but yet very valuable production and use the revenue to compensate the affected parties. If, however, the market value of the damage is higher than the market value of the factory's production, the factory should stop their activities, provided that the affected community, its neighbors, are willing to pay to compensate the factory owner for the cost of stopping the production. This would be the price that an affected community would be willing to pay for having an environment that's not polluted by sound. Well, of course, it doesn't happen in real life. Could you imagine this happening? And why it doesn't apply to real life? Well, just like most of the economic theories, it depends on certain assumptions. And one of the biggest assumptions, actually the main assumption of the Coase theorem, is that the parties are bargaining in a perfect market. A perfect market would depend on the absence of power imbalances between the parties. So factory owner and affected communities would be able to bargain as equals. Another condition for a perfect market is the absence of transaction costs. So the parties would be able to bargain to enter and to continue in the bargain process freely at no cost and for as long as necessary. And the parties would have no liquidity constraints, so they can stay in this negotiation for as long as necessary, not being pushed to hush any decision. And in this perfect market, information is complete and symmetric. What one party knows, the other party knows as well. There is full transparency and commitment to informational completeness on both sides. Now, let's take the textbook aside. We are not talking about the noisy factory, switch it off, and let's think about something else. Let's bring it to the real world. Let's imagine a mining company in Brazil, operating in Brazil, whose activities is polluting a river with toxic chemicals, byproducts of their mining activities. And let's imagine on the other side, the community that is affected by this activity, a community that relies on this river that is being polluted. Let's imagine that these neighbors include fishermen, reliant on the river to fish and provide for their communities. They include families and children for whom the water was, before pollution, a place of leisure and enjoyment. Let's also imagine that among the affected are indigenous and traditional communities that have been there for centuries and for whom the river is considered sacred. People who have lost access to the river for all of their essential economic, social, and spiritual needs. If we follow Coe's theorem, under perfect market conditions, these two parties, the mining company and its neighbors, could reach an agreement by themselves, bargaining to achieve an optimal outcome for both, based on which side has the property rights with the highest market value. I hope that you now can see where I'm going with this law and economics theory. When we take this Coe's theorem from the abstract and put into the real world, it's clear that its logic doesn't hold. The truth is, while efficient outcome might be reached by parties negotiating a perfect market, the perfect market does not exist in real life and have never done. Reflecting on this very real example of a mining company responsible for environmental pollution in a culturally rich and biodiverse Brazilian community, we can clearly see the power imbalance between the parties. The asymmetry is obvious. Could you imagine a leader of indigenous community knocking on the door of a polluting factory to complain and claim for compensation? Do you imagine that the mining company would be open and transparent about the extent of the damage caused to the environment? Can you imagine that the community would be able to afford to bargain with the mining company in parity of arms for as long as needed? Of course, no, you cannot. And this is the reality where we find ourselves today, and why corporate accountability for externalities caused by economic activities can be pushed through litigation. The total responsibility for environmental, social, and governance issues is often only achieved after taking the powerful companies to the court. A more modern approach of the Coe's theorem in a recent study has shown that going to court levels the bargain power between the parties by imposing litigation costs to both. Parties should be able to leverage on those resources to achieve a better settlement or a favorable court decision. But still, it is difficult to imagine in our example of the indigenous and affected fishermen community, how could they do that? How could we ensure that parties are able to go to the table or to the courts and equilibrium. Group litigation and funding for this kind of dispute is part of how we are doing this at Pogus Goodhead, one of the world's premier environmental group litigation firm. We advocate for millions across the world who have been affected by environmental harms caused by large corporations. By giving our clients the chance to bring their case collectively with financial support and protection, they enter into the negotiation in parity. We are tilting the power scale a little more towards equality. It's about bargaining power. We are now allowing people who would otherwise have no means to pursue legal remedies to do so at no financial cost for themselves. The prospect of group litigation is among the most effective ways of holding powerful corporations to account over their actions. It is also relevant for its potential to prompt companies to proactively adjust their business models in light of ESG risks, ultimately encouraging better corporate behavior and reducing the chances of future infringements on human rights. Other associated ESG legal risks, other forces associated with ESG legal risks also nudge or even forces companies to adapt. Reputational costs, consumer preferences, the emerging scientific evidence on climate damage, which I foresee that will make climate litigation skyrocket, and the growing trends towards regulation are powerful to enforce great adherence to ESG principles. I am a firm believer that all those tools are pressuring points combined that are shaping a new landscape for corporate accountability and improved governance. The world has changed, and the business that do not adapt will lag behind. Do you remember the perfect market conditions that we talked about at the beginning, and how it was difficult for us to imagine that the damaged community would reach equal balance with the polluting factory? Well, I'll show you how we are doing this at Pogus Goodhead. One of our largest cases at Pogus Goodhead concerned the collapse of the Fundão Dam mining in Mariana, Brazil. This, which was the largest environmental disaster that has ever occurred in my country in 2015, has liberated over 50 million cubic meters of toxic tailing dams, which were dumped to the Rio Doce, or Doce River. To make a comparison, it is as if a volume of toxic mud that would be equal to 22 Empire State Buildings have run through a distance that would take you from Scotland Highlands into South Thames here in London. It killed 19 people and affected the lives of hundreds of thousands more, not to mention the ecosystem. Even the corals were affected. We are representing over 700,000 Brazilians affected for the collapse against the Anglo-Australian mining giants, BHP and Vale, who were responsible for the dam's operation. As we prepare to go to trial this October, this is now the largest group litigation of its kind in English courts, with recent estimates by the accountancy firm Crowe placing the damages on over 36 billion pounds. With its sheer size, the potential of this case to transform corporate accountability on ESG through its precedent cannot be overstated. In another significant case, showcasing also a very sheer and clear imbalance of power between claimant and defendant, we represent 1,600 of orange growers based in Brazil against the powerful Cutrale family, for engaging in unlawful cartel practices to control the export of orange juice to the international markets. This practice pushed many orange growers out of the market and forced those that stayed in buying following the cartel terms. The parties that were then helpless have now gone to the courts. The English courts has accepted jurisdiction, and we are preparing to go to trial in the near future. I could go on and on about numerous cases where we are working to ensure equal access to justice for people and communities affected by corporate wrongdoing, because unfortunately, there is no shortage of illustration of illegal and criminal corporate behavior. But the encouraging thing is that this market for this type of litigation is growing exponentially. Last year, we have secured the largest ever litigation funding deal of a bit over $500 million to secure the funding and finance for a portfolio of environmental cases. That means that our work really is only getting started, and even better, I'm not alone. I have many colleagues with me, many of them here in this room. So, whether it is fishing communities in Peru seeking compensation from Repsol, a Spanish and Dutch-owned oil company who destroyed their coastal waters, whether it is an indigenous community living in Barcarena in Brazil, suing Salik, the Saudi sovereign wealth fund, for its role in controlling Minerva, one of the largest protein producers in the world, or communities in Brazil taking the chemical company Norsk Hydro to court over aluminum pollution in Pará. The landscape of corporate accountability is changing rapidly. The status quo can no longer be taken for granted, and the cost of ignoring ESG legal risks is skyrocketing. At the heart of these cases is essentially the principle that citizens should have the right to challenge corporate wrongdoing and have their rights and the rights of their lands respected. Group litigation and financing for it is helping us to enforce those rights. And to close, I would like to take you back to the example of the indigenous leader knocking on the door of the polluting factory. While it might have seemed unbelievable, this is the new world. It is not as unimaginable as you might have thought from the beginning. Well, in respect of power imbalances, we still have a long way to go. But from what I see, and from what the market is now, I'm betting on David. Goliath, better watch out. Thank you.
Thank you very much. That was thought-provoking and optimistic at the same time. Our next session is a panel on key trends in climate and ESG litigation. And I'm inviting Matthew Townsend, who will be our moderator for today's panel, to join us today. Matthew is a partner and global co-head at the International Trade and Regulatory Law Group, Allen & Overy. He has extensive experience advising financial institutions, corporates on economic and trade sanctions, export control, and wider strategic level trade and regulatory issues such as World Trade Organization rules, FDI regimes. He works closely with a range of clients on developing internal compliance programs and training covering sanctions. Welcome, Matthew, and please introduce our panel. Thank you.
Very good. Thanks very much for the kind introduction. Hello, everybody. Good morning. What a better way to start the week than looking at key trends in climate litigation and ESG litigation. So I'm going to try and catch up a little bit of time as well, not to eat into Jeff's very interesting session, I've no doubt, on director's duties, which we will touch on. So what we're going to try and do for the next kind of 30 minutes or so is kind of set the scene a little bit, because I know there are sessions which follow, which dive into some of the, it's going to dive into some of the more detailed aspects of the cases, themes and trends, etc., that we will touch upon. So we are going to take a kind of close look at some of those themes. Right, so let me introduce our esteemed panellists. So first of all, Paul Benson, senior lawyer at Client Earth. He's a climate litigation specialist with a strong expertise in corporate management of climate risk and shareholder rights. He had 10 years in private practice before joining Client Earth. So Paul, a warm welcome. Kate McKenzie, CEO and Director of Climate Change Legal Initiative, having contributed to the initiative since its inception and over, I think, 20 years of experience as a lawyer mediator specialising in social justice, climate change, law and litigation. So Kate, welcome. And last but certainly not least, Mike Clark, Founder Director of Ario Advisory, responsible investment advisory firm, an actuary, I think, by profession, and with a very esteemed advisory credentials and expertise in the investment, pensions, risk and governance spheres, and was a NED at Brunel for nearly 4 years. So welcome to our panellists. What I propose to do is give each panellist, and I am going to be quite tight on time on this, right, to 2 minutes each, just to kind of set a little bit of scene, share some thoughts on some of the kind of things we're going to touch on in more detail, and perhaps I can invite Kate to kick us off on that.
Yeah, sure. Good morning, everyone. It's nice to see all your happy, smiling faces on this beautiful windowless room. I will just give just a brief little sort of setting of the scene, the landscape, as you will. We're seeing trends in climate litigation. Of course, they're shifting over time. When C2LI started 5 years ago, we worked on a scenario-based methodology. We had 3 basic litigation scenarios. We are now having to sort of explain or redefine what those scenarios are, because the landscape really has changed. The growth rate in climate litigation does appear to be slowing a bit. The LSE's 2023 snapshot indicated that in the last 3 years, we've seen a slight decline in the number of cases that are filed over the previous 12-month period. So we went from 266 to 200 and something, and now we're at like 190 over the last 12-month period before the 2023 snapshot was published. So the growth rate is slowing slightly, but not significantly. We are still adding new countries that are seeing climate change litigation. One of the things that C2LI always has focused on is what we call not the usual suspects. So countries that have seen either little or no litigation, that number of countries is decreasing. More and more countries are seeing climate-related litigation. We're also seeing more cases against corporate actors. The first few waves of climate-related litigation were really focused on human rights and looking at rights-based claims and some other legal grounds, but really looking at overall climate policies or projects. And now we're seeing a lot more focus on corporate actors. We're certainly seeing a growth in climate washing cases. Just last week, the Dutch court found against KLM for their claims regarding climate. And we're also seeing litigation in investment decisions sort of increasing. So the shift of climate-related litigation is really going in the direction of corporate and financial actors. Shall I stop there?
Yeah, no, that's great. I want to come back to some of those kind of themes and what the horizon looks like in a minute. Mike, can I ask you to say a few words?
Sure. So I'm a great fan of climate litigation. I find I'm usually on the side of the citizen rather than the organisation being sued. I'm an actuary, so we're meant to be quite good at risk and uncertainty. I like to pick up the points from Anna Carolina on COES. Clearly, COES doesn't work. You don't need to have done a PhD in economics, that if systemic climate risk is ignored, then the supply of systemic climate risk is probably rather more than demand. And that raises the rather uncomfortable thing that price does not work. And price doesn't work sort of rather fundamentally tackles the finance sector. And of course, equilibrium is even more of a problem, which leads on some of our work with the official climate scenarios. I hope most of you know that official climate scenarios are not decision useful. If you saw some of the stuff being published by UK pension funds, I have a fine example here which says if we get to 4 degrees in 15 years, our pension scheme will lose 60 or 70 bips. 4 degrees, 15 years, 60 bips. Absolute nonsense. So there's some challenges in the finance sector. We had the privilege of working with my Exeter hat on for USS last year. We produced some narrative scenarios. This sounds very strange to finance people. No numbers, narratives, which are driving their strategic risk management and then strategic allocation. So lots of things going on in finance. I hope we cover some of them in the panel, but I'll stop at that point.
Mike, thanks very much. Paul.
Thank you, Matt. I think Kate touched on it, really. I think we're seeing climate litigation evolve pretty rapidly in a number of different fields. We have climate tort litigation, which is a really rapidly developing field. We've seen recently in the New Zealand courts a group of dairy and agriculture companies primarily being sued for breaching New Zealand tort law. And for those of you not familiar with notions of tort law broadly, that encompasses concepts of a duty of care that these companies owe under the common law of these jurisdictions, a duty of care to citizens in the country or parties with whom they're dealing. And the Supreme Court in New Zealand has recently refused to strike out that claim, so that will go forward, which is an interesting development, certainly for us common lawyers. We see greenwashing cases, as Kate alluded to. Just last week in the Netherlands, KLM was found liable for its greenwashing practices. We see a really developing field in terms of directors' duties, and I know that Jeff will be touching on that later. It's a subject that's very close to my heart, as I led our litigation against the Board of Directors of Shell. So looking forward to talking about that a little bit on this panel. And so what you see, I think, is corporate actors being held accountable, or claimants seeking to hold those corporates accountable. Not just, I think it's important to note, in the fossil fuel industry. I think historically we have seen fossil fuel defendants largely being targeted, and that's in a sense unsurprising, because 86%, I think the figure is, of anthropogenic climate change is attributable to those companies. But we're seeing increasingly other high-emitting sectors being targeted, including, for example, the automotive industry has been sued a number of times in Germany. We've got a cement company being sued in Switzerland for climate damages. And we're also increasingly seeing financial institutions being targeted. Friends of the Earth Netherlands recently has announced that it will be taking legal action against the Dutch bank ING. And of course, they were the successful claimants in a recent claim against Shell, whereby the Hague District Court ordered Shell to reduce its global net emissions by 45% by 2030. And that represents, of course, probably the starkest example of litigation risk. That would be an existential challenge, really, for Shell, and one with which it has not yet grappled.
Super. Paul and our other panelists, thanks very much for those introductory comments. Maybe if I can kick off the discussion, and actually before I do that, we welcome comments, questions as we have this discussion, so I'm going to try and leave a bit of time at the end as well, but if you've got observations to make, you've got questions, just put your hand up and we'll bring that into the discussion. So very much encourage you to do that. So if I perhaps have to start with Kate. So we touched on a little bit of some of the kind of trends where cases are being seen. What's your kind of sense as to the horizon a little bit? What does that look like in terms of the type of claims that are likely to be brought or will continue to be brought. And I think also want to make sure we touch on claims against corporates, but also actions against governments, which we've not really talked about yet. So I'd like to draw those out. And then a follow-on question is, certainly when I talk to corporate clients, there is a lot of concern about greenwashing. Now, greenwashing is very much, as we all know, an umbrella phrase. So it'd be great to get your thoughts on the kind of greenwashing type claims, and actually, ultimately, how worried should corporates be in that space?
How worried should corporates be in the space of being sued for climate washing?
Greenwashing, specifically.
Well, they shouldn't be concerned at all if they comply with the law. To answer your question, sort of, what do we see coming? I think one of the areas where we're going to see a lot of litigation in the next few years are based on new reporting requirements, right? So you've got a lot of the new EU reporting requirements. You've got the SEC has just come out with new rules. Of course, they're being sued already. But I think that we are going to, certainly supply chain due diligence is becoming a really, really big factor, especially anyone who wants to do business in the EU with the new Triple D. So there are a lot of new areas where, particularly I think from a due diligence perspective and a fiduciary duty perspective, so really I think where we're going to see this trend going is looking at duties of those responsible in making decisions really are going to be, whether that's due diligence or fiduciary duties or investment, it is the duty to make a well-informed decision that is going to be, that we're going to see. And that well-informed piece, I think, leads us to another new trend. One of the things that we at C2LI work with really closely is we work with the legal profession and law firms to really understand, as a legal profession, we are going to have to grapple with our responsibility here. And so I think we're going to see an increase in sort of challenging advice that is given. There's this discussion of advised emissions. And you also mentioned, Matt, governments being sued. We've seen governments being sued for many, many years by citizens. We are now seeing more anti-regulatory climate suits where I mean, in the United States, you have 16 different states are suing the federal government over the new SEC rule, right? So that's a little bit of a strange situation. But a lot of these, I think we're going to see a lot of strange bedfellows too, as we go down this road. That was kind of a meandering answer, but
no, it's interesting, and this actually bring Mike into this as well. So I want to pick up specifically this point about corporate reporting and whether it's CSRD and the acronyms in this space are never-ending, TCFD, so on and so forth. But actually, if you drill down, well, if you're going to litigate against a corporate in respect of what's disclosed, then you're into essentially, in the UK context, capital market rules, in some contexts, FSMA, etc. And those claims are notoriously quite difficult to bring, particularly if you look at the disclaimers that tend to accompany any form of more formal financial type reporting. Do you have any kind of thoughts on that? I mean, the US may well be different, but in the UK, for example, those claims historically have been very challenging to actually bring. Do you have any, well, Mike, you have any thoughts on that?
Well, I'm going to flip it back to the finance sector, picking up Paul's point. If you're a trustee and you looked at those figures and you had to defend them, are you going to get sued? Is your investment consultant going to get sued? Because basically, if you had a climate scientist and you asked them, what do you think of that? They wouldn't know whether to laugh or cry. So we've got to the point, the great separation between the societal risk management of climate change, which is one thing, and the way finance manages it. You probably all know that the damage functions in the NGFS scenarios are hopeless. One of my actuarial colleagues thinks that Nordhaus by now should have been indicted. There's a clue to lawyers. So I think one of the gaps is the way that finance is dealing with the problem. Because if you look at risk and uncertainty, you just can't model a lot of this stuff. And of course, we finance people, we actuaries, we just love numbers. But if you can't capture mass migration, Trump re-elected, yes or no, economists cannot model asset prices, stranded labour. Think of all the things that aren't in the official climate scenarios. So part of the greenwashing problem is actually a thinking problem. We just think about the issue the wrong way. Investors, we love modern portfolio theory, but modern portfolio theory assumes that risk is the volatility of market prices. It has no interest in the source of that volatility, that risk. So there's a whole load of rethinking going on. Leading pension funds are realizing this, and we're moving towards a much more narrative, qualitative, trying to access the real world. You know, discuss at what point is the Bank of England open to at least reputation risk if it doesn't move on from the message that the insurance and banking sector has effectively received, that this is a compliance exercise. I was working with a bank guy, and he was doing lots of climate scenario work, and I said, that's very good. How's it has changed the strategy of your board? He looked rather sheepish and said, well, not at all, really. So we've got a big problem which is starting reporting. It's becoming a governance issue. So I encourage the lawyers to make this a governance issue, because governance beats investment every time.
Yeah, no, I agree with that. Did you have a question?
Yeah, I was just wondering, given that the basis of the issue that the current climate scenarios don't work, how do lawyers who are even less versed in the climate scenario then bring something alternative to a board saying this is the credible model you should look at, if there seems to be a systemic, all of the finance industry is relying on the same figures from, say, the IPCC, which...
Well, let me have a go at that. Firstly, you use the word model. That probably defines a mindset. You may wish to think of a real-world model as opposed to a financial model. We've done some work in Canada, and one of the law firms in Canada started bringing good questions to pension fiduciaries, like, please tell me what's in the model, what are the assumptions, what's not in it. So the more it becomes a governance issue, and you sort of go above the investment issue, which has defined the problem narrowly, I think the way that pensions lawyers are tackling it is to do that.
Okay. Paul, I just want to pick up on this point around reporting and data, because this is definitely a concern as we speak to many clients. Yeah, is client kind of rubbing its hands with glee as it sees this whole wave of CSRD reports. I mean, TCFD is so high level, I'm not sure you could do a great deal with it. But CSRD is a game changer in my view.
You can do a lot with TCFD, we'll come back to that.
Right. So are you kind of seeing that, great, we're going to suddenly have a whole new kind of subset of data to crawl over and then start, bringing litigation?
I think the short, you're probably all hoping and expecting me to say yes to that question.
I'm not sure I'm hoping, I'd just be interested.
The answer really is no, because the way in which companies should be, and a lot of companies, it's fair to say, actually are thinking about CSRD, CSDDD, those sorts of obligations, is not as, oh my goodness, if we disclose all of this stuff, then we're going to get sued. Rather, it's an exercise that is helpful for these companies because it focuses their minds, it provides them with legal certainty in terms of what are their obligations. And it was interesting actually to see the outcry as CSDDD was being diluted from a number of companies in different sectors across Europe, saying, actually, no, this is not what we want. We want the legal certainty of, I hesitate to say high ambition. I think that would be putting it too high, but at least
some ambition.
Some ambition, some disclosure requirements which are meaningful. And at the end of the day, in a sense, this is a risk management exercise. And I think Mike hit upon it very nicely. The extent and scale of climate risk is just unprecedented. And I think that's the issue with which a lot of companies are just not grappling. A lot of high-emitting companies are very good at putting out reassuring messages to the market, to shareholders in glossy brochures suggesting, no problem, guys, we've got this in hand. Our strategy is aligned with the 1.5 degree goal of the Paris Agreement. when you scratch beneath the surface, a lot of that is nonsense, and it doesn't stack up, and it is effectively highly sophisticated greenwash. And that was the basis of our claim against the Board of Directors of Shell, which I'm happy to talk about a little bit more later on.
Yeah, okay.
Can I pick up your TCFD challenge?
Yeah, please do.
So you've heard me speak about pension fund trustees and climate publications. I guess this is an invitation to either lawyers who have asset managers or as a client, or those who might wish to tackle them from the other side. I haven't done the research yet, but my understanding is that investment managers' TCFD reporting can include lovely fund reports where on a fund, on some of the reports, there's a nice little exhibit. And because they fundamentally use the same numeric modelling as pension trustees from the, let's call them the usual suspects, the 1.5 degree exhibit on this fund manager's TCFD report is indistinguishable from the 3 degrees exhibit. Now that seems to me slightly surprising. So if you guys are interested in research, either to get ahead of an interesting conversation with investment manager client or to accelerate progress. So just one place, I haven't had time to look at it, but I'm told there's some very interesting things out there, and at some point that will arise.
Yeah, okay. Okay, yeah, please.
I just wanted to make a point that I think is often sort of left out of this discussion. So all of these new reporting requirements, right, they're important for a lot of reasons, right? But I think we're going to see over the next few years, as a lot of these new reporting requirements go into effect, we're going to see a lag in enforcement capabilities, because it's a lot of information that's coming to a lot of places, and the question is, have governments, have EU member states, they have a little bit of time, but has there been enough resource put into the enforcement side of this, or just the going through all of the reporting side of things? So I think we're going to see a gap there.
Yeah, okay. Can I also, I want to bring you in on this, and you previously mentioned this, so just super brief if you can. So many in the room will have been tracking the kind of ups and downs of CS-DDD, the European proposal for supply chain due diligence. We've seen, of course, duty of vigilance in France, which is actually being used now as quite a powerful tool, German Supply Chain Act, so on and so forth. Assuming CS-DDD finally makes it into the official journal. I mean, do you see that as a game changer in terms of claims arising, or more evolutionary? What would be your take on that from a litigation perspective?
Well, I think it's going to be interesting. One of the areas that I think we may see some conflicts arise is when we're looking at a supply chain, and an example might be the easiest way to think of it. So if you have a supply chain, and part of your supply chain in your manufacturing production supply chain comes from a country where the law states that if energy is used to produce something that is green, renewable wind turbine blades, for example, right? That is going into a green industry. But the energy that is used in that particular country is labeled as green because it is going into a green product, even though it comes from coal. Do you now have, if you just checked the laws, the law says this is green energy, great, I can use it in my supply chain. There's a conflict of laws here, right? The country that has that law actually is using, the company is actually using coal-fired energy to create this product. So you, as the company who operates in the EU, have the requirement to now, you have the obligation to do your due diligence and not just say, oh, the law says it's green, but actually to go deeper and say, is it in fact green? So I think we're going to see some sort of technicality issues there. We may see some anti-regulatory litigation. But I think that the time lag, particularly in the U of the CS-DDD, I don't think it necessarily will lead to increased litigation. I think it may give companies, just as you said, I think it may give companies a lot more ability just to be more transparent and reduce their own litigation risk.
Yeah, and obviously civil liability mechanism that sits in Triple D has been heavily watered down from where it at least was. So, I mean, essentially, I think we've got largely a member state by member state position now. Is the reality. But Mark, you had a point in the asset management industry in particular.
I think that supply chain point is a really interesting one, because typically finance doesn't think as well about that as the sort of real world economies. But I'll give you some examples, and picking up this enforcement point, and I hope I agree with this once I've said it, but it strikes me that maybe finance will be a stronger enforcer than the law. We need all these acceleration mechanisms. I was working with a asset owner the other day, and some of you were familiar with the investment managers that were withdrawn from Climate Action 100+, and they were considering terminating their mandate with JP Morgan Asset Management as a sign of great disapproval of their withdrawal from Climate Action 100+. Some years ago, I recommended that BlackRock had three choices. They could continue to lose clients from either side, those that thought they weren't going fast enough, those that thought they were going the other way. Or Larry Fink could say what he really believes, which he can't. Or they'd split their business into two. Well, you would have noticed that recently BlackRock have retained their position in Europe in one of these collaborative organizations, but they've withdrawn from it in the US. So I actually think that asset owners who I place great trust in because they are very close to citizens. I don't know if I have time to get to insurance, but I attended a meeting of the International Association of Insurance Supervisors recently and had the pleasure of speaking. Came away mildly depressed. We may not have time to discuss that. But I think the supply chain issue, so that asset owners appoint investment managers whose business model aligns with the asset owner's real world view, and the same applying to investment consultants. They are the principal supply chain consultants, asset managers. So I think the supply chain argument, and in fact we had an actuarial webinar on this topic last year, I think supply chain argument may sort of come up the rails a bit.
Yeah.
Finance?
Yeah, okay. All right, let's change tack a little bit. So, Paul, you've touched on this. I think we'd be very keen to learn a bit more around your thoughts on directors' duties and the Shell action in particular. And this is the theme we're going to touch on during the course of the day, and very much. Certainly when I speak to boards, directors are increasingly nervous of personal liabilities. But actually, probably more thematic is understanding what the parameters now are of their fiduciary duties. So it'd be great to hear a little bit about the case and your kind of thoughts.
Yeah, absolutely. Thanks, Matt. So to address that final question first, perhaps, what are the parameters of their duties? I think the difficult thing about the court's decision in our claim against the Board of Directors of Shell is that directors have been left with very, very little guidance about how they actually should be managing climate risk. Certainly it was our feeling that the court, in dismissing our claim, for those of you who aren't aware, didn't really grapple at all with the evidence that was put before it, and what climate risk means for companies like Shell. And of course that wasn't an assessment by the court of the merits of our claim, but simply a rather procedural, technical decision. And I think that presents a lot of difficulties, and we've seen, in fact, the decision having been pretty heavily criticised by a number of eminent barristers across the legal community, and indeed by a former Justice of the Supreme Court, most strikingly, Lord Carnwath, who in fact was chairman of the Law Commission at the time that the Companies Act was reformed, and those sections 172 and 174, for the lawyers in the audience, were crystallised in the Companies Act. And so what we have is a slightly a picture which is not completely clear, really, in terms of directors' duties in the UK and indeed across Western European jurisdictions, where a lot of these duties find resonance, and there is essentially an equivalent of the duty to take reasonable care, skill and diligence, the duty to act in the best interests of the company. And it's worth, if you like, going back to sort of first principles and the context in which we brought that claim. And one of the points of context certainly is the scale of climate risk that Mike has alluded to. Shell's board, for example, acknowledged a great deal of that risk in its annual report to shareholders. The difficulty is it's doing very, very little about it, in our view. And that view, interestingly, was shared by a significant pool of institutional investors who, if you like, have seen the light. There is, I think, a bit of a split developing in the institutional investor community between those pension funds and asset managers who have realized that climate risk fundamentally affects the value of their portfolio. In fact, it goes to the very core of the value of their portfolio. Certainly for pension funds who need to have that medium to long-term view in the interests of their beneficiaries. And so that's why you saw a lot of those investors coming out to the tune of over $500 billion in assets under management and supporting our claim. And that's why you also see action taken by some of those investors in other jurisdictions against other companies. So it really comes back to that climate risk. What does it mean for a company whose primary business product is fossil fuels? When the International Energy Agency says that in every transition scenario, demand for those products is going to decline. What does it mean in terms of litigation risk when you have judgments like that of the Dutch court saying you are now under an obligation, Shell, to reduce your net emissions by almost half by 2030? And what does it mean in terms of physical risk and supply chain risk? Systemic risk to the wider economy, I think, is by many companies really not very well understood. They may understand the types of categories of climate risk that affect their company, but what about the broader economic and systemic risk that climate change presents?
Okay, I think we have a question. Yes, if you've got questions, if you would kindly give us your name and organisation and then your question, that would be great.
Thanks. Hi, I'm Janina from White & Case. It's a question probably for Paul, but grateful for views from others too. Obviously, the Client Earth Shell decision, hugely disappointing for many as a result of what you say about, the missed opportunity for not giving directors more guidance on their duties, on how to comply with their duties. And as has been mentioned, there's lots of really interesting climate litigation decisions or pending cases, and before the Dutch courts, the French courts, New Zealand. We've discussed a few, and for those of us tracking climate change disputes globally, there's lots to say. My question was going to be about what we think is next for the UK courts with climate litigation and greenwashing beyond, obviously Client Earth Shell disappointing. And beyond ASA rulings, which are non-judicial in the greenwashing context, what do you think is next in terms of climate and ESG litigation cases in the English courts?
Yeah, Paul.
Thank you, Elena. I think the answer is that climate litigation is very much here to stay. I don't think it's the case, certainly not because of this one decision, if you like, in our claim against the Royal Shell, that other potential claimants will look at the UK courts and think, well, goodness, there's no chance. I think that, as I sort of mentioned before, the scale of climate risk and the way in which companies are managing it, there is such a gap there is such a huge discrepancy that companies are leaving themselves exposed. And we are fortunate, really, I think, in the UK to have an intellectually rigorous and fair judiciary, and I think rightly England and Wales has an excellent reputation for its legal system around the world. And so I think with a lot of high-emitting companies obviously being based in the UK, or there are claims that are being able to be brought in the UK for actions of companies' subsidiaries abroad. We've seen that with the Okparbi decision in the Supreme Court, for the lawyers among you. I think we will see this trend just continuing to evolve, and I don't think it will be the case that claimants, whether they be NGOs, investors, contractual parties, what have you, and we are seeing that pool of potential claimants widen, as I said. I don't think it's the case that they will avoid the UK, if you like, if that was the sort of subtext to your question. Rather, I think it's the case that as the energy transition accelerates, as climate risk materializes in ever more stark terms for these companies, we will just see litigation, not just in the area of directors' duties, I should say, but also in climate tort, other areas continue to develop.
But there is a question, maybe Kate as well, get your views on this, as to whether we're going to see a degree of forum shopping.
Well, I mean, we already are. I think that you mentioned the UK judiciary. I think it's important also to recognize that there is lots of movement happening right now that pertains to the legal profession specifically, right? The Law Society of England and Wales has put out guidance on climate change. Other law societies and bar associations across the world are really looking at this and really looking at what is the legal profession's responsibility here. And so there are, you know, most law firms in the UK are now take step one. Let's get to climate conscious lawyering first, and then the next step is to get to climate competent lawyering. And well, I mean, you got to get to one first, right? So, but it's also important to recognize that climate change is impacting, just like it impacts every area of life, it is impacting every area of law. And when you're an expert in a particular area of law, that's your expertise. You don't have necessarily time to also become an expert in climate change. But the legal profession is being held to a higher standard. That guidance is going to, it's a matter of time before it becomes the rule. And so I think there may be, I don't know if we're going to see climate-related litigation brought against lawyers, but there is this new sort of newish concept of advised emissions. It is controversial among the legal community, but there are a group of lawyers who are working on methodology. How do we calculate the emissions that are caused by our advice? So there's a lot of really interesting stuff happening in the legal sphere. One other thing I just want to mention briefly is a new kind of case that I believe we may see more of, and that is just transition cases, right? So I mean, yes, we still talk about them as climate cases, but they're really looking at how are actions that are meant to bring the transition further and to be positive when they have negative impact on communities that are already marginalized or minoritized. Then we're going to see some of those cases. A really simple example locally here is if you are a wheelchair user and you have an electric vehicle charging points are not very accessible, right? Either the bollards are in the way, you can't get the chair through, or the screen is too high for you to reach or read. So there are some strange new sort of issues that we're going to see in the. I think a few years ago, everyone was incredibly surprised why Greta Thunberg was protesting a new wind farm. Well, it was a wind farm that was going to be built on indigenous Sami land, and the indigenous community hadn't been incorporated into any decision making. So I think we're going to see some just transition cases happening, particularly here in the UK, because there is movement in the direction of transition. So I think that's another trend that we may see coming.
Okay, just with an eye on time, I want to get people's views on the impact of, in putting it crudely, the anti-ESG litigation activism that we're seeing in the US, and how significant we think, putting to one side, one's views as to whether it should be there or not, but how significant it is in terms of global trends. I mean, Paul, do you want to share some thoughts on that?
Yeah, thanks, Matt. So one of the clearest examples of this is the case that's been brought by Exxon, the oil and gas major in the US, against an NGO called Follow This. And what Follow This does, and has done for a number of years, is file shareholder resolutions across oil companies, requesting/requiring them, if the vote were to pass, to put in place genuinely Paris-aligned emissions targets. And oil companies have fought this tooth and nail, and they have, in the case of Exxon, now taken that to quite an extreme by way of suing Follow This and its co-filer, an institutional investor, it's worth noting, not an NGO, in the relevant US court. And what Exxon essentially has said with this is, oh, look, this is an abusive process, this is a waste of the company's time, this resolution is filed every year and has so far failed to pass. Which, I mean, I think really to any or certainly to the vast majority of sensible investors, is a load of nonsense. Because that the very fact of filing a resolution on a matter which is of such significance to a company, that is the process. That is not an abuse of the process. And for the companies to sort of disregard this resolution, which has attracted, 10 to 30% of shareholder support over the years, is quite staggering. But we are seeing, I think, that split in terms of the investor pool, as I suggested, the anti-ESG backlash. There is one trend which has been developing over a few years, whereby, certainly in the US, companies will seek to suggest that perhaps there is something anti-competitive about a pool of investors clubbing together and having a view on the way in which companies should manage its climate risk. Again, I think we've seen from clear guidance from the UK and the EU, relevant regulatory bodies, that there is no substance to that. It's disappointing in a sense, certainly from the Client Earth perspective, that these companies are switching off from the ultimate owners of their companies. And I think they do that really boards at their peril, because we've seen with Exxon, 3 of their directors were booted out just a couple of years ago because shareholders had had enough of the failure to engage on issues material to the company. And we will see that, I think, increasingly, whether it be led by a pool of really quite progressive investors, or whether that pool widens as the risk becomes ever starker.
Okay. Mike, briefly, yeah.
Well, when I first hear that comment, I remind people of King Canute, although that doesn't always resonate with Americans. There is clearly a systemic risk in the policy sphere. There is clearly the same systemic risk in finance. They overlap. They are not separate. I am increasingly of the belief there will be a significant repricing of climate risk in some markets. So get on the right side of that repricing, and that's a very investor-led perspective, but would apply to holdings in companies as well. And I guess as we sort of head towards the end of this, I'm just going to make it's a sort of call to, I hadn't planned to do this, but it's a sort of call to action to lawyers. I think your job, in part, is reducing uncertainty, especially for your clients. So if you think about reducing uncertainty of the world, and let us assume we have a contract between an insurer and a run-off insurer, which, after 5 years they sell their book to a run-off insurer and there's a contract. It is my guess that some bad things will happen. Both parties will claim that the systemic risk which created the thing, which was just ex ante at the time of the contract, but is now ex post because there's a big loss. So my call to action is thinking in the legal profession how you can accelerate the reduction of uncertainty. We're going to have some good force majeure blowaways because it was no longer an act of God. You knew this would happen. It was an act of man. So just thinking within the legal profession what you can do to accelerate change.
Very good. Okay, well, I think that's probably a good time to stop. We have slightly overshot by 5 minutes, so I don't want to eat into the next session. So I'd like to very much thank our panelists for their contributions. So thank you very much for that, and if you'd be kind enough to show your appreciation.
Next session, just before taking a quick break. And we've touched on this topic. You guys have touched on a bit on this topic already. But our next session is on directors' duties, derivative claim, and personal liability. And I will invite to the stage Jeff Twentyman, who is the Chair of Sustainability and Responsible Business at Slaughter & May. He's also an honorary professor in practice at UCL Faculty of Law and a non-exec director at the Green Finance Institute and trustee of Blueprint for a Better Business.
Thank you very much. Thank you. Good morning. For those who hadn't appreciated, I'm not Smriti Saran, my talented and advertised colleague and litigation partner at Slaughter & May. I'm sorry she can't be here to speak to you. She sends her apologies. You'll have to make do with me. I know we're compressed with time, but fortunately Paul has stolen most of my lines. so I can cut those bits out. I should acknowledge from the outset that my views speak from a corporate governance perspective rather than a litigation perspective. I was not involved in the Shell and Client Earth case, and obviously I do have to balance some duties of loyalty to clients in what I say. I'm also no longer a practicing lawyer engaged advising clients on what the law is. Rather, I'm involved in policy initiatives relevant to the broad idea of better or more responsible business, and so my views will inevitably stray into what the law might become rather than what it is. That's not irrelevant to companies. They need to anticipate an evolving set of demands on them, but I'm declaring my interests. My colleagues would say that what you will hear are my views and not necessarily theirs. Mark Carney's well-known speech from 2015 spoke of 3 climate risks: physical risk, transition risk and liability risk. And you might think that this talk will be focusing on legal liability risk, but it's important to understand that the liability we're talking about derives from a failure to manage physical and transition risk. There are other liability risks, of course, for example, of the type in the German case of RWE and Lawyer, but I'm not going to cover those. So all my disclaimers are now out of the way. And as Catalina said at the beginning, we are now grounded in the realities of the law. The landscape is moving fast. It was only 3 years ago that we saw a Shell ruling in the Mil Defensa case in the Netherlands. And the key developments since that Dutch ruling was the English court's forceful approach in the Client Earth and Shell proceedings that Paul has talked about, which have perhaps tipped the scales back the other way. We're also now in a place where there's commentary which suggests that a substantial fund may bring a claim asserting that a corporate has swerved too hard into more sustainable business activities where they have no comparative advantage and hence are breaching their duties to promote the success of the company. And Paul has mentioned the Exxon Follow This litigation in the States. Also in the States, there is litigation pending in more than one state which is seeking to make it illegal for board directors to consider sustainability factors in corporate decision-making. That would be a very material encroachment on the business judgment rule. And yet for all of these counter initiatives in the US arena, the prevailing wind in the UK and in the EU is still towards mandation of additional disclosure designed to facilitate better capital allocation and towards transition plans with an underlying presumption of alignment to the Paris goals. But we are in a topsy-turvy time and place. Climate-related litigation against business is driven by many things: perceived management failings at the corporate level, conflicting views of short and long-term value, economic factors, impacts on stakeholders, historical attribution of damage, but also a failure of policy response and active regulatory intervention. Building policy objectives here, less climate impact from business from the ground up by challenging the way directors manage businesses is always going to be difficult, indirect and a challenging pathway to meaningful change, particularly with unsympathetic government and long-established vested interests. And I'll come back to this later on. So the subject I'm here to talk about is directors' duties, derivative claims and personal liability. It's inevitably going to be focused on the law in the UK, but I hope there will be some read across as the basic tenets of directors' duties are in fact surprisingly similar across developed economies. What I'll argue is this: directors' duties have changed markedly since legislation in 2006 and no longer mean what they meant then. Secondly, reports of the demise of the derivative claim as an intervention are greatly exaggerated. And thirdly, the subjective and objective test of due diligence and directors' duties remains intact, and the responsibilities of directors have become more severe. So, directors' duties have changed. You'll all be familiar with the framework and background of Section 172 of the Companies Act, the primary duty to promote the long-term success of the company for the benefit of members, having regard to a list of stakeholder factors or interests, including community, employees, and the environment. The wording of this section was debated for a very long time in the process that led to the adoption of the new legislation. it's funny how I think of it as new legislation, is enlightened shareholder value. Decisions are enlightened by an appreciation of the impacts of decisions on and the dependency of business success on good stakeholder relationships. The more significant the relationship, the greater the weight that directors would have regard to. It was a compromise between a pluralistic view and a more rigid shareholder primacy view. It's now entirely non-controversial to say that a director that doesn't take into account climate risk will likely risk being in breach of duty. The vital question for a director is what is the appropriate weight to be given to a particular stakeholder factor, here climate, which is a quintessential matter of judgment in the circumstances and not a question of whether a factor is relevant. For companies that are subject to the Corporate Governance Code, the position has advanced even a bit more. Principle A of the code says that the board's role is to promote the long-term sustainable success of the company, generating value for shareholders and contributing to wider society. The references to long-term sustainable success and contributing to wider society extend beyond the footprint of the Companies Act formulation. And unlike much of the Corporate Governance Code, the principle is not subject to comply or explain. All listed companies will uniformly, by claiming to comply with the Corporate Governance Code, represent that this is what their governance delivers. It's interesting to hypothesize how this might form an actionable representation. The situation will be given even greater specificity if we get to the adoption, as the government has committed, of both the ISSB Standards S1 and S2 and the Transition Plan Task Force framework. These will require disclosure with much greater elaboration on transition strategy, programs to deliver on that transition, metrics, KPIs and risks and so on. Transition plans will provide greater decision useful information to investors and will lead to greater accountability for directors on the actions needed to transition. It is anticipated that this will be material for capital flows. The FCA has described transition planning as unusually important. Many businesses will adopt transition planning ahead of regulation and hence pull up market practice and expectations of market practice and perhaps gain competitive advantage. Lastly, businesses now operate in an unforgiving context for unsubstantiated ambition. Whether it is the FCA, the ASA, the CMA or civil society claimants or the demands of the EU regulations for those in scope, the space for well-intentioned aspirations to be a more sustainable business has diminished unless supported by credible, visible, realistically deliverable and assurable programs. So I say again, decisions that might have been possible 18 years ago, even 8 years ago, will be subject to very different expectations and deliberations now. The law has moved dynamically to reflect the increasing demands of the social licence to operate. If the words have not changed, the meaning certainly has done so. That's not to say that all corporate decision-making has kept pace. It is generally accepted that climate risk is inadequately priced into capital. That means that it also inadequately built into corporate finance and business propositions and strategy. It means that assets and liabilities on balance sheets may be mispriced. I think in many places boards are behind in their appreciation of the risk posed by climate change, the speed and the bumpy nature of the transition, and of the importance to directors' duties, not just of managing that risk, but also of taking full advantage of transition opportunities. This is fertile ground in due course for directors being held accountable, at least in theory. I'm now going to touch on derivative actions. Directors' duties are, of course, owed to the company, and our system primarily sees the company as the active claimant for breach. The positive duties in the Companies Act are owed to the company are to promote the success of the company and to act with reasonable skill and care. And for any risk for a director to crystallise, this liability would need to be enforceable, which is a practical matter, absent a material change to the composition of the board, will only occur through a derivative claim mechanism, where a shareholder effectively takes on the role of the company bringing the action. However, after the Client Earth and Shell decision last year, this claim mechanism has shown itself to be a formidable obstacle to holding the board to the claimant's account. I won't go into the details of the case, not least because I wasn't involved in it, but the key point was that the risks presented by climate change were said to have been insufficiently considered, and that despite Shell having net zero climate targets to 2050, they had inadequate policies to support a pathway to achieve that net zero ambition. As you've heard, the decision went in favour of Shell. It was determined that a derivative claim should not be brought, permission to appeal was refused, and an adverse costs order was made. The combination of those aspects, particularly the costs order, which was very much a reversal of the norm, means that the decision arguably raises the stakes for anyone else contemplating using a derivative claim. The court examined the intentions of Client Earth and its consideration relating to whether the proceedings were brought in good faith. The court adopted a but-for test, which is what the precedent suggested it should, into the actions of Client Earth and made a range of comments, including that Client Earth had adopted a single-minded focus on the imposition of its views and those of its supporters as to the right strategy for dealing with climate change risk. We might observe that all shareholder activists adopt a single-minded focus on the imposition of their views of strategy. Is there a basis, therefore, for believing that derivative actions are no longer viable ways of questioning directors' decisions? In my view, it's too early to tell. Maybe, but not necessarily. There has already been cogent criticism, again referred to by Paul, from Lord Robert Carnwath of the Grantham Research Institute. He made a series of points criticising the decision, particularly strong point about the court's findings in relation to the motivations of Client Earth. In summary, he noted that any shareholder taking an action has an ulterior purpose, if only the desire to protect the value of their own shareholdings. Lord Carnwath's opinions have been picked up in a recent opinion that you're going to hear more about today concerning nature risk and directors' decision-making. That opinion says that the Client Earth and Shell case should not be read as a general bar to derivative claims in relation to nature-related risks. There is in any case a view that the Shell judgment gives something of a roadmap of how to do it differently and how to avoid the imperfections that the judge saw as significant. It's perhaps more likely that the next attempt at a derivative claim may look a little bit more like Bluebell Capital Partners and other fund managers and asset managers. Bluebell is a holder of shares in BP and has issued a call to ditch various commitments in relation to reducing oil and gas output and investing in renewables. In particular, Bluebell rejected BP's pledge to reduce oil and gas production by 20% by 2030. Their concern is that this is said to have reduced current shareholder value. They have in effect taken the views of Milton Friedman and that school of thought at face value, albeit with a professed interest in maximising good capital allocation to renewables by people with greater expertise than BP and comparative advantage. They assert that there is a clear and present value discount directly consequent from the directors' choices. How might the court in Shell have reacted differently to a case brought by a more traditional financial investor, asserting that the directors have harmed present company market value? A further thought on this judgment. The judge was dismissive of the idea of declaratory relief. Whilst the courts are rightly wary of assuming a policing role, particularly where it is far from straightforward what the better solution would be, declaratory relief is far from unheard of in administrative courts. Indeed, Client Earth, the Good Law Project and Friends of the Earth have a current live action against the government by way of judicial review, questioning the sufficiency of its net zero plan on broadly analogous grounds to the claim in Shell that there are ambitions but inadequate policies to or appreciation of the risks to delivery of those ambitions. It is an interesting conjecture to think how the Shell case would have played out differently in the administrative courts, or if it had been brought to the court after the judgment emerges from this more recent case. My last point on the subject of derivative claims is perhaps a statement of the obvious. The thresholds and gateways set by the process in Section 260 of the Companies Act on the notion that it turns on the notion that the decision objected to by the claimant should be one that no reasonable director could have taken. I think we should pause to contemplate the consequence of this. In order to get into the ample vestibule of the courtroom and judicial consideration, a claimant must squeeze a very large bundle of papers through a small hatch. Or putting it another way, that to bring a claim that directors have failed to act reasonably, there needs to be a case made at the preliminary hearing that the decision was in fact not just not reasonable, but not tenable. This is a remnant of the creation story of derivative procedure. It was new in the 2006 Act, where there was a fear of the floodgates of litigation and where stakeholder interests candidly didn't associate with such existential dread as they do today. I think it is legitimate to ask whether this threshold and the procedure is a historical artifact, an indicator of historical nervousness, and whether it serves well our current public interest in having businesses that do well by society, and whether this particular threshold to initiate a claim makes sense against a substantive performance requirement of objective reasonableness as set out in section 174. And this then brings me to the third point, the area of personal liability. The standard of performance expected of directors is set out in section 174. It is a standard of reasonable skill and care, and it is what is sometimes referred to as a subjective and objective test. In my experience of advising boards, all directors are motivated to comply with their duties, and no one would look to behave differently, hiding behind the difficulties of derivative claims. There is no cohort of directors out there willfully mismanaging business. And given the crucial role in the positive duties of good faith and reasonable conduct, that leaves me with a strong belief that fear of personal liability will not unlock this issue. However, what can be expected of a director on this moment of the 21st century is a detailed appreciation of climate risk, physical, transition and liability. The information available to inform is widespread and there's no shortage of available expertise. The broad picture of what is needed to achieve radical decarbonisation of the economy, is not seriously contested, even if the means of achieving it are many. The risk horizon is ambiguous, complex and dynamic. All businesses have a common future of needing to thrive in the short-term future of a radically decarbonised world. And at the same time, the opportunities for a business are as great as have ever been presented. There's no doubting that the duties of a director in a business in the vortex of transition are highly demanding. There is arguably no more important issue to take a board's time and attention. And of course, not all decisions will, in due course, seem to have been correctly made. As I alluded to earlier, in the Shell case, the read across from alleged breach of duty to value impact was contestable. The Bluebell situation, it is more evident. There are many other possibilities for rapid value adjustment to contextualise board decision-making. Significant regulatory intervention, appreciation of the obsolescence of assets, recognition of material liabilities or provisions, what is known sometimes as the fur coat moment. The company is the primary claimant in the area of directors' duties. If new ownership or new management with the benefit of hindsight or existing management under the influence of their owners sees that previous directors have not met their positive duties and have failed to promote the success of the company, the test will be looked at in a very different way than the derivative claims procedure, and with the benefit of hindsight, and an evolved understanding of how uncertainties prevailing at the time have played out. Derivative claims are always a nod to unusual circumstances rather than a primary accountability mechanism. So there should be scant comfort from the failure of the derivative claim in Client Earth and Shell. In my view, the potential for personal liability should be seen as remaining as potent after the Shell case as before. As a brief footnote to that, much climate and sustainability litigation is not, in fact, seeking to impose personal liability in a punitive way. Arguably, there is a case for greater leeway in directors' performance to recognise that climate-responsible business is uncertain, multidimensional and urgent, and therefore inherently carries a different risk profile to business as usual. It would be counterproductive if fear of liability based on orthodox assumptions should be an inhibitor to business innovation and ambitious change. There is a good case to be made for a safe harbour for forward-looking information in transition plans, and there should be a broader discussion of risk. So, litigation will continue in this space, and judicial clarity will almost inevitably be needed. Undoubtedly, we will continue to see more innovative lawsuits across a whole range of issues for so long as the policy response remains inadequate. Where we are now is this, I think. We are on a pathway to zero tolerance of greenwash, which will contribute to a whole new language of corporate communications and realism. Getting this right is squarely a responsibility of the directors. There are continuing concerted efforts within civil society, and despite recent setbacks in the EU, to steer towards better business, which involves business taking responsibility for its impacts. That is a strategic challenge, and again, squarely on the table of directors. Upcoming COPs will see a renewal of NDCs and increasing pressure on governments to adopt policies that match the scale of national and international ambition, and to pass these obligations through to non-state actors, in particular to businesses. And the real impacts of climate change are plain to see. Much of our journey of appreciation of the climate crisis in this country has been spent where the governing ideology has been non-interventionist and with a strong, possibly blind belief that markets fix everything. This is all up for grabs. Lenin said there are decades when nothing happens, and then there are weeks when decades happen. It doesn't take much imagination to see how the change in the short term can spill into directors' duties. The claimants seeking to change how directors make decisions only have to be right once. Those who defend their claims need to be right all the time. As I've said elsewhere, the best response to a threat of climate litigation is to have a Paris-aligned business. Thank you.
Let's take one question and then we go for break. Mike, you have a question.
Jeff, thank you for those very wise remarks. I could not have asked this question 30 minutes ago. I'm going to call it a vestibule question. I want to get inside the vestibule before the papers are thrust through the hatch. As a citizen, I have a single-minded focus on the existential risk to my life and my interests from climate change. So how might we craft a transition plan for the UK judiciary? Forget the rest of the lawyers, we're going to focus on the guys making the big decisions. How are we going to craft a transition plan for the judiciary? And the thought that came to mind is getting Tim Lenton from Exeter University, who's an expert on tipping points, to present to them and to scare them rigid in their defence of the UK citizenry.
Just going to try and interpret a question in that statement, Mike, but the judiciary are in fact ahead of you already. I have participated in informal discussions with leading current and former members of the Supreme Court, where they have been trying to find ways to interpret the existing law on directors' duties in a way which imposes greater responsibilities on directors to manage climate risk. There are programs of education and enlightenment for the judiciary, both in this country, but also in this country for judiciary from other countries, in particular Singapore and China and such like. So the judiciary are definitely alive to that. I think the idea of transition plans beyond the scope of of corporate actors is a really interesting and important one, and actually what each country needs is a transition plan. And there's a glaring regulatory gap between the international obligations that the UK and other jurisdictions make in international climate forums and the delivery of those commitments, or if you like, the back-to-back pass-down of those commitments to the corporate and other sectors of the economy. I don't know what that transition plan would look like, but there's plainly a gap where we are now, where the UK ostensibly has that obligation, but in fact the bulk of the economic firepower of the country, which is no longer the government, is not itself subject to positive duties to transition to a different trajectory. So that's a subject of another discussion another time, I suspect.
One more question from Paul.
I was waiting for a microphone, but I just...
Oh, sorry, I can hear you.
That's fine. Well, maybe. Thank you. That was a speech which I hadn't quite expected from you, Jeff, and I found myself agreeing with...
I did it just for you, Paul, don't worry.
Thank you very much. I appreciate it. No, I did find myself agreeing with much of what you said. I wanted to pick you up on one point with which I disagreed, which was the hypothetical Bluebell example, whereby Bluebell were to initiate a similar derivative action, but on going the other way, essentially. I disagree with you that that would be a more viable action. I agree optically for the court. It might be easier for it to pass a prima facie test because you have a sophisticated investor whose eyes are very clearly on financial return, although I would say that the court disregarded very swiftly the investor support that we had for our claim. But I think the crux of the issue is that oil and gas fields take decades to become operational, and so the investment that is made in oil and gas fields today will not reap a return realistically until 2030s, 2040s. And that was part of the evidentiary picture for our claim against Shell's board. And so any claim that companies should be continuing to invest in oil and gas today in order to reap immediate profit doesn't make any logical forward progress. And you then come up against the clear evidentiary picture that that investment will result in stranded assets, according to every transition scenario from the International Energy Agency, accepting that the transition will be volatile and will go up and down and may take different courses, but there is no evidence to suggest that those investments would reap any financial reward for the company.
Thank you. I wasn't in any way suggesting that the case was likely to succeed. It's just it's interesting that a sustainability-minded activist investor is bringing really quite a counterintuitive claim against an oil company, asking them to stop making investments in renewables. And you know, it's quite a cute economic argument that BP are not the best people to be investing in renewables, and whilst they may be good people to invest in oil and gas, whatever the trajectory for that oil and gas investment, they should make money there, pay dividends to shareholders, who can then allocate their money to people who are better at investing in renewables. So it's a sort of classic Friedman-esque piece of economic theory, and I'm not at all saying it will be successful, but I think it just shows the range of perspectives that people are coming at this subject from. I don't know.
Let's take that question for the coffee break.
Yeah.
Thank you very much. Thank you, Jeff. Thank you for the questions. We're running a little bit behind, so let's take a 20 minutes break. So be back by 11:10 with the next sessions. Thank you very much. Great, welcome back. I think we can start. Welcome back to in-person audience, virtual audience. Thank you for your patience on staying with us. So, for the next session, which is on environmental whistleblowing, having the correct process in place, I will invite Bob Mattison, who is an associate solicitor at Leyday, and in his role, he focuses on representing whistleblowers whose cases have an international or cross-border component. Bob, please come up. Thank you.
Thank you, Catalina, and good morning, everybody. As Catalina said, I'm a solicitor at Leyday, who, along with Pogus Goodhead and Client Earth, are one of those law firms who would be on the other side of some of the claims that are being discussed today. Although the majority of my practice at Leyday is, as mentioned, is representing whistleblowers in claims against companies when they've mistreated that whistleblower. Although I've been asked today to speak on environmental whistleblowing and having the correct processes in place, and to do that, I'm going to be drawing more on my experience in a previous role where I was the head of advice and advocacy at the UK NGO Protect. And Protect is a body which does all things whistleblowing, which includes providing legal advice to whistleblowers, but as relevant to this particular presentation, it also advises a large number of corporate organisations and governmental bodies on their whistleblowing arrangements. Before I launch into what correct whistleblowing processes are, I just wanted to start with what I mean by whistleblowing. I think it's a term that can be used in a variety of different contexts to mean different things by different people. I noted that when I was given the title for the presentation, it had inverted commas around whistleblowing, which I think gives an indication that it's perhaps not the most well understood term. And what I'm going to mean by whistleblowing in this presentation is really any activity by someone within an organisation looking to raise concerns about risk, wrongdoing or malpractice within that organisation, raising that to someone with the authority to be able to resolve it, whether that's the line manager, or whether that's a departmental manager, or whether that's a dedicated whistleblowing team, or whether that's someone with directorial responsibility for that issue, or whether that's to a regulator, or whether that's to the press. So there's a whole spectrum by which you can whistleblow to various people, and I think it's important to kind of start the conversation in that, because sometimes whistleblowing slaughters just that end where you're going to the regulator or the press. But when I'm talking about it very much in the context of speaking to your line manager, etc. as well. So, the importance of whistleblowers in the context of environmental wrongdoing. Well, the first place to start with this is that, for my mind at least, and I think these days most businesses are catching up to this, whistleblowers are really an important resource for all organisations in terms of being able to detect and deter wrongdoing. And that's not that surprising, because these are the people at the coalface of what the organisation does, so they've got an awful lot of knowledge about what's going on. But they're also highly motivated to be able to resolve those particular issues. When I, in my previous job, speaking to lots and lots of whistleblowers, whereas now there are kind of less cases, less number of whistleblowers, when I was speaking to lots and lots of whistleblowers, generally speaking, people's motivation was, I do this job, I want it to be done properly. It's not very satisfying when things are going wrong or when the organisation is doing something it shouldn't be. So you've got this amazing group of people who are very knowledgeable about what's going wrong and also very motivated to be able to fix it. So most organisations now recognise that we should do something to try and make use of this cohort of people and to utilise them in the organisation's process, to utilise them in what we do. That being said, I think in an environmental context they're particularly important, and that's for a number of other reasons which I've set out on the slide, and I'll just talk very briefly on each of these in turn. So the first is that most sophisticated large organisations will already have a number of reporting channels for particular issues. I'm sure most of you are familiar with anti-money laundering or with health and safety issues, or although I wouldn't treat it as whistleblowing, it's a form of problems within the workplace grievances. You've got very established mechanisms there for people to be able to raise issues. Generally speaking, organisations won't have something like that for environmental issues. So when an environmental issue comes up and an individual's can see that we're doing something wrong and it's having an impact either on a particular natural ecosystem or on the way that we're representing our green credentials, that individual might not know where to go, and that's where they'll be falling back on pre-existing, or they'll be falling back on your whistleblowing arrangements. In addition to that, it's been very enlightening for me to hear about all the different particular legal rules around environmental policies and what organisations are meant to do. Nevertheless, it's still my perception that many areas of what organisations should be doing with respect to the environment, and certainly what they should be doing with respect to a just transition and decarbonisation, currently lack the government saying, or the kind of government, parliament through the government saying, this is what we'd like you to do, these are the rules, this is how quickly you should decarbonise. So a business is in an area where they know they should be doing something, but they don't know exactly how much they should be doing. And that's quite difficult for the compliance individuals, who generally will be looking at, are we legally compliant or not? But it's a better space for a whistleblower who might have a bit more of a sense of, is this right or wrong? How do I think the public would see these particular issues? Number 4 on this slide is that for multinational organisations, it may be that your operations in some countries overseas might not have the same level of oversight as they would in London, for instance. And so whistleblowing arrangements, being able to hear from the people that work in these particular countries that can see what's going wrong, is a really powerful way of being able to find out what the issues there are. And last but not least, because these issues are so much in the press at the moment, a lot of organisations are very concerned when they do get things wrong about it coming out. And that's exactly the sort of environment where, unfortunately, when things do go wrong, organisations or individuals are more likely to try and cover things up, to misrepresent things, and your whistleblowers, in a sense, are a kind of antidote to that. So what can an organisation do to improve its whistleblowing arrangements? Well, really, the first and foremost thing that all organisations should have is you need multiple channels for raising concerns. So what do I mean by that? It means that normally the first place to start when you're concerned about something would be go to your line manager. But what if your line manager isn't a good option in that instance? Either they're conflicted in some way, either because they're involved in that particular wrongdoing, or they're long professional acquaintances or friends with the person that's involved in that wrongdoing, or you've already been to the line manager. So in addition to being able to point people towards their line manager, you also want to say these are the other people within the organisation you can contact. And for big organisations, it's becoming more and more popular to have a particular team, a centralised team that people can whistleblow to, as it were. That needs to be backed up with procedures for how do we receive whistleblowing concerns from these individuals when they come through these channels, and training that's associated with that. So, for instance, you're going to want to be able to have a think, how in our business, and how can we train our staff to do this, so that if someone comes to us with a concern, we're able to manage their identity, manage their confidentiality. Because it's not going to be very good for our whistleblowing arrangements if when they raise concerns with us, we haven't thought through how that information travels through the organisation, and so that person's identity becomes known, they suffer retaliation, and it undermines all of our arrangements. Similar to that is the procedures for investigating the whistleblowing concerns and associated training with that. And in addition to how can we investigate issues without showing the identity of the individual, so how can we depersonalize the information that they're bringing to us, you might also have questions of where someone is coming to us with whistleblowing issues, which we see as outside of their own employment rights, not relating to their own rights within the workplace, where that's coming alongside with private grievance issues, which is not uncommon, because it may be that someone's tried to raise it, they've already had a bit of a problem, or it may be that they have difficult work relationships already, and that means that it's been harder for them to raise this issue. How do we disentangle those two things? Because we don't want our really highly skilled, compliant, maybe even environmentally specific investigators dealing with grievance issues. So we need to disentangle those two things. Number 4, an effective case management system. If you're going to be dealing with lots of people and you're going to be protecting confidentiality, then you're going to want a system, a bit of tech really, to be able to deal with that and to be able to have a process of managing those workflows. And then lastly, and in my experience, this is something that tends to get missed because feeding back to the whistleblower doesn't seem in each individual context as that important for how do we identify problems and how do we resolve problems. Because by the time we've got the information from the whistleblower, well, you know, we don't need to go back to them anymore. We've got what we're looking for from them. We can move on. We don't need to give them any more information. But it's actually a really important component for the overall arrangements, because if you end up with a perception within the organisation that when you raise concerns, nothing is done, then people will not continue to raise concerns with you. And lots of organisations have that particular problem. And people will largely build that perception if you don't tell them what you've done as a result of the issues that they raise with you. But if all of those 5 issues, and there's many more that you could add to that, if they all constitute operations, then it's very, very important to recognise that that's not enough in and of itself. So I've got here 2 points, that you also need effective engagement and you also need effective governance. And to give a small anecdote in relation to this particular point, one of the pieces of work that I did previously was for a large household name multinational that worked in lots of worked in pretty much all jurisdictions around the world, but also worked in some particularly difficult, sensitive areas given the work that it did. And they had recently had a very large issue come to the press, which was very embarrassing for them and was having both an impact on motivation within the staff force, but it also had an issue on their share price. And when they'd done some initial investigations, they'd found out that some of the problems that had ended up in the press had already been raised internally within the organisation. And so they thought, well, this is obviously a bit of a problem because we have these whistleblowing arrangements so that this sort of thing doesn't happen, so that we're able to hear about it first, act on it, and it doesn't end up in the press. But actually, even though these issues were raised within the organisation, you know, me as the senior director that deals with that particular area of the business, I didn't hear about any of that. So why has that happened? And what was very apparent when I was doing the work, which in addition to looking at some quantitative things around reporting rates, etc., there was a big piece of qualitative work where we interviewed country managers around the world, and then some of the kind of staff that had more operational roles. And it became very, very clear very quickly that even though this organisation had quite a sophisticated whistleblowing team based in London, which was a dedicated team with a dedicated telephone number, so that any country that you're working in for this particular organisation, you pick up the phone, you go straight through to this organisation, and they'd done all sorts, straight through to this team, and the team had done all sorts of training, and they were very aware on how these things were to be dealt with. What actually was happening on the ground is when you spoke to people that worked in these countries, that they'd either never heard of that team, or they said, I have heard of that team, but if anything ever went wrong, they would be the last people I'd contact. I don't trust them, I don't know who they are, I'd be worried that's just going to make its way through to the people who I'd be whistleblowing about. And in addition to that, the organisation, in its total global sense, had absolutely no idea that these particular arrangements weren't working, and that within these countries, no one was using this centralised whistleblowing and didn't have any trust in it. So it's really important that you don't just put all your efforts in operations, and that you also need to do work around engagement and governance as well. So just to put a little bit, I mean, the points are already on the slides, so you can obviously read them, but to put a little bit of meat on those bones, when we're talking about engagement, it's not going to be enough, normally speaking, to just put something on a kind of centralised intranet or something like that. There are some people that will read the intranet, there are some people that won't read the intranet. Clearly everyone should read the intranet, but the reality is they don't. So in addition to an intranet, you might use emails. You might, within Teams, make sure it's mentioned within team meetings. You might have it in circulars. You might think of as many ways as possible. How can we get word out that we have these particular whistleblowing arrangements and people can use them? In addition to that, you're probably going to want to include within your annual staff survey, which most organisations have, questions around, do you know about our whistleblowing arrangements? If you do know about our whistleblowing arrangements, do you trust our whistleblowing arrangements? You're then going to get information back about, you know, how much they know about it, how much they trust it, and then you can take steps in response to that. And then probably less frequently, because it's a lot more work, but still something you might want to do, is you might want to get focus groups to understand in a bit more granular detail. We recognise there's a problem with people's awareness of these arrangements. Where else could we be publicising them? Or people don't trust these arrangements. What are their particular fears about it? In terms of governance, whistleblowing champions is a terminology that's been adopted across a number of industries, largely from financial services, where it's required by the FCA, but generally in its kind of wider sense, cross-industry, what that means is someone within the organisation who has responsibility for how our whistleblowing arrangements are working. So someone who's going to have oversight over all aspects of it, is going to see the outcome of that survey data at the focus groups, etc. In addition to that, if you already have existing internal audit processes, you might want to include within that some sort of audit of your whistleblowing arrangements. And that might just be looking at the numbers of whistleblowers that are coming, trying to understand trends in that, trying to understand if those numbers are lower than you would expect given the amount of issues that have come out through other channels in the organisation. And then on a less regular basis, you might want to get someone independent who's not within the business to have a look at that data and to speak to the staff and to find out what's going wrong and what's going right, much as I was doing in the anecdote that I just mentioned, because you'll be able to find things out from that you wouldn't through your own processes. And then lastly, you're going to want the board to have some insight into some of this information so that it can be informed and take it into account in terms of what it's suggesting as well. So what are the risks if you don't deal with a whistleblower appropriately? Well, first of all, you're going to diminish trust in your arrangements. So you're going to defeat the point of all of this work that you've put in to start with. Because one whistleblower who's mistreated or one whistleblower who's not listened to, a promise that will filter through to the rest of the organisation. And that's how you build up a culture of this isn't an organisation where it's safe for me to raise concerns, or this isn't an organisation where if I raise concerns, they'll listen. So you really will be judged by your record, and so that's why it's of the utmost importance that you do as much as you can to make that record brilliant and that there aren't examples where it's gone wrong. In addition to that, if you mistreat whistleblowers, then within any UK employment law and across many other jurisdictions, there's going to be potential legal liability for that. And there's a financial cost to that legal liability, but as I'm sure most people within the room will know, there's also a reputational cost. And in the context of whistleblowing, generally that reputational cost is going to be even more. Point 3 on the slide, and this generally only really applies to multinational organisations, and this is really my day job. There is an evolving area of law and practice that we're doing within Lead A, which is for those whistleblowers who are raising concerns in jurisdictions other than the UK, but for a company, say, that's UK headquartered, it's holding the UK headquarter responsible for how that whistleblower has been treated, depending on what involvement they've had or what promises the UK headquarters makes to safeguarding whistleblowers in their interests. And this is quite a frightening thing for a lot of organisations, I think, because in many jurisdictions in which they practice, they might not have that much insight into how particular individuals are treated, and I think it would scare them to know that if they're mistreated, that they might be held responsible for that, both in terms of how worrying that is from a financial point of view and the legal case that kick-started this, the claimant won $10 million in damages, but also, again, from a reputational point of view. That claim was against Ernst & Young or EY, and the judgment, which is very long, effectively sets out all the ways in which EY covered up this particular issue that he'd been raising about money laundering, etc., in terms of an audit that was going on that he was doing overseas. Number 4 on the slide is that if you don't deal with issues early, then of course they get bigger over time. A stitch in time saves 9 is the famous expression, and that's particularly true in the context of whistleblowing, where you have an opportunity to find out about problems when they're quite small, before they get very, very large and can start to affect the reputation of the company and the share price, etc. And then lastly, of course, with any sort of these issues that are coming up and aren't being resolved, there's regulatory and reputational fallout as well. So that's everything I had to say on a whistle-stop tour of what good whistleblowing arrangements look like. Happy to answer any questions.
Do you think it's sufficient, and specifically in environmental whistleblowing, are there any sort of specific factors that would need a separate approach to be taken?
Yeah. Let me deal first with the environmental aspect of it and then whether I think the legislation is working in practice. So, in theory, the legislation in the UK, Public Interest Disclosure Act, it sets out a number of types of issues that, if you raise that issue, you'll qualify for protection, of which environmental harm is one of those issues. So in that sense, the legislation is fit for purpose for environmental whistleblowing. In practice, I think what's a particular problem for environmental whistleblowers is that, and this goes back to something I said at the very start, is that in many areas there's either a lack of rules around what companies should or shouldn't be doing, or there's a lack of knowledge around rules. And really, for a whistleblower to be effective, it's much easier when you're in a space to say, objectively, what we're doing is wrong, and it's objectively wrong because these are the rules, rather than subjectively, I think this is wrong for X, Y, Z reasons. So I think that can pose a potential challenge in the context of environmental whistleblowers. In terms of the legislation as a whole, there's been a movement for several years to reform it in a number of ways. There are certain areas where arguably its holes have developed over time and it's not able to effectively deal with changes in the modern workforce, and many other jurisdictions that have subsequently developed whistleblowing law have got bits in them which make sense that the UK law hasn't got, so I think there's definitely space for it to be reformed. What I'd say from experience is the main area that legislation falls down is that within the employment tribunals, which is the tribunal in which those cases would be heard, it's actually very difficult to fund those sorts of claims unless you have either a really good insurance policy, you're unionised and your unions opt for the fight, and they very often aren't, or you've really got a lot of disposable capital. And if you're not in one of those situations, which of course most people aren't, then you will have a problem, I think, with being able to enforce your rights in that context. So we end up in a position where, whilst we have the rights in theory on paper, in practice they're a bit illusory.
Thank you. There's one more question. And the last question. Hi. Thank you so much. That was super interesting. Sorry, Janina, law firm, White & Case. When you undertake due diligence on a target company, I often find that surprisingly there's a lack of clarity between in corporate governance documents between whistleblowing mechanisms and grievance mechanisms. And I wondered whether you think that the distinction is still important, and if so, what practical steps can be taken to ensure that the lines aren't blurred, and how to ensure that those distinctions are drawn out in both corporate governance documents, but also in terms of the practical implementation.
Yeah, it's a really good question, and there are industries which I think are moving more towards a space where they don't distinguish between the two, with the rationale being, well, it's easier, it's clearer for people to understand. And health services one, and I think increasingly now that the FCA is taking more of an interest, or at least in theory taking more of an interest in the conduct of senior managers, financial services as well. Certainly, my view on that, back when it was my job to have a bit more of a view, now it's not so much my job to have a view on that particular issue, but my view was it is important to make a distinction between the two, and that's for a number of reasons. Actually, first and foremost, I would say, because whilst grievance mechanisms and how people are treated in the workplace is very important, actually what we're saying within a whistleblowing space are, this is us getting ahead of some of the things that are potentially going to ground this organisation, will have huge reputational fallout, or huge regulatory fallout, or impact. So actually, we might want to say we're going to put a bit more resource into our whistleblowing than we might with our grievance. That would be the first reason that I might think it's useful to distinguish. The second is really a practical one, which is in the classic whistleblowing situation, the whistleblower is just a witness. And once they've given you the information, you then really, as much as possible, want to take them out of the process. And you want to investigate it based on the information, and for those people that are responsible, put that evidence to them and see what they've got to say about it. You don't want to be including the individual in that, largely as a means of protecting them, but also because actually in some senses it's not their business, although the caveat being that it's important to feed back to them at the end of the process. Whereas in a grievance process, you can't have an effective grievance investigation without the accused hearing the evidence of who is accusing them, because it's an interpersonal thing, generally speaking. I mean, not all grievance issues are interpersonal, but generally it's an interpersonal thing. So that investigation is going to look very different. And for those reasons, I think actually it can make sense, practically speaking and procedurally, to distinguish the two.
Right. Thank you very much, Bob. I think we're going to stop there. Let's give Bob a round of applause. For our next session, I'm going to invite Sarah Ellington to really give us a zoom in into managing potential exposure to human rights claims as part of the broader ESG dynamics. Sarah is a partner in the dispute resolution team at Watson, Fowley & Williams. She's very much well known for her work on ESG and human rights, and she combines experience on complex, high-profile litigations with advising on complaints to non-judicial mechanisms such as OECD national contact points, UN special procedures. Sarah, thank you very much.
Thank you. So what I want to do is take a bit of a helicopter view first. I can tell definitely from the questions that we've had so far that we've got a very experienced audience. So most of this won't be new to you, but hopefully sometimes it's helpful to kind of take this overview. So first of all, when we think about managing potential exposure to human rights claims, it's important to know what types of claims you might be exposed to. So I've put a couple of examples for you up on the screen. I would have thought that for some people, some of these might surprise them as being human rights issues. But unfortunately, Kate's already ruined my party here and touched particularly on the human rights aspects of climate change cases in the panel already this morning. And that's particularly because in order to gain legal standing for these cases, you need to show some kind of effect on the individual. And that's taken in some of the examples, again, we've already heard this morning in terms of Dutch property owners in the cases in the Netherlands, as well as New Zealand Indigenous groups. Who were in part relying on interference with their Indigenous cultural rights in the case mentioned by Paul this morning. Although I have to say, perhaps because of our different perspectives and the types of clients we act for, I would say that there's probably more of a difference between English tort law and New Zealand law, particularly because we don't have those Indigenous rights incorporated into our law in the same way. So effectively, climate change isn't a cause of action in itself, but it could be. Effects on human rights could be. There's also some issues there which people might consider as being the preserve of the state. Something like civil liberties, for example. But we've seen a number of cases which allege some collusion with or control of state security forces in particular, and particularly in the context of resettlement or use of security forces to protect commercial operations. So there's a number of different procedural routes to exposure as well. This is very rough, but I've kind of tried to put them on a scale from left to right. So on the left, we've got the kind of significant legal claims, breach of legislation, etc. And they go through various different grades through to the right, where essentially the intention of those people who are trying to comply with voluntary standards or get a better rating or benchmark position is that they want to be seen positively. They want to act positively and for their business to be seen in a positive light. But without putting in place the relevant policies and procedures to actually make them implementable in practice, that can in itself lead to increased exposure. So these different procedural routes also carry different tests. So obviously if there's different tests, there's potentially different things that you as an organisation need to do in order to help you manage those risks. Now, a lot of these obviously vary from jurisdiction to jurisdiction. But one of the ones that I get the most questions about is this test of cause, contribute, or direct link. So that's the one I thought I'd just take you through, again for background. So cause is perhaps the most easily understood. This is where an entity has directly caused an adverse effect on human rights. Contribute, not weighing down quite so much on the scales. This is where the entity is not the entity that's directly responsible for the harm, but without the actions of the entity contributing to the harm, the direct actor couldn't have caused the harm themselves. Now, this argument is most often seen in relation to financial institutions, and it's said that those financial institutions might contribute to harms because they are funding projects, for example, which have adverse effects, and the argument is that the project couldn't have happened without that finance being in place. And the last one is direct link, almost, I'd say, in the middle. I should say, obviously, all of these are on a sliding scale. They could all be slightly further up or further down the seesaw. I really hate the name direct link. I think it's a total misnomer. Because in many cases, actually, there's no direct business link at all, or direct business relationship. But the argument is that essentially, where your relationship with an entity is, who is causing the harm puts you in a position that you might be able to seek to persuade them to prevent, mitigate, or remedy that harm, then you should do so. And so your position on one side of the scale also correlates to what you should be doing on the other side of the scale. If it's direct link, you should be exercising your leverage over the entity causing the harm to persuade them to do something about it. For example, withdrawing your business from them. If it's contribute, then again, you should be pushing a bit, but not quite so hard as those causing. You're supposed to contribute to the remedy. But it's not supposed to be the case that this excuses the entity causing the harm from affecting the remedy themselves. However, in practice, what I see is that these entities who are alleged to be in the contributing position are the ones which are lent on the hardest, because in many instances they're actually much easier to get to than the party that we might say is directly causing the harm, either because they are local actors and it's difficult to get lawyers, for example, in the jurisdiction to take cases there, or because they're state actors, although the duty still rests on those entities to do the most in order to redress the scales and push it back in the other direction. So, what can be done to mitigate these risks? Sounds quite simple, really. You just have to find out what they are, put a plan in place to prevent them arising, or remedy harms which slip through the net. Now, this is looking at things on a double materiality basis, which we've already heard about this morning in the context of things moving this way in a European context, certainly looking at CSRD and CSDDD, assuming it gets through the final hurdle with the European Parliament. And it's about looking not only at single materiality risks to the corporate, which obviously is the foundation of how you might think about things on the traditional directors' duties, fiduciary duties point, but also looking directly at how risks manifest for third parties. What I'd like to add to that is that I don't think that this is a uniquely European trend. So, for example, the new rules under the Chinese listing requirements also require double materiality. So it's not just a European thing. Actually, this is where everything is going. And if we think about how that then translates into directors' duties, they're obviously set by looking after the company and looking at those what were common law duties and have now been codified in the Companies Act 2006, but also looking at that within the regulatory environment that you operate in. And that regulatory environment really does only seem to be going one way, unless, of course, you're in the US. So it's not that simple when we consider the fact that it has to be done over the entire value chain. When also do we have to do it? All of the time. And that's quite difficult to do as a business when you work on maybe quarterly cycles, you work on 3-year cycles, you work on 5-year cycles. You have a compliance team that is dealing with many different things. But the perceived wisdom, what many of these voluntary standards in particular require, and what some of the incoming regulation requires, is that this is really done all the time. I've just got an example here of a mine that might be doing some due diligence to just think for a minute about the complexity. We talked in some of the panels this morning about kind of doing due diligence, understanding your supply chain. I think the thing to remember is that it sounds very simple and easy to do on paper, but in reality, these supply chains are massively complex. They go through many different rounds. There's many different contractual clauses, which says actually you're not allowed to speak to my suppliers. I'm the only person who can be in the middle. You're not even allowed to know who those suppliers are because I want to keep those relationships essentially secret to myself for commercial reasons. So there is this kind of weighing up that you have to do of can you negotiate the right contractual provisions to be able to know your entire supply chain. And then, of course, in terms of how the incoming regulation is working, it's not only supply chain, it's the entire value chain. So you're looking both at what comes into your business, but also what goes out. So you might have thought previously about this kind of due diligence and the information flowing kind of down the chain. But actually, increasingly, we're being asked to look at due diligence coming up the chain as well. And thinking about how your products are ultimately used and whether more control should be exercised over that. We see that particularly in terms of climate and emissions, but also in relation to human rights issues. So in a way, you can see that you can do this through a waterfall provision. You can have contractual provisions where information can flow both up and down the value chain. If only, again, it were that simple. Actually, what we're seeing is more claims saying that you should have done direct due diligence on different players, that you should have understood who the ultimate users of your product would be, for example, and taken steps to make sure that they could only use it in a specific way. So how are we going to navigate this? Well, essentially, we need to try and achieve a balance. Now, most of the regulation and the voluntary standards don't say that actually you have to look under every single stone. At least I'm very much hoping that when member states decide to put in place their own legislation to implement the Corporate Sustainability Due Diligence Directive, that's not what they say. What the voluntary standards generally say is that you should be doing something that's reasonable and proportionate for your particular business. So you have to try and achieve that balance. Now, what does that mean in practical terms? I've put here some example methods of how you might choose to do your due diligence in practice. Now, by no means is this an exhaustive list. And the other thing to bear in mind is that absolutely you can't do one of these things in isolation. This is essentially a menu of different things that may or may not work for your organization, and they may or may not work because of how much it costs to implement them. And I've vaguely put them in order, so essentially the ones at the top are the ones that are generally the most cost-effective to put in place. but generally perceived as the least effective in actually making sure that you understand everything that is going on, and you can then put in place particular items to help mitigate risks. So most people will use a mixture of these different things, and most organisations will also start with something like self-assessment, but then also look for higher risk areas to supplement that with other things as well. And just taking this back to the claims and the litigation piece again, we had a look through with my team at some of the pieces of litigation and also some of the complaints, particularly in the OECD complaints process, that have been launched within the last 5 years or resolved within the last 5 years. And here is just a bit of an overview of some of the top tips from the cases. And hopefully this also gives you an idea of the types of things that people are falling down on most often over that time. And perhaps the eagle-eyed amongst you will have already noticed that I had to give a whole extra line to effective consultation, because this really is something that comes out very clearly in cases. Not only under voluntary standards, but also effective consultation is very often baked into the regulation, which is applicable across a number of different jurisdictions. So a number of different things to think about there as well. It's also about not closing your eyes to the issue, making sure you know your business partners. And for me, actually, that is one of the most difficult things I think that companies are coming across when they're looking at how practically they're going to implement something like CSDDD, is how you actually map your supply chain to start with. And also a further word for grievance redress mechanisms. I know that we've just had the session from Bob on whistleblowing, and that's obviously an important part of it. Actually, until we got to the questions section, I thought something strange was going to happen, and I totally agree with someone from Lead A for the first time in my career. But we then got to the section about the questions and the kind of difference between whistleblowing and grievance mechanisms. And I have to say I slightly disagree there. I know obviously there's the regulatory picture for whistleblowing as well there. But I do think actually grievance redress mechanisms are a very important early warning system. And the fact that individuals essentially need to be kept in the loop and that there should be some form of redress within a grievance redress mechanism can make it a lot more effective to make sure that those people come forward to start with. I think an important thing to remember there is that when we talk about remedy, people's thoughts often go straight to financial remedy, but remedy is a spectrum. And so one of the remedies could be, for example, new policies and procedures being put in place, which I think is something that loops back into the kind of whistleblowing scenario and people understanding more. So maybe a difference of lexology. I don't think we're fundamentally on different pages. But that is what I wanted to say, and invite questions.
Hi, thanks very much for that. Gabriel from Slaughters. You mentioned in one of your slides, I think, the risk of liability from, I think, misstatement from sustainability reports. And now with all the increased reporting requirements and stuff, I think there's a lot more corporate focus on sustainability reports. And a lot of their focus has come from the greenwashing side, but given that you're also talking about human rights, have you seen anything on the ethics washing side? Because a lot of the sustainability report also covers ethics washing, but there's a lot less regulation, restrictions around that.
Yeah, so I mean, I think it's almost interesting from a kind of sales perspective how all of these things have been put in different buckets over time, because essentially they all come down to the same thing, which is, lawyers we should understand very well, which is that if you want to make a claim about something, you have to make sure that it's correct. Correct that you can't make a claim about, how much coal you use, if you don't have the figures to back it up. Also correct that you can't make a claim about how many lives you've affected in a positive sense if you don't have the information and the data to back it up. It's exactly the same thing. But we've thought about, I think, all of these issues very much more in a kind of publicity sense over time than we have necessarily in a legal sense. And I remember a few years ago kind of speaking to someone who'd been on secondment to a large multinational consumer goods company during COVID, and the rigor that was gone through to be able to say kills COVID on a bottle of bleach, you couldn't say that until you'd actually managed to get hold of some COVID samples so that you could take it into the lab so that you could prove that that was the case. And ultimately, shades of grey, but is there a big difference between doing that on a bottle of bleach and saying something in your sustainability report?
The question, where does legal risk come from? Because if it's publicity, reputation, everybody knows, but if there are no causes of action to actually be sued, that might focus mine a bit less.
So, I mean, maybe we should hear about more from Lee Day on what causes of action there are, but I think we've seen quite a lot of innovation from various law firms over time. So I think I'd be cautious in advising a client that they could say what they wanted, no matter whether there was already some existing legal standard. And obviously remembering that tort law is an unwritten law that looks at the context of what's happening, what other people are doing and what's reasonable. So that's essentially a shifting paradigm as well.
Two more questions.
Thank you. Thank you so much for a fascinating presentation and also for building on the distinction between the grievance mechanisms and whistleblowing mechanisms. I would love to know your personal perspectives on the evolution of the civil liability provision in the CSDDD, from the initial proposal to the recent compromise text from the Council, which is likely to be the one that is adopted published in the official journal. And we can obviously anticipate the impact of the CSDDD to the extent that it enters into force on regulatory enforcement. But in reality, what impact do you think the CSDDD will actually have on human rights-based litigation claims in the future?
Yeah, so this is a really interesting one, and obviously things have changed over time, and I did take part in some of the early consultation sessions with the European Parliament members around what things should look like. And I've always had some reservation about the civil liability provisions, particularly because, and I know that other lawyers who might act on the other side of these cases think differently, but my view is that we have jurisdictional rules, we have those for a reason. The law has taken hundreds of years to evolve in the way that it has, and that's because there were reasons behind all of these things that happened. And to have this kind of wholesale change where essentially you do away with those jurisdictional nuances because there was significant pressure from NGOs to want to do that. And, whenever we discuss this provision, the MEPs would always come back and say, well, this is just what the NGOs, they want it so much. This is like almost the whole purpose of having this piece of regulation is so that we can have these civil liability provisions in there. I think it makes it very difficult when you think about how it's also going to affect businesses outside the EU. So people businesses that have had to essentially feed into disclosures that are made by corporates that are within the scope of CSDDD, and also kind of, how you just think about what is reasonable for a corporate to have done, and then, what the causation tests are going to be. And obviously the main difficulty with that is that it's a directive as well. So, we're going to have slightly different implementation in the different member states, which also have their own different procedural rules as well. So, in some ways, it's great for litigators because we're going to have quite a bit of uncertainty. But, yeah, I'm not a fan in general.
One last question, quick question.
Thanks. This is a double materiality question, and the question, I'll just use in context, the question is, how do we accelerate the arrival of double materiality in finance? Because my sense is it sort of works in the real economy, because finance does risk, so we don't have data like, the coal thing, risk is very intangible. How do we accelerate the arrival of double materiality? Because regulation is very single materiality focused. I'm regulating your company and this company. I have no interest in systemic risks. So how do we accelerate the arrival, and I'm thinking of climate, of double materiality in finance, which is quite different to the real economy?
Yeah, okay, so I think the first thing I'd say is that there is also a difference between double materiality and systemic risk, depending on your map of stakeholders. And perhaps another issue there is about the legal definition of stakeholders and how that's different in different jurisdictions. So obviously in some jurisdictions you actually have nature or maybe a river, etc., which has a legal personality and therefore can be taken into account as a separate stakeholder. And if you're a very forward-thinking company, you might have the environment generally, or the earth, as a stakeholder itself. But actually, mostly that's not taken into account. So if you're thinking about overall climate in double materiality, that's not necessarily even going to be taken account for corporates. And that's different, again, for financial institutions because mostly those are exempted from a lot of the regulation that's coming through, at least for the moment, which we're seeing. So how do we accelerate people taking that into account? I mean, I'd like, in some ways, to hand that back to the economists, because I think if we have... Let's say some economists, if we think, for example, about, is it Kate Raworth, donut economics, if we're thinking more in those holistic economic terms rather than the kind of old school economics in terms of Milton Friedman, then I think if we look at it in that perspective and hand that back and say, okay, we need you to help us with, I'll use the dirty word that someone else did earlier, modelling, then you can start to see kind of what the impact is going forward. But I think that there is still this view, and let's see how, for example, RWE litigation turns out and whether everyone is responsible for their own percentage of emissions. But if you can essentially see that everyone is responsible rather than the current situation, which is generally no one is responsible, then you can start taking responsibility for it yourself. But at the moment, we've got this situation where, I might want to use a disposable coffee cup, but actually it's a massive pain lugging it around. And if I see everyone else buying their coffee in a disposable cup, I just think, oh, well, me doing it's not making a difference. So I think there's more of a overarching societal and perception change.
Great. Thank you very much for the questions. Thank you very much, Sarah. Let's give her a round. We are rapidly moving from ESG due diligence and human rights claims to nature. So I'll invite Tia, Philip, Sharif, and Jeev to talk about UK company directors and nature. nature risk, a new legal opinion that I'm personally very excited about because I've heard it live 2 weeks ago, so very keen that colleagues share their thoughts with you. Just to quickly introduce the joint presentation. Tia Philip is actually my colleague at Pollination. She's an associate director, and within her role, she focuses on advising large corporates, financial institutions, and significant landholders on TNFD-aligned nature risk assessments and strategy development. Just to note, this is the first time we're mentioning TNFD. TCFD has been mentioned alongside other reporting acronyms. And on my side, on the right, we have Sharif Chibchi, King's Counsel, who is a barrister for Fourstone Buildings, and he has actually been one of the lead authors of the recently launched legal opinion on directors' duties of nature. Yeah, I think you have the floor.
Thanks, Catalina. Hi, everyone. My name is Thea Phillip, Associate Director at Pollination. Today, Sharif and I have the pleasure of speaking about a new legal opinion recently commissioned by Pollination Law as instructing solicitors and the Commonwealth Climate and Law Initiative, CCLI. The other barristers on this opinion we want to note were co-authored by Rebecca Stubbs, KC, Carl Anderson, Hussein Sharafi, and environmental law expert James Burton. So we're picking up on some of the points raised earlier, one being around the Klein Earth and Shell's decision and the judge's election not to comment on the scope of the director's duties, as well as some of the questions around forward-looking trends for litigation in the next frontiers in future, which also lead into our panel discussion this afternoon. So looking forward to that very much. This independent legal opinion, released 2 weeks ago, includes more than 100 pages of very detailed legal analysis, which I'm sure you'll all be very excited to get stuck into. It's publicly available online on the Commonwealth Climate and Law Initiative's website, as well as Pollination's. It comments that directors subject to the law of England and Wales should have regard to relevant nature-related risks in discharging the company law director's duties under section 172 and 174, which we've been discussing this morning. So hopefully it goes some way to filling the gap on the assessment of the scope of those duties. I will first provide a bit of an overview of the opinion and the project in general, as well as some key definitional concepts on nature-related risk that some of you might be less familiar with, given so much of this morning's conversation is focused on the climate risk side. And then I'll hand over to Sharif, who will provide an overview of the key conclusions of that opinion, synthesising the 100-plus pages for you into a short 10 minutes. The role of company directors in managing climate-related risks has been discussed in a landmark series of legal opinions in many other jurisdictions, but notably not the UK. These were released between 2016 and 2023 in a number of other jurisdictions, including Australia, Hong Kong, Singapore, India, and others. The first of these was published in 2016, so if we think about that in some time horizons, that's well before the Task Force for Climate-Related Disclosures finalised their recommendations, let alone had become mandatory in any jurisdiction. So these opinions really were groundbreaking at the time. That first opinion in Australia, known as the Hutley opinion, ultimately concluded that it's only a matter of time before litigation is commenced against directors for failing to perceive and act on climate-related risks where those risks have caused material harm to the company. We're now seeing this materialise. We've had the litigation we've spoken about this morning with Klein Earth and Shell. Also in Australia, ANZ Bank, there's been a recent shareholder action filed for failure to act on climate and biodiversity risk, which we anticipate eagerly. These opinions contributed to an overall growth at the time in the understanding of climate-related risk as business risk. And that was part of a wider growth in understanding at the time that ultimately contributed to many of the regulatory developments that we're speaking about today and all learning how to respond to in due course. For example, the mandatory TCFD disclosures that many of us will be becoming familiar with. But this now takes us to nature risk. Over the past few years, there's been a growing understanding in the scientific community, but also in the business community, about the extent to which nature and ecosystem services underpins the global economy. There's widely published research out there and many figures that attribute nature-related risk to wider financial risk, but one that's commonly cited is from the World Economic Forum, which is that 55% of global GDP is moderately or highly dependent on nature. This is at the same time that extinction rates now are higher than any other time in human history by factors of up to 100. And as well as the fact that recent research indicates that we've transgressed 6 of the 9 planetary boundaries that define a safe operating space for humanity. Those who work in this space will hear quite often that nature is following the same playbook as climate, but on fast forward. I very much see that. I trained as a lawyer for the early part of my career, but then moved across into climate and nature advisory because I wanted to be somewhere where it was happening faster. And I think that it's really interesting now seeing that nature is starting to increasingly creep into the conversation, and it's not just about climate-related risk now. So we thought it might be helpful to define some of the key concepts that underpin the legal analysis that we were very pleased to launch a couple of weeks ago. So firstly, when we talk about nature risk, what does that mean as compared to climate risk? So as defined by the TNFD, the potential threats posed to an organisation that arise from the organisation's and wider society's impacts and dependencies on nature. When we talk about impacts, that necessarily means the way in which an organisation's activities change the state of nature around it. And then when we talk about dependencies, that's the extent to which the organisation relies on nature and ecosystem services to function. These risks can be physical risks arising from degradation of nature or transition risks, such as those in the regulatory space or with respect to consumer preferences. An example of this that is drawn out in the opinion, which I think is a particularly helpful one, is with respect to companies in the UK food production sector who are highly dependent on soil health for their business models. The UK government estimates that soil degradation in the UK causes $1.2 billion in losses each year. And then we think about that degradation occurring at an increasing rate over time. That exposes companies in the food production sector to reduced access to or potentially higher costs for key commodities required for those business models, looking the whole way along the supply chain from producers, manufacturers, retailers, and also financiers as well. That brings us to the opinion that we were excited to launch with Sharif and the team of barristers. We think this opinion is particularly exciting for one reason being the lack of a detailed, comprehensive analysis on climate and nature-related risks and directors' duties in the UK as compared to other jurisdictions, but also because this opinion covers both climate and nature, which is a first for these types of opinions. Usually it's either climate or nature in isolation. When we were identifying barristers to instruct, it was particularly important to us that we were not focusing our scope on environmental lawyers. We really wanted to search out corporate and financial experts who could speak authoritatively about the state of the law as it is today and not progressively about how we would like it to be in future. In summary, the questions we sought counsel's advice on were, are nature-related risks relevant to directors' duties under sections 172 and 174 of the Companies Act? Are directors currently required to consider nature-related risks facing the business? What forms of board action or inaction in respect of nature-related risks might discharge or breach these duties? And what potential consequences could arise for breaches? And then finally, are directors permitted or required to disclose those risks, to take action or to mitigate those risks? So with that, I'll hand over to Sharif, who will summarise the key conclusions, and then I'll jump back in for some tangible, practical next steps for companies and directors.
Thank you, Thea. So my name's Sharif. It's very nice to see you all. Just doing the customary adjusting of the microphones. So I'm a disputes lawyer, and as Thea said, my background really is in corporate disputes and financial services. And for my sins, I started life as an economist and then a derivatives trader, and then I ended up here. So it's been a slightly unusual journey. Aside from my life as a disputes litigator, I'm also an advisor to boards on governance. And I normally ask that the word governance is put on the agenda and then when I stand up to speak to boards on it, I can see board members' eyes rolling and glazing over, because people think, directors often think that governance is a dull concept, addled with legal constraints, which interferes with the operation of a business. And governance isn't that. And putting my old hat on as an economist, I would say that governance is about making sure businesses run effectively and efficiently, using the talents of your board members, their skills and experience, and ensuring that they're plugged in to the underlying operation of your business. And you'll be able to draw on those talents, and you'll also be able to supervise the operation of the business. And so I think, looked at in that way, governance is about deploying your board as effectively as possible and identifying things that are of significance to the business, in particular risks and opportunities. And risks are a good lead-in to the work that we've then been doing with pollination. We were asked to consider whether under English law, directors were required to have regard to nature-related risks. And nature-related risks include, but are not limited to, climate risks. We heard from Paul Benson earlier today from Client Earth that the English law of directors' duties has a fair amount of uncertainty about it. And what we've tried to do with our opinion is dispel some of that uncertainty by providing a definitive guide to what English law currently requires. Now, I come before you not as an advocate to persuade you as to what the law ought to be, but as a lawyer trying to understand and explain what the law currently is. So our work is not a piece of advocacy or ambition as to what the law could develop to be. It is simply an analysis of how, as we see the current state of play. And quite a few people have commented on the length of our opinion. It is long. And I'm not going to, you'll be pleased to know, I'm not going to try and cover all of the bases today, but I'm going to try and draw out some of the themes that we thought were significant when we were doing the work, and some of the things that actually surprised us about the current state of the law. And some of that actually might give you a bit of an indication as to the direction of travel. So there are 4 propositions that I wanted to draw out today. The first is that directors' duties under English law have evolved over time as society's attitudes have changed as to what is responsible governance. The second is that company directors are required to take into account all relevant risks, and that goes beyond financial risks and includes climate and nature-related risks. The third is that disclosure standards are developing apace, and the regime is complex and varied. I'm not going to tread on the toes of those who are going to come later about that regime, but I want to say something about liability, and companies obviously must take great care over their disclosures, but assuming that they do, we think that the risk of voluntary disclosure is very low, and in fact there are good reasons why companies might want, good commercial reasons, why companies might want to make voluntary disclosures. And then the fourth point is that directors should draw little comfort from the fact that the Shell case did not pass the first stage, and in our view the risks of litigation continue to increase. So those are the 4 points I want to hit. I'm going to give you a little brief snapshot of the current state of the law on English directors' duties. I know many in this room will be familiar with the broad framework, so I'm not going to dwell on those. I'm just going to draw out some interesting points from them. The first point to note is that English law has largely evolved over time with case law. The 2006 Act was a fairly material milestone in that development, but actually the purpose of the 2006 Act was largely to capture, as regards directors' duties, what was already there. And that means that you can go backwards and look at the case law as to how it was applied, and forwards. And all of that case law should work together in understanding the current state of affairs. There were 2 core duties that our opinion was concerned with. The first was the fiduciary duty under Section 172, and that's for a director to act in good faith in a way that the director thinks is most likely to promote the success of the company for the benefits of the members as a whole. So that was the first duty. And then the second duty is that under 174, the duty to exercise reasonable skill and care and diligence. Now, the Section 172 duty we think is particularly interesting and we think is likely to be a source of further litigation in the future. And there are a few pieces of that I wanted to mention. The first is that it's a subjective duty, so it's left to the director to consider what is likely to promote the success of the company. The second is that there is no definition of success. There are various factors in the legislation that a director may have regard to, but they are non-exhaustive and each case will be fact-sensitive. Significantly, they go beyond financial considerations. So in our view, directors mustn't only have regard to the financial bottom line. And there may be circumstances, in fact, where there are competing considerations and directors might have to weigh, in particular, short-term financial benefits against longer-term strategic requirements. Those factors that a director may have regard to include the impact of the company's operations on the community and the environment. And that is a question, that part of the legislation is something that's not been litigated, and I will come back to that. So that was my second point about the definition of success. My third point under this duty is that a director who fails to consider whether something's in the best interest of the company or who overlooks something very material is judged to a different standard. At that point, a court will deploy an objective standard of whether an intelligent and honest man in the position of the director would have reasonably believed that that particular decision was for the benefit of the company. Now, in our view, that objective standard is likely to be a source of litigation risk for boards in the future. And it's striking for a director who's got a very varied agenda that if you don't look at a particular issue, if you don't make a decision, don't take into account a particular risk at all, you may well find much greater exposure than a director who has considered that risk and then made a business judgment on them. Anyway, so that's a little bit of a primer of the law. I know a lot of you will be familiar with that. In recent years, the courts haven't had a chance to really scrutinise these duties within the context of essentially non-financial considerations. We think the Shell case would have been an excellent opportunity for the courts to do that. The courts didn't take the opportunity there, but we expect that there will be other cases where these duties will be considered in further detail. So just a few points now on my propositions. My first proposition was that directors' duties have evolved and continue to evolve over time. We heard earlier on from Jeff, who suggested that the judiciary might themselves be playing a part in moving directors' duties forward. It's not quite how we see it on the current state of the law, but I want to give you an example as to how what the courts are doing, we think, is reflecting society's attitudes as to proper business management and good governance. And so I want to take you back to another case. It's not a recent one. It's from the 1840s or later, but it's quite a good tale of how directors' duties have moved on. It concerns the third Marquis of Bute. Not all of you will be familiar with him, but he was a director of Cardiff Savings Bank in the late 19th century. He was born in 1847 and was appointed president of the bank at the age of 6 months in effectively a director-like role. He is known to have attended one board meeting at the age of 21 and then no more until the bank's collapse as a result of a fraud when he was 39. In fact, by the time the bank collapsed, he had forgotten that he was, in fact, a director. The bank had some internal processes for handling depositors' money, and a fraud occurred essentially undetected because the processes weren't followed. Now, the Marquis had been sent the company's annual reports each year and some other documents, but he had no recollection of reading them. And his defence to the case, essentially, a defence was for breach of duty in allowing this fraud to happen, was that he said, essentially, I was unaware of these irregularities and they couldn't have been detected on the documents that were sent to me if I had read them, which in brackets I didn't. And the court found he wasn't liable, and that he was entitled to rely on those directors who had actually attended the board meetings to ensure that the relevant processes were followed. And we found the Marquis of Boot case pretty remarkable, actually, because as a litigator, and I do have to stand up and fight these cases from time to time on both sides of the fence, and I wouldn't dream of running any of the arguments that the Marquis of Boot's team did, because I know I'd be laughed out of court, and I know the case would be unwinnable looked at in that way. And when we now look at the sort of current state of the law has essentially evolved from exactly the same duties that were under consideration in the Marquis of Boot's case. But the idea that a director could now say, well, I know I didn't attend the meeting where these issues were considered, but I just relied on there's great people on that board. They would have done the great job, and it's no problem because I wasn't there when the relevant decision was made. That is just unthinkable in the current environment. And directors' duties, in fact, are probably higher than they ever have been under English law. They're expected to have a good understanding of their companies, the risks, opportunities, and context in which they operate. They have complex disclosure obligations and regulatory obligations, and they're not simply permitted to take information at face value. They're expected to challenge management and ask probing questions. And all of that really is as a result of society's expectations changing as to what directors should be doing. So that moves me on to my next point, which is that when we were looking at the approach of company law to risk, we reached the conclusion that nature-related risks, including climate-related risks, are no different to any other risks that boards have to tackle. And of course, the risk to a particular business is always going to be fact-specific. But we think it's very significant that directors must look beyond financial risk in what they're doing. Of course, often boards will ultimately be interested in the financial bottom line, but it is simply not an answer to say, I ignored a particular risk because it didn't have an immediate or an obvious financial impact on my business. Now, again, this is an area where the law just isn't very clear on the authorities, but it is striking that under that fiduciary duty under 1722, there are a list of relevant factors that go to discharging that duty, and there's some non-judicial writing that suggests, including from Lady Justice Arden, that those factors are actually relevant to the discharge of your duty under 174. And that is certainly our view, that the courts, there's like to be some degree of read across between the fiduciary duty and the duty of care in terms of the factors that directors need to have under consideration. And the punchline really for us is that directors are required to take into account all relevant non-trivial risks, whether financial or not. Now, as regards nature risk, as I said, it will depend very much on a business as to their particular impact or relevance. But in fact, many of the nature-related risks that we looked at when we were doing our opinion were actually tangible and could have a clear impact on a business's operation, whether it's part of its supply chain or its cost base or the regulatory regime or its reputation amongst consumers. And so sometimes when one's looking at these sorts of risks, I always feel that some of these things are rather nebulous and it's quite difficult to bring them home to reality. But we felt that with a lot of these nature-related risks, actually when you sat down as a business and looked at what you did, it was quite easy to start seeing areas where nature could have an impact on your operation. And for directors, all relevant non-trivial risks really should be on their agenda. That brings me on then to the disclosure regime. I'm not going to cut across what's coming later. The disclosure regime is complex and highly varied. It's pretty unhelpful in areas because the taxonomy is different, so it's not always clear exactly what concepts are covered. But even as regards to the current mandatory disclosure regime on financial reporting, we see that some of it covers risk beyond climate risks, including potentially nature-related risks, and that is both impacts and dependencies. Now, in our opinion, we've considered the question of whether directors would be exposed to a greater risk of claims if they make voluntary disclosures. We think that actually that's unlikely to be the case. Of course, directors must ensure that their disclosures are accurate and reliable, but they're not prevented from making voluntary disclosures, and in fact, in some areas, there's quite a lot of investor and consumer demand for them to do so. And we saw from the Shell case that actually one of the reasons why permission to pursue the derivatives claims was refused was because Shell had actually considered the relevant issues, taken advice, and given voluntary disclosure. So the voluntary disclosure was a point in the board's favour in Shell, not a point against them. Now, moving on to my last area, I just want to say something about the risk of claims. I've said to you that directors shouldn't draw too much from Shell in terms of breathing a sigh of relief, because I think there'll be other claims of this nature coming through. Shell, to some extent, is a product of its circumstances, the evidence, the particular judge. I mean, these cases are always a product of the way that they're put and what was before the court. We think that litigants in the future will learn from those experiences, and then there'll be a case put in a slightly different way with different arguments. There is one point where I think we particularly part issue with the judge in terms of his findings on Shell. He found that a declaration of itself wasn't a useful remedy in this context, and we don't agree with that. Our view is that, in fact, in an area of uncertainty where directors are making big and difficult decisions with long-term consequences, they might actually find a declaration useful, not actually pointless. And in terms of the way that case evolved, one of the issues that didn't come up in that case, but I think is likely to be of significance in future cases, are these occasions where directors don't consider an issue at all, and as a result, they could be exposed to a claim under 172. So that risk I talked about earlier on didn't actually come up in Shell, but I think could be a cause for significant litigation in the future. So just a few, sort of putting together a few final points on where we are on claims. The first is, I always say to directors, they shouldn't be driven by whether or not someone's going to land a successful claim against them. They should be driven by what is in the best interest of the company in discharging their duties. The second point is that many of the challenges in terms of bringing a successful claim turn on whether or not you can establish a loss. Now, of course, yes, that for a director, you might draw some limited comfort from the fact that you're unlikely to have to put your hand in your pocket. But actually, it's not much comfort to know that you could be on the receiving end of a claim where someone successfully establishes liability, even if they don't then get home to prove a loss. That brings me on to my third point. Many of my corporate clients are keen to avoid litigation full stop. They're not interested, frankly, in being told, if this case fights and you get to the end of some enormous trial where all the lawyers have had a very jolly time, that we will win. They want to kill off a case at the beginning. And looking again at the Shell case, for the corporate clients, they'll be saying, obviously we want to do the right thing for the company, and we want to prove to the court at the first stage of a derivative action that we've done a proper job so that we are vindicated. And then on to my fourth point, putting aside the derivative action type cases, there are other avenues for claims. Firstly, looking at it from a purely selfish individual's perspective, directors will have regard to their own remuneration packages. And so a director finding themselves in breach of duty, even if it's not actionable, even if there's no derivative claim, might find that their compensation package is hit. They might end up leaving as a bad leaver, not a good leaver. That is surprisingly, or not surprisingly, unsurprisingly, at the forefront of many clients' mind. So that's another reason to get it right. And then finally, in terms of other areas of claims, in recent years there's been a new line in sort of financial disclosure type cases brought under FISMA, And there's a section 90A of FSMA and Schedule 10, which are essentially issuer liability claims. And I did essentially the leading case, which is the Hewlett-Packard autonomy case on that. But they are claims by essentially investors on the back of financial statements which give rise to issuer liability. But the issuer, if it is found liable, can then sue the directors. And that's in fact what happened in autonomy. It was a dog-leg claim brought against the directors in respect of issuer liability. And an issuer can, it's a type of fraud case, but an issuer can face liability where disclosures were made recklessly. And so in this sort of field, that does strike us as being particularly pertinent, because again, if you're making disclosures and you haven't actually properly investigated what you're disclosing, if information is given off the cuff without proper investigation, you are potentially at risk there. So that is a whistle-stop tour of 119 pages. Thea's going to come and tell you essentially what the punchline, what the practical solutions are for directors on the back of all of this.
Great, thank you so much, Sharif. And as I'm sure many of you can imagine, as instructing solicitors and commissioning partners, we were very pleased with the results of this work. It's an incredibly comprehensive analysis, and the conclusions are really actionable and practical for readers, both the boards and their companies. The opinion clearly identifies 5 practical steps that boards and companies should take in response to the findings of this analysis. These include identifying and actively considering the nature-related risks faced by the business, assessing and evaluating these risks and the potential they have to cause harm to the company. And we find that the Task Force for Nature-Related Financial Disclosures is a useful framework in that regard. Manage and mitigate nature-related risks where this is considered appropriate. Disclose those risks in line with legislative and regulatory requirements, but in some cases, voluntary disclosure might be seen as beneficial in meeting directors' obligations. And then finally, to document the directors' decisions as going part through this process and the reasons behind them. This will give directors a greater degree of protection against shareholder and claims for breach of duty compared to directors and companies who don't take these steps. It also really clearly frames this as a governance issue as well, which I think is really was drawn out through Sharif's remarks. We also wanted to provide some thoughts around the tools and frameworks that are available right now. A lot of this can sound really overwhelming, and we often find that with our clients who come to us saying, we've just gotten a grip of climate, what is nature? Can you help us with that process? And really interestingly, there are fantastic tools and frameworks available now that companies can step through even without comprehensive supply chain data or even without asset level data. These provide sectoral and jurisdictional materiality assessments that we recommend governance professionals and their companies consider. So some of these include the Encore tool, the SBTN materiality screening tool, and GRI's sector program, and then various supply chain analytics offerings that look at species extinction risks within supply chains. There are a few other things that we were sort of thinking about talking through today, but I think that's been a huge amount of information, and we're really appreciative of your time. Some key lessons that we wanted to draw out as Pollination, we're climate and nature specialist advisors, interdisciplinary, and doing this work with a lot of the leading companies and financial institutions who are already taking steps to understand and respond to nature-related risks more broadly to climate, is that much of the internal infrastructure that companies have developed to understand and report on climate-related risk can also be leveraged for nature-related risk. So that sort of draws some of those synergies internally and makes it a little bit less daunting when you're looking at nature-related risk assessments for the first time. And also that boards and companies should start addressing these issues now and start sooner rather than later and get ahead of the regulatory curve, because there will inevitably be data and skills gaps identified throughout that process. It's a bit of work, so we recommend starting sooner rather than later. But I don't think we have time for questions because we've run a little bit over. Thank you so much, and happy to chat during the breaks as well. Thanks.
and lunch. So we have an hour, so if you don't mind coming back at 1:45 for the next sessions, that would be great. Thank you very much. Again, thanks to our virtual audience as well. Yes, I will introduce. Welcome back, everyone. I think we're ready to get started. So welcome back, in-person attendees, virtual attendees. Thanks for staying with us on the line. So for our next session, I will be introducing Veselina Haralampyeva, who will be talking about the role of the board, minimizing the risk of greenwashing claims through effective governance. Veselina is the head of Sustainable Finance Governance and Regulation within the European Bank for Reconstruction and Development in London. She leads the energy and climate change policy of the EBRD's legal department, and she advises on matters relating to energy and climate change, law, policy, sustainable finance, governance, and regulations. Vessi, thanks for joining us today.
Thank you very much. Good afternoon. I hope you had a nice break. And thank you so much to the organizer for the invitation. So I'm happy to talk today about the role of the board in minimizing the risk of greenwashing claims through effective governance. For that, I thought there are three key topics that I'll be covering. One is what is the role of the board? And I'll go back to Sharif mentioning earlier that it used to be a dry topic, but not anymore. What is effective corporate governance really, and looking then at climate change as a financial risk. I also will be looking at the responsibilities of the board of directors for effective corporate climate governance. I would like to highlight, what greenwashing is, and give you a snapshot of what EBRD is doing to minimize actually such greenwashing risks, and even more to prepare our clients for the transition to a low carbon and resilient economy. So the role of the board. The key purpose, there are different definitions, but I think this sums it up, is to ensure the company's prosperity by collectively directing the company's affairs while meeting the appropriate interests of its shareholders and relevant stakeholders. So ultimately, it's really for the board to judge on a case-by-case basis which stakeholders it treats as relevant. We've heard earlier in the day discussions about financial materiality versus impact materiality. And this is becoming increasingly important for businesses from different industries and sectors. So board members also have to take into account the law, the relevant regulations, the commercial considerations, and in pursuing this key purpose, a board of directors faces a uniquely demanding set of responsibilities and challenges, and it also faces, on a day-to-day basis, a number of objectives that sometimes are conflicting. They seem contradictory. So the board is a collective body. I also wanted to mention that there is sometimes a confusion on the role of executive director and non-executive director, but ultimately they each have the responsibility to act individually, to contribute with their skills, capacities, knowledge, range of perspectives, to inform the board and to ultimately reach the best balanced, independent, collective decision. So what are these contradictory objectives at sometimes, which we, as a multilateral development bank working in Central Eastern Europe, Central Asia, and North Africa, so a lot of these frontier economies, emerging markets. So we are facing those on a day-to-day basis with our clients. So the board, on the one hand, has to be entrepreneurial. Indeed, they need to be able to bring in all the new trends, developments that are material to the company at the board, on the board agenda. At the same time, the board has to keep the businesses under prudent control, so they have to be very strict. The board members have to be sufficiently knowledgeable on particular matters, but also retain an objective, longer-term view of the industry and the economy. So this is really expected, goes deep into the board duties that we heard about earlier today. The board members have to be aware of the pressures of short-term issues for the particular company, being on the products that it offers, on the marketplace in the industry or in the particular jurisdiction, but at the same time has to take account of much broader, longer-term trends, more kind of horizon scanning, looking into the future. What are those trends that may emerge in mid to long term that are important for the company, for the sustainability and kind of building a resilience of the business model of the company. Board members have to be knowledgeable about local issues, so they have to be very well placed within a certain jurisdiction and sector, and local communities understand what is the pressure from shareholders, but also aware of wider competitive influences increasingly occurring across borders. So for multinational, but not only multinational businesses, really businesses now depending on various supply chains. So, and of course, this goes to also knowledge about the commercial needs of the business, so delivering on the key objectives for the shareholders, so increasing value, but at the same time, the board members need to act responsibly towards stakeholders, towards customers, but also employees of the company. So I wanted just also to highlight the 6 key areas that boards are focusing on. One is establishing the vision, mission, and values, so that's clear. So this is quite important to determine what are the values that are promoted through the business, ensure that these values are enshrined in the corporate policies, processes, services, engagement with stakeholders, employees. The board members are there to set the strategy and the structure, to review and evaluate present and future opportunities and threats and risks in the external environment, but also the current and future risks and weaknesses relating to the company, internal. So with that comes the responsibility for the board to determine strategic options, determine the business strategies and plans, and look at the organizational structure, the capability of the company to deliver on the strategy. Of course, boards also have to know where their authority ends and what matters have to be delegated to management. They need to determine monitoring criteria and internal controls, communicate frequently with senior management, and others. The fourth area is the importance of accountability, the exercising this accountability to shareholders. So, as I mentioned, taking into account the shareholders' interest in each and every decision they make. I would have a separate category on the board's responsibility to other relevant stakeholders, because quite often it requires different types of discussion and considerations, especially in the context of broader impact materiality. And so maintaining such open, transparent communication with the broader stakeholders is also falls within the remit of the boards. And ultimately, I think transparency and ethics. This is important because, related to the accountability, being transparent about your business to shareholders, to stakeholders, upholding the higher ethical standards and rules is strictly within the remit of the board. Now, out of this, I would highlight there 3 key requirements for the board. One is to have the relevant expertise, have the accountability, and transparency. Ensure that good governance also involves regular and transparent communication. And we will see why this is important in the context of climate change. So this is just an introductory slide. I think we all are like-minded here, and we understand that climate change and climate-related risks can have a significant financial impact. So the World Economic Forum registered climate action failure, extreme weather events, nature and biodiversity loss as the top 3 global risks, ranked by severity and both in severity and likelihood. So how intense they are, how severe they are, and how likely to occur are amongst the top 3 global risks. So this is for one slide that actually it's quite helpful in discussions with clients on underlying the climate changes happening now. These are examples of a couple of physical climate risk events. In Germany, the drought of Rhine River and the collapse that it brought for several months to transportation, to the other commodities, to the whole supply chains that depended on it. In Pakistan, of course, that touches the massive flooding that flooded around 10 to 12% of the territory of Pakistan, had ultimately human costs. So many people died and over 2 million were left homeless. And also as a sobering here, statistics, the 700 million people are at risk of being displaced as a result of drought by 2030, and if this doesn't cause a significant impact on businesses and economies, what would? So we have started looking at the connection between good governance, effective governance, climate governance, and the support we provide to clients, both as an investor as advisory support in 2018. And in the development of a corporate climate governance approach that the bank has now adopted as part of our Paris alignment commitment, we very clear, and we are being guided at that time by some of the studies of the World Economic Forum, that the board should be accountable for the company's long-term resilience with respect to potential shifts in the business landscape that may result from climate change, and failure to do so may constitute a breach of directors' duties. Now, we've heard today in the morning discussions about, in particular, English legal system. We are a multilateral development bank, so we operate in close to 40 jurisdictions. There are different legal requirements and expectations, but ultimately, the expectations by investors that companies would be managing better climate risks, will be transparent about it, is part and parcel of what our companies expect to receive, and kind of shapes I would say the policy environment, even if there are not strict legal rules in those jurisdictions. So climate change impacts an entire organization, starting from governance, but really looking at strategy, at risk management, metrics and targets, and ultimately disclosure. So we work with financial institutions, with companies from real sector, various industries, also with SMEs that are particularly affected and vulnerable to climate change. And our approach varies, but we have our products, our services are geared either top level, engagement with government, government and senior management, or engaging closely with senior management in order to develop the functions, the processes, the governance structure, eventually to inform also board decisions. So, so this is a kind of an issue that affects all levels of an organization. I also wanted to, before we look at the specific issues arise in relation to greenwashing, just to have a slide on what greenwashing is. So there is no harmonized legal definition, but it's very important for our work and ultimately for the economies, because this is a problematic practice that undermines the genuine action of company or of investors to act responsibly in relation to one of the defining issues of our time, which is climate change. So greenwashing generally concerns misrepresentation, misstatements, or false and misleading practice in relation to the environment. It occurs in disclosures and marketing with non-financial reporting. Quite frequently, what we have seen is companies are under immense pressure to communicate certain sustainability or climate goals. They include certain targets in their sustainability reporting on investor communication, but it is not underpinned by proper governance or marketing and brand image. So when it's a matter of being ahead of your peers, getting a better share of the market by misrepresentation of a company's green and sustainability credentials. For solicitors, look, there are quite a number of different categories of greenwashing determined by legal regimes and how they are codified in different legal acts. But we've had, I'm also a member of the working group on climate change with the Law Society, and we've looked at 3 types of claims that a solicitor may want to warn their client and employer. One is when a company has broad claims or buzzwords, when, for example, say eco products or sustainability kind of claims or becoming, I don't know, green. So having this net zero buzzwords that are very quickly adopted through maybe some of the management functions, through the sustainability team, if at all, but through their marketing. So as a solicitor, it's quite important to advise clients that absolute claims that, for example, indicate a business has certain climate gradations, when they are absolute claims, they quite often may lead to greenwashing claims. We haven't seen in practice any businesses that have no negative environmental impact across its full life cycle. So that claims would require a very high level of substantiation, robust documentary evidence, risk management. And so we would advise our clients to stay away from that. The other is, of course, net zero and carbon neutral claims. So many financial institutions are under pressure to have net zero claims, to aim that they are carbon neutral, but now emerging sustainability standards such as ISSB, but also CSRD, are asking to be fully transparent about how do I arrive at that conclusion. Are you using offsetting? If so, you have to be transparent about it. And so it's, so this is also future climate commitments. So we will be, net zero by 2030 or statements like that. Also have high risk of businesses being accused of greenwashing. So key strategies for mitigating greenwashing risk. Going back to the chart on the main board, the key areas for boards, we were talking about first, capacity of the board. So the board has to have the right expertise. So if you as a business make certain claims that you are net zero, then the board definitely needs to know what net zero is, is it regulated, what is the national legislation, how does it define it? So increasing the capacity and skills and various perspectives at the board in relation to sustainability. The other aspect is accountability. Again, looking through those previous slides on the role of the board, accountability has to go deep into the organization, to senior management, senior officials. The boards have to be aware, have to be accountable about all communication with the broader public about their sustainability claims. And one very powerful kind of approach to mitigate greenwashing risks is to be transparent, not necessarily about the targets that you have set, but how do you arrive to those targets? What processes, what due diligence, what risk management, scenario analysis you have taken, and how the conclusions of those internal analyses have then informed decision-making, investments, engagement with investors. So I think what is important, it's very much coming, is the pressure for companies to publicly disclose their transition plan as a voluntary instrument, but also as a tool to mitigate greenwashing risks by identifying, what are the challenges, what are the risks, what are the opportunities, what the company, what the directors are doing in order to, to become more sustainable, and this very powerful way to mitigate greenwashing. This is one just example of how we, a starting point for our engagement with clients. We assess what's the board oversight, we look at the cross-functional approach of what functions are involved in sustainability, what's their remits, how the processes are set up, what's the reporting to the board. how remunerations are also taken into consideration. I wanted to bring to your attention one piece of analysis that informs also our engagement and advisory with clients. And this is informed by the voluntary transition plan template published by TPT. And this is built on 3 key pillars: having the ambition, having a clear action, and accountability, or AAAs. So one is to set the ambition. When you set the ambition, usually this is not something that you negotiate as a business. Ambition stays internal until you go through the internal robust risk management and development of policies and strategies and processes. So ambition would inform then the action. So what will be the implementation strategy? What will be your engagement strategy with broader group of stakeholders? How this may need to change and to be updated in order to achieve your ambitions? And ultimately also accountability, where the role of the board is quite important. So when you set certain metrics and targets, how do you plan to achieve them? How are they informed by SBTI or other kind of targets or processes? Or in some countries you have low carbon transition pathways, so how your business fits within the country platform that the government or the industry has developed. And so all that has to feed into the way the organization is governed. So we're talking about here transformation of the business models in order to set them on a more transition pathway and to avoid greenwashing risks. It's a snapshot of our approach or our toolkit. We call it EBRD Corporate Climate Governance. So we look across the 4 thematic areas. So, they resonate very well with the 4 pillars of TCFD, now ISSB, and also very much in the core of the CSRD and the ESRS, the European Sustainability Standards. We assess companies at each of these stages. What are their, responsibility for climate change? What are the functions? How such considerations inform decision making? Very importantly, what's their stakeholder engagement? And we rank them according to their climate maturity, and you have different levels of climate maturity or practices, and we work with them as investor, as technical assistance provider and advisor in order to help bring them to a more advanced practices. And our advice has always been that disclosure comes when actually you have done internally your work and you're prepared for that. And these are 6 guiding questions, initial for setting the right agenda and focusing the climate on the questions that we want to raise. So it's really, if you have a climate commitment, how then the organization govern the delivery of this climate commitment, looking then across the strategy to risk management, specific metrics and targets that are developed to achieve it, and finally, how do you plan to disclose it and to engage with your stakeholder? So that's for me. Thank you very much for your attention.
Thank you very much, Leslie. Questions? Maybe time for one question? Is there any? I have one question, but go on, Mike.
I did give everybody else a chance, honest. Can we apply that excellent framework to EBRD? It's becoming clear that tipping points are really important. So how is the EBRD incorporating the Earth and climate tipping points we're rushing towards in its strategy at the board level?
Yeah, very relevant question. So there are 2 things. One, the happy record that we have is that we are the first MDB to issue a TCFD report, way before the World Bank IFC. We are the first one to commit to Paris alignment and develop Paris alignment methodology, which part of it incorporates, so we look not at the use of proceeds, where our investment goes, but really at the counterparty risk. So we assess the counterparty, we engage, we dedicate resources for that. We also have a team that works on policies. So in order to address the huge challenges that you are saying, we need to, of course, to look also at the policymakers and regulators. So we're working with that in our country's operations. So that's in terms of our institutional commitment, engagement with clients. What also I would like to say is that we, as a multilateral development bank, we work in those regions that are most vulnerable, but also that are least prepared to face the consequences of climate change, and if you get into the long discussion of responsibilities, have contributed the least to the situation where we are. So we sometimes, the success for us in terms of Paris Alignment, of course, to engage with those businesses that are greening or in the process of greening, becoming more sustainable. But sometimes we need to invest in businesses where other investors will not. So we cannot say we close the doors to certain countries' operations that are dependent on fossil fuel. There is no other source of energy production. What we can do, and this is under our new energy strategy, is that we work with them to invest into new ways of producing electricity or energy in general for, I think, new investment, but providing, engaging also with the country, so there is a clear public-private partnership and a transition plan, not only of the particular client, but of the industry and the country as a whole. So way ahead some of our more developed shareholders that sit on the board, North Macedonia, for example, which is highly dependent on coal for years. Thanks to early engagement by, with EBRD and other donors, they have now a clear phase-out commitment and plans for investment into renewable energy, just transition, engagement with the local communities in order to retrain them, reskill them. So it's different kind of product offering and services, but ultimately they come now, it's one of our policy products is called a country platform. They come out as one of the front runners in the region. And we're looking for developing similar partnerships and similar commitments with Egypt, Kazakhstan, and other countries.
Great. Thank you very much, Bessie. Let's give Bessie another round of applause for today. For the next session, we're going to be talking about activism as a driver of change for business. And we have a joint presentation with David Hammond and Catalina Becerra Trujillo. Just to give a quick introduction of our presenters. So David is a public policy specialist with experience advising multinationals on a wide range of activist-driven reputational and regulatory issues. And he sees a data-driven understanding of activism as a change to turn risk and crisis into opportunity, forecasting where and how activism will change the operating landscape. Catalina Becerra Trujillo is a research associate at Sigwatch. She's a qualified attorney specialized in public international law in Colombia, where she advocated for victims of state-perpetrated human rights violation and practiced as an in-house commercial attorney. She specializes in public international law, primarily on the intersection of international economic law and human rights. Thank you very much. The floor is yours.
Thank you very much for those introductions and having us here to speak. So, we are here today to talk to you about activism. Now, some of you might be thinking, why are we talking about activism? And many of you will be thinking, of course we're talking about activism. We're here to talk about activism as a driver of change for business and as a driver of risk for business. Also as a predictor of change and of risks. We've been talking a lot today very concretely about risks now, risks in the past, risks that are just around the corner. We use the perspective of activism to understand these risks today and far further down the line through one of the main drivers, which is activism. So, I'll give a little introduction to our company, our business, first of all, so you understand why we're speaking about this topic. Over the past 25 years, we have collected data on activism. We now collect it, have done for over a decade, on a daily basis, according to a standard methodology. Now, what this allows us to do, is it allows us to monitor trends within activism. Which companies are being targeted? Which issues are activists targeting companies on? Which tactics are they using? And when we're monitoring these trends, it enables us to get an understanding of where it's all going and how it fits into the wider stakeholder landscape. This enables us to provide information on risk for businesses. It also enables us to speak a little bit wider about where change in society is going. Now, before we move on, Catalina, you were going to talk a little about our methodology, just to clarify what it is that we mean when we speak about activism.
Yeah, so it's quite important because we will refer a lot. As David has already pointed out, he has 1,000 times already activism, and we will refer 1,000 times more to activism and NGOs. And therefore, that's why we should define it. So when we refer to activists or NGOs, we are referring to traditional liberal cause activist groups without overt connections to political groups, funding, or business. That's what Sea-Watch's methodology has been built around for the last 25 years, as David has pointed out. And we find it provides the cleanest and earliest signal for emerging reputational and regulatory risk. However, David will talk a bit more about all of that later. But yeah, in a nutshell, we are tracking campaigning, advocacy, grassroots groups, whistleblowers, and think tanks, independent of political parties or business interests across all causes and issues. We're also tracking labor unions and professional associations when they campaign on issues of public concern. So for instance, take labor unions campaigning on supply chain abuses, or also on medical associations campaigning on air pollution. And all of these groups that I had just mentioned attempt to influence business, public, and policymakers to drive change in society and tend to seek to expand or protect personal liberties. So in that sense, it is essential to state that this means that most of the new wave of anti-ESG sentiment has been excluded from our core methodology. These groups primarily found in the US that seek to limit personal liberties, such as religious groups, anti-abortion, anti-LGBT, anti-ESG, do not currently fall within our core methodology. And it's not that we are not watching them, it's more that we are currently keeping our monitoring separate because they impact stakeholder groups differently. So please bear that in mind. And now, continuing, please.
Yes, thank you very much. So that's the methodology. The core of it is liberal cause activist groups, as they have been traditionally campaigning for decades. And we have come to understand how these groups are delivering impact on business quite well. The nice thing is it's a very, very broad range of groups, both in the type of campaigning, but also in the regions, the issues that they're campaigning on. Very widely distributed, very diverse. But they all come together to form what we like to call the activist ecosystem. All of these different groups campaigning towards their causes, towards their issues. And so right at the front edge, we have the radical edge. And those are your disruptive groups like Just Stop Oil, Extinction Rebellion. And their function is primarily, instead of to generate sympathy, is to raise awareness, is to get a spotlight focused on these issues. Then behind those, you have groups which are using a diverse range of tactics to pressure companies and to pressure businesses to change their behavior on social issues, environmental issues. And then at the tail end, you have the groups which are prepared to engage with business, will work together on joint initiatives with business to drive meaningful progress on the issues at hand. So we have all of that working together as an ecosystem. And there are three main routes by which activists are actually impacting businesses and wider society through their activity in this ecosystem. We've got reputation, regulation, and responsibility, the three R's that we like to use to explain this. So to touch on the first, reputation, I'm sure reputation management is something that you have all had conversations about. Activists are campaigning to drive negative reputational impact on companies. And this is the disruptive protest, the demonstrative protest that we're all used to seeing in the news. Just imagine thousands of branded plastic bottles dumped outside a company's headquarters and an ensuing social media campaign trying to target consumers and make clear to them that through the use of plastic, this company is driving irreparable harm on the environment and indeed on communities. So that is the first and most immediate type of reputational campaigning that we see. What are activists trying to do here? Yes, they're trying to make clear to consumers what company impacts are, what the impacts of their consumer choices are, and potentially drive them to change those choices and impact companies financially. But they are also trying to paint that picture of risk within companies, within boards, within their management, to heighten the idea that there is reputational risk that might have a financial impact, to then drive voluntary progress on issues like plastic, like climate, etc. And we see an enormous different types of it's not just plastic bottles dumped in front of an office. It can be reports, which is where much of the very interesting information for policy often lies. We will see activists be very specific about which forums they target, which moments they choose for their campaigning. It's interesting when we are able to watch these trends on a top level, we will see them spike up around key drivers. For example, COP events, they drive huge spikes in campaigning across a range of issues because activists know that across stakeholder groups in these moments, attention is focused on these issues and on the people who are in power and able to drive change on these issues. All of this reputation issue has been about activists using their soft power to try to get at consumers who have hard power over companies through their consumer choices. They're also trying to get at the management and decision makers within those companies. They also have hard power. What activists are also always after is the hard power of regulators, of legislators, to impact company behavior. And that is where this then links in to the legal risk. Because, of course, if you have regulation, it then becomes an issue of compliance. And activists absolutely love to pressure regulators to pass legislation. It's what we call when they're in their change maker function. They're pressuring for new rules. Once those rules are passed, whether they be exactly as they would have imagined it or not, they will then use these standards on companies, again trying to impact their reputation to try and drive further action on these issues. And there we have activists driving change in company behavior through regulation, reputation, and then responsibility is the third point that we like to talk about. And this is the least tangible of these three, but I think it's the most interesting, and it gives us the most insight when we are looking the furthest forward, is through this campaigning, through all of this communication work that activists are doing. They are brilliant communicators. They are trying to change the way that society, key stakeholders in society, think about the issues of concern to us today. Yes, they are trying to create concrete standards, but through that activity, through this awareness raising, they are trying to change our opinion on these issues. I like to use a public policy concept to explain this, which talks about the Overton window. You might have heard this, but it's essentially the window of acceptable policy within society. As society changes, as new laws are passed, this window moves along. What is socially acceptable moves along. So decades ago, across many societies, the death penalty was an acceptable thing. It was widely accepted throughout populations. Now this is no longer the case. And there are other acceptable policies that have moved in to fill that gap. So through their campaigning to raise awareness, to create standards, to drive change in company behavior and regulator behavior, activists are changing the way that society thinks about these key issues. Now, when you take all of that and you place data underneath it, you can start to play around, understanding where it fits into the social and political concept and get predictive. This allows us to talk to companies about what risks are likely to hit them further down the horizon, including the legal risks that we've been talking about today. Now, before I pass over to Catalina to speak a little bit more about how activists are using the power of other stakeholders to drive change, I'm going to show you a little bit of this in action. This is an issue that we'll all be very familiar with. It's cropped up a number of times today. This is greenwashing. So the red line there is activists campaigning on greenwashing. You can see that activists were campaigning on this issue for years and years and years, and public awareness remained low, and suddenly there was an escalation in activist campaigning, and so trends in, this is just Google Trends searches, it's a very rudimentary way of trying to track this, but so public attention began to grow, and then we had regulators paying attention, and that then comes into a sort of a feedback loop, a self-reinforcing system, because we have these standards. Activists take these standards, use them to hold companies to account, and so the narrative continues to develop. Now, pass over to Catalina to talk a little bit more about how activists are using the voice power of other stakeholder groups.
Sure. Thank you, David. So let's take a look at a couple of examples. The first example that we wanted to bring today is divestment campaigning. So first, to begin with, the whole idea of these examples, again, just to reiterate what David said, is how activists use all the soft power that they have to drive or leverage the hard power of others. In this case, financial institutions. So on divestment campaigning as a whole, it has been one of the most popular strategies that activist groups have used in the recent years. But what is actually happening here? What are activists trying to achieve? Divestment campaigning doesn't limit itself to just trying to keep money away from the projects that activist groups don't agree with. Actually, it has a lot to do with leveraging the hard power of institutions. And as I said, in this case, financial institutions. So their main aim of targeting these institutions is to remove their social operating licenses and create reputational risk for them in the hope that they will pass this pressure on to their clients. In other words, activists pressure financial institutions to use their hard power over their clients to avoid further reputational risk to their brands. And we have already seen this happening actually quite frequently. For instance, take the 28 insurances like SiriusPoint, Riverstone International, Enstar Group, and Blenheim, who have so far declared that they will not insure ECOP due to climate and human rights pressures from activists. And another example is the following graph that shows the trend lines of campaigning of oil and gas and coal. Please follow the red and yellow lines. And what we see in this graph is that after years of activist campaigning for companies to divest from fossil fuels, COP26 resolutions in 2021, so please look at 2021, finally showed an international statement on the phase-down of coal. What happened? This gave free way for activists to start directing more resources to the oil and gas campaigning, and that's the bifurcation that we see in those two lines. So this doesn't mean that activist groups have stopped advocating against coal. What it actually means is that they acknowledge the importance that these COP resolutions have to the general public. That is, the general public holds in a very high place the COP resolutions. Therefore, if financial institutions keep investing in coal, this in itself, despite what the COP resolution states, inherently poses significant reputational risk for the financial institution. So, as a result, the strategy has pivoted to targeting oil and gas, aiming to achieve comparable outcomes in future COPs. And now, having said all this, let's turn to look at another example that we made today. That is courts, which we have already talked a lot today, but I invite everyone to think of courts now not in the lens of law, but more of the lens of campaigning and what it means in the environmental and not environmental in the environmental that you guys are thinking, but in the environmental landscape of activists.
Yeah, the wider landscape.
Yeah, the wider landscape. Thank you. So the first thing that I might say about litigation in the world of campaigning is that this is just the peak of the iceberg. Litigation flags, in most cases, years of campaigns, calls, and failed opportunities for companies to engage with activist narrative. Are activists successful at court? Not always. However, campaigners are not always seeking to win. They have other priorities in mind. So for instance, take into account placing the defendant under scrutiny in the court of public opinion, showcasing faults in the legal system and how the system must shift, and overall raise awareness of their issues, meaning that even if they don't win, this moves the overturn window that David was talking about before. And in this case, what litigation does is that it shows how the system fails, and it's part of bigger campaigning trends to change the issue's viability. So in other words, litigation is just a small step to influence public policy and force structural changes. And we have been able to see all of this through Sea-Watch's data. So what we can see in the graphs is that campaigners are turning to the courts more and more. This is evidenced by the rising trend line, the blue one. And from this, we conclude that defendant success is not really dissuading activists from pursuing this avenue. We have actually seen quite the contrary, and is that litigation results in an increase in activity, not only targeting the defendant taken to court, but the sector as a whole, and this usually tends to trickle down to other sectors and therefore to other companies. And if we take another look at the graph, we can also see how campaigning levels showcase activist priorities and where pressure will continue to increase. In this case, we can see how the targeting received by energy, mining, and arms and security are all in an uptick. So the lesson from observing how activists leverage the hard power of courts, and all I have said before, is two key takeaways. The first one is that even if you or your sector or your clients have not really been targeted at courts, you can actually learn from the targeting that other companies have received or other sectors to try and stay away from the spotlight. And the second, and also as a concluding remark, is that litigation is definitely here to stay as a strategy, and we can definitely see that if we take a step back and look at the big picture of the world of campaigning.
Thank you very much.
Any questions?
Comments, concerns?
We have a bit of time for questions, if there are any from the room. If not, I will ask you a question. Can I ask you a question, and maybe this is more from a data mind perspective. But do you and can you measure, monitor activist success? Is your line going down means there is less engagement because everything is fixed, or actually people have given up on the topic?
On the topic of activism, or the topics that
you're monitoring?
on the specific topic? I mean, absolutely. We can measure the success of activism in changing company activity and pressuring regulators. If you look at the text of the CSDDD, there are sections which look like they were directly lifted from activist campaigning materials. And so really that's sort of looking at the regulation and that path. There we can really measure the success, but it's not something that we track concretely in our data. It's something that we look at when we are talking to clients about how activism might impact their business moving forward, and indeed what the regulation that results in might look like.
Thank you. One more question.
Can you say anything about activism within companies? One of the things we often see is that, and I guess this is a bit climate focused because I am, there's a lot of feeling in, let's call it the sort of middle ranks, that there's a climate problem. It doesn't get to the board. So does your data give you any insights on activism within companies?
That's not something that we measure directly, but that is definitely something that we speak to a lot of clients about, actually, because a lot of activist groups are trying to target those people within the middle ranks of companies, because they know that employees are one of a company's most important stakeholders, and they also know that management is sometimes out of touch with employee opinion. And so we are speaking to people about sort of how they can read across from NGO activist sentiment potentially to the sentiment of their employees, and how to respond.
Of course, considering the context and every jurisdiction is super different to each other. So again, what I was saying at the end of the presentation, the good thing about being able to take a step back and look at the bigger picture is that you are also able to check individual jurisdictions and what their priorities are, because what's a priority here in England, for instance, is not a priority in Africa or Latin America or Canada. It really depends. So you are able to go to that particular state of things in that particular context, see what activity has been around there, and then you are able to more specifically be able to see what are the concerns of, for instance, the activists that are within companies.
Yes, so we've got one starting in the insurance industry.
Mm-hmm.
Thank you very much. Thank you very much, David, Catalina. Another round of applause.
Thank you.
So our next session is on potential legal risks from reporting standards. We've mentioned ISSB before, but this is a specific session on the potential legal risks. And we have Melissa Murphy, King's Counsel, joining us today. Melissa is part of London Chambers. She's a barrister specializing in planning and environmental law. And within that, she covers the full range of planning, real estate environmental litigation work, planning appeals, major infrastructure projects, compulsory purchase and compensation, regulatory crime, together with related property, contract, and public law. Thank you, Melissa, for joining us today.
Quite the specialist. It's a real pleasure, actually, to be with you here this afternoon, and so many of you still. Well done. I thought, assumed, rather, in a way, sort of hoped, that half of the people would all leave the room around about lunchtime, but that doesn't seem to have happened at all. So by way of a personal introduction, I'm a planning and environmental law barrister, and I've been in practice for about 23 years, coming up 23 years. And when you're a planning barrister, you're almost inevitably an environmental law barrister, because the cutting edge in terms of public law decisions in your particular field of planning will involve things like environmental impact assessment, habitats, biodiversity, impact on nature, landscape, nuisance, noise, dust, all of the, because planning is really practical. It's about the world we live in, and usually it's about the future. So you get to be quite good at evaluating claims, plans, and programs. So some of you might think that has some resonance with some of the things we're going to be talking about this afternoon. At least, I hope you will. My general thesis for the 20, 25 minutes, whatever we've got together, my thesis is that disclosure standards of the sort we're seeing adopted around the world will give rise to an evidence base for litigation. And as far as constraints or preclusions which are contained within legislation are concerned, or indeed in directives, count me as a skeptic. I am skeptical about the efficacy of any such measures. And the reason that I'm skeptical about constraints and preclusions in relation to civil liability, for example, is because of what I know about the muscularity of the common law. We'll come back to that idea a little bit later on. The menu for this afternoon is a set menu until we come to the Q&A session, where that becomes a little more a la carte. And we will begin with a discussion where I will discuss climate change and the role of standards in the transition to net zero. Then we're going to look a little bit more squarely at risks arising, this is the sort of meat of it really, or for the vegetarians, the tofu, from reporting standards such as the standards I mentioned there, sustainability standards. And then we're going to turn back to planning and development into ESG in that context. It's a sort of plug for those of you for whom it would be relevant. But I'm also going to illustrate a win-win in that context, which I think is really quite interesting for us all to think about and see whether it's portable into your own specialist areas. I've noted with some interest, do you see the graphic which they gave us as speakers to then put out into the linkosphere or whatever you call it? It's a sort of Dante's Inferno, isn't it? And I think for me, it signified wildfires, right? And I thought, well, yes, because I'm in my LinkedIn tiny, weeny group of my mum and my sister and one or two other people in my LinkedIn followers, there's a consensus, and the consensus is that climate change is a really serious issue and we've got to do something about it. But actually, that consensus, to the extent it exists in this country, I don't think this is an echo chamber, actually. You've had quite a disparate range of speakers. It's quite a disparate group, matter of fact, so I don't think it's an echo chamber. I think there is actually broadly a consensus in this country. Not so in other countries. I mean, I was in the States recently for a really, really brilliant conference. This is two. On ESG run by the International Bar Association. Oh my word, it's all too difficult, bureaucratic nonsense. It's woke agenda. You know, people seriously saying, well, why do we need this extra layer of bureaucracy? It's just a cost. Justify the cost to me. How does it help? So it's precarious, this consensus. So we should nurture it, value it, we should foster it. We should look for win-wins, actually, with corporate clients and the sort of world at large, because a backlash is all too possible. And of course, because rules reflect society, you then will start to see slippage, I think. So it's really, just wanted to say that just because I've got the opportunity, really. It's not a legal point, it's just a cri de coeur. We need to live, don't we, more sustainable, more sustainably, because you can't have your cake and eat it. And yet, this is, in my view, and not just my view, but also Jeff Twentyman from Slaughter and May, who's now not here, so I can say what I want about him. But his view was that there's a sort of policy failure, and I couldn't agree more. Here I thought, crikey, it's amazing to hear you see that, but brilliant that you are. Because what's happening here is that the government's committed, as we'll see in a moment, I'm going to put up a slide about the Climate Change Act, committed to orderly transition to net zero. And we say, oh, that's excellent. OK, could we have just a look at the regulations so that we can see what we're going to be allowed to do or not allowed to do? And we'll base all our investment decisions on that. Oh, no. No. We're not going to give you that. But what we will ask you to do is disclose your plans for how you are planning an orderly transition to net zero. Sorry, but quite a large parts of our economy are fossil fuel-based. We're quite heavily carbon dependent at the moment. Oh, yes, but you tell us, corporates, you tell us, economy, how you are planning to reach an orderly transition to net zero and still make a profit and still fulfill your duties. So part of all of this, actually, is government having its cake and eating it, and not just this government, but international governments too. So when I see a sort of nonsense at the heart of all of this, I think, in a way, like a parasite, oh goody, that's going to lead to a lot of litigation. Some of this does get actually on topic and more serious, honestly. But the serious point here is that absent major technological change, we are in, aren't we? We're in for a rough ride. We're going to see some really significant change in the way in which we do business, the way in which we live, and people are not going to like it. But we do have to live more sustainably. And I thought, well, since I'm going to be making a few mentions of sustainable, I'm going to just put up what do we mean by that? It means meeting the needs of the present without compromising the ability of future generations to meet their own needs. That's what we mean by it. And there are, happily, it's not all bad and terrible and gloomy, there are bits of the economy where this isn't new news. So for the planning system in England and Wales, which is my happy place, national policy, which is of universal application, says that the very point of the planning system is to deliver sustainable development, which should tell you a little bit about where, if you've got lots of green capital, you should be applying it, which is a matter of interest. And so that's gone right into a sector of the economy where we're looking, in each planning decision that you're making, you're looking at the social, environmental and economic implications of your decision. This is national planning policy guidance. So in every decision that you're taking, as a decision maker in planning, these are factors which you are taking into account. So we're going right down into the weeds of one sector of the economy, and we're finding something good there. We'll come back to the planning system a bit later on. But we've zeroed in on that. Let's go back out and look at the overall objectives. So we've got the Climate Change Act there, as you can see, the target for 2050, the Secretary of State's duty. And what the Climate Change Act then requires is for the government to be setting legally binding carbon budgets to act as stepping stones towards the 2050 target. Carbon budgets are cap, emitted over a period, and the budgets are intended to be set in advance. Okay, so that, we know that that's the legislative objective, and of course I can make no apology for speaking only about England and Wales. I'm a barrister in England and Wales, so I'll be focusing on England and Wales. So what's the plan? Well, the plan rather depends on which department you're looking at. You know, you've got some decisions where you're allowing renewables, planning permission, development consent, for example, for renewable schemes, and others where you're saying you've got to budget so as to hit net zero. So you do seem to have pulling in different directions, and this is particularly complex and vexed then when you come to what companies going back in at the micro level ought to be doing. So how does reporting fit into all of this? Well, okay, wind back 8 years, and we've got the Financial Stability Board and a task force, and we've already had, I think, mention made of the task force and their advice on financial disclosures. And you can see that the purpose of all of that, I've set it up on the slide, to develop climate-related disclosures that could promote more informed investment, creditor lending and insurance underwriting decisions, and in turn would enable stakeholders to understand better the concentration of carbon-related assets in the financial sector and their exposure. So you can start. So that was the underlying purpose of all of these then developed requirements in the UK. What's the rationale for it? Well, you can see that all of the starting bit up here, right until we get to the bottom bullet point, is all rather solipsistic. Do you know what I mean by that? Companies focusing in on themselves as if there's nothing else outside them. Or one might call that single materiality. It's only until we get to the bottom bullet point, impact on resources and other relationships, we start to look out at double materiality. Do you know what I mean by that? I've got some people who look entirely as if they understand that, other people who look as if that's a completely foreign concept. Okay, most of you got that. Okay, so it's only there that we start to look at the, if you like, outward impact. And then we have published, last year as you'll come to see, the International Sustainability Standards Board standards, a wholly different set of standards. Quick, let's capture them before things move on again, because if there's one thing that is consistent, it is that things keep changing in our world, and that is absolutely true in relation to disclosure. The question of interoperability, well, that's another matter again. And I can tell you that that is something particularly vexed, of course, for your multinational clients. But these standards, the International Sustainability Standards Board standards, published in June of last year, you've got two bits, essentially, two statements that you need to have regard to. The general requirements, the S1 requirements, and then the climate-related disclosures, the S2 requirements. Now, these are international standards, but they are not, at the moment, if you like, applicable in this country. I was asked to talk about them, and it's important that we know about them, because this is, if you like, the next moving target against which you are going to be setting your bow and arrow. And what's the plan? Well, there's a consultation, which I think closed recently, about adopting these standards in the UK. And so you've had consultation responses from lots of different stakeholders, different stakeholders, including investors. And investors seem, I'd say, I had a look at quite a number of the consultation responses, because I thought it was really interesting, actually, to see, are these welcome? Do people hate them? Do they think they're silly? What do people think about them? And there's great concern about the single materiality aspect of them. But in general, the idea of having interoperable international standards is welcome, because if you're a multinational company, it makes things simpler, doesn't it, to have to play by one set of rules. Consistent, comparable, reliable information from companies on social or environmental issues which are financially material to their businesses. We rely on information in relation to current performance, as well as information on drivers of value that may be predictive of its long-term performance. So this helps us reach our investment decisions. Well, one thing we know for sure is that that is, if it's then material to value, that will then be taken into account by investors. So what are the potential legal risks arising from reporting standards? And we come here from the appetizer into the main course. And actually, Kate, Dr. Kate, you mentioned the snapshot, didn't you, from the LSE 2023. This is it. So I thought it's as if the speakers have coordinated between us, and as if by magic we put it then up on the board. And what you can see, you're not here looking at developments or themes. What you're looking at is simply a snapshot, a cumulative snapshot. And the short point is the darker the colour, the more the cases. And you can see then actually a huge jump in the numbers from a sort of lighter blue to a darker blue. Huge jump in the numbers. And this reflects, in fact, it looks to me like regulatory activity, actually, for example, in the States, where you see an awful lot of state and cases where greenwashing is said to have taken place in some very active states. So that's, but what's very interesting, of course, is that this is, this isn't niche. For litigators, for those professional advocates like you and I, this isn't a niche area. This is an area where litigation is prevalent. This isn't a sort of dim and distant prospect for companies or governments. This is mainstream. And yet, if somebody tells you that they are an expert in climate change litigation or ESG, and I said this to somebody else before the break, that is a really good indicator that you should be sceptical of them, because nobody is a specialist in climate change litigation and ESG. There's no such thing. The reason that there's no such thing is because this is an inherently creative process. What you're looking for is to identify potential causes of action. You're looking to operate on the boundaries of the law and to push it or pull it back, depending on whose client who's your client. You're operating at the very cutting edge. Well, you're operating at the cutting edge. Obviously, you need a nice sharp tool, but you won't necessarily be able to identify the specialist subject area where this is going to come from. What you need are people who've got really good understanding, really good overview of our common law system and any applicable statutory material. And actually, of all of the areas in which litigation might arise, black letter law, statutory law, is kind of hardest because the courts are more constrained. You get a nice common law jurisdiction, and well, it's a question of interpreting the cases. What's the ratio? Where's the dicta? Can we apply this case in this context? Was it wrong? Was the previous decision wrong? Are we prepared to stick our necks out on that subject? So it's a really, really interesting creative process. But from the perspective of somebody who might receive a claim, from a governmental perspective or from a corporate perspective, it's a bit like whack-a-mole, right? Because you're looking to identify where are the risks coming from. Well, you don't know, because if your artsy friends are telling you that being a lawyer is not creative, it's simply not right. Working out where the causes of action are, working out where among the weeds of disclosure you're going to find a nugget of something useful, that's a creative process. It's a careful process, methodical process. It's really hard work, and some of it's really dull. There's no shortcuts, you've just got to read it all. But ultimately, you're working out how you can come up. So you say, come and speak to us on litigation risk arising from disclosure. All right, well, I'll stick my thinking cap on and be creative. And I've come up with some. I think you'll come up with some too. And that's where we need to be advising our clients. It's not certain, because we may not have come up with the great idea that might get traction in court with a good creative common law judge. So all of those qualifications and excuses and so on given in advance, then let's get into it. Well, let's start with this, at the outset. Where's the beginning risk? Well, as soon as you say you're going to adopt a particular set of standards, you've got a public law risk, haven't you? Because you've got to select the particular standard. So, the UK said at the moment, well, our intention is to adopt the ISSB standards with as little change as possible, taking into account UK particular circumstances. Well, that's interesting. I mean, our first port of call is going to be, let's play spot the difference between what the UK's adopted and what the ISSB standards are, and see if it matters, see if we care. The other possibility is that you might look at what's the objective of this, because of course it's not adopted and they've got a choice about how to adopt it. What's the difference between the adopted standards and EU standards? How are these regimes going to relate to one another? For example, does one include double materiality and other single materiality? And do we care? Does it matter? And what margin of appreciation does a government have in this context? And what leverage do we have? I put the Climate Change Act up already. Planet Earth had a measure of success already in relation to holding government to account in terms of progress towards its commitments. So you have some leverage there. In the Heathrow litigation at Court of Appeal stage, certainly, the Paris Agreement itself was a material consideration which should have been taken into account by the Secretary of State in deciding whether or not to identify Heathrow. So, not to get into too much in the detail of that, but the point is that you've got a standard against which to hold government action. So, public law challenge, simply to the standards themselves. And actually, matter of fact, I think somebody mentioned it already, but you've already got, reflecting the backlash in the States, the SEC disclosure requirements, they're already the subject of litigation. But my understanding is it's litigation the other way. It's that they're not onerous enough. Or no, rather, they're too onerous. Sorry. One could get confused in this fetid, hot legal context. The next, then, is assume you've got your adopted standards. What about when you take a decision where you've got an approval of them? Now, I'm going to just use the example. It's not on point because, of course, we're talking about standards which aren't enforced yet. But the Client Earth and the FCA litigation, you will or may remember that this is to do with the Ithaca proposal, prospectus. Now, you had Mrs. Justice Lang made that decision. It was a permission case. Now, one of the interesting things about Mrs. Justice Lang is she's a planning judge. Planning judge sits in the planning court, and she's applying. When I look at that permission decision, I think, oh, that's interesting. She's applying pretty orthodox public law planning principles to that permission decision. Her perspective on things was that when a decision maker decides that there's a sufficiency of information about something, that's something that the court should be loath, really, to interfere with, that the administrative supervision should extend only to whether the decision is a rational one. You see, it's interesting, this. It's not the question of sufficiency of information there. It's not a hard-edged one. You know, the court decides, is this sufficient information or not? Instead, was it a rational decision for the decision maker to have come to that the information was sufficient? They're quite different. I mean, I might have argued, I might have had a pop at arguing that there's a second limb of Wensbury, which is if you reach conclusions, question whether what evidence are they based on. So there might be a little bit of, anyway, wiggle room in that. But anyway, we're all critics, you know, crikey, after the event, aren't we? And in any event, actually, it's interesting when you know your decision makers by, you know, black letter law, actually, not that. Probably a luckier draw, to be fair. Not to bring the judicial system into disrepute, but there are others who would have been more interested in that challenge, I think. But that's only an example. It's just an example of where you've got a justiciable decision to approve something, bearing in mind the particular regime concerned. I mean, here, what we're talking about at the moment is disclosure where there's no settled approval mechanism. And actually, I agree with you, Kate. I think that even though we haven't yet got any sort of approval mechanism settled at the moment, even once that's that happens, we may have a transition period. There may then, in fact, be an enforcement lag. So I agree with you. And so this is a sort of potentially a sort of longer-term question. And also, I was very interested in the kind of mini-debate. Is this a bit too inward-focused? But for lawyers, maybe it is. But there was sort of mini-debate about the appetite for the judiciary in England and Wales to evolve the law in this context. Well, there's probably as many views about that as there are judges about judges. And the views probably differ as between particular judges, don't they? But the people that I had in mind include Julian Knowles, who gave a talk to the Chancery Bar Association. And when he was talking to them, he certainly gave, I would say, quite a lot of encouragement to the view that there would be some sympathy within the courts of England and Wales where there's proper scope to be entertaining climate change litigation. It's an important qualifier, of course. And of course, then you've got retired judges like Robert Carnworth, who's quite happy to then fire at will. As Paul, as you noted with some glee, I think. Yeah. But put the man aside, the ball, what he said was very interesting, wasn't it? And I think more on that anon, more anon. And so what then about sort of inter partes litigation? Well, you know, concentrating on climate change stuff, I think, sensibly, given that I'm nearly out of time, I know we started, I'm going to give myself 5 minutes maybe. Yes, I mean, look at what the standard is requiring in general terms, and then think about the specifics. So look at these. I've given you just a couple of examples of disclosure requirements. First, your greenhouse gas emissions. So claimants not now operating in a sort of mysterious world in which they think they understand what the greenhouse gas emissions of an entity might be. No, instead, you've got the data. We understand what the effect of your company is because you've told us. Thanks very much indeed. It doesn't need to be fraudulent. It doesn't need to be misleading or misrepresentation. It can be accurate. And yet, in my view, still capable of contributing to a case where you're alleging harm and damage. Climate-related targets too. What are you planning to do as an entity? What are you planning to do for your orderly transition to net zero? Well, is it good enough? There's a court of public opinion, as well as everything else. And so that too is highly noteworthy, in my view. So what about candidate actions? Candidate actions potentially inter partes. Well, it won't surprise you to learn, bearing in mind my general theme, which is that of these two pillars of the system in this country of England and Wales, statute, common law, growing up side by side, I think the common law, you know, on one view, offers more scope. And so you can see that I've given, well, tort claims. I've mentioned the Smith and Fonterra, rather tantalising New Zealand case. It's tantalising because it's only about a strikeout application. Rather wonderfully, the court simply preferred for any evolution in the common law to take place in the fertile fields of trial rather than the barren rocks of a strikeout application. So I love how whimsical that was. But the point being that it's not beyond the realms of possibility that you will see the evolution of tort law. And so, in order to for Smith and others to secure the relief they were looking for, which was declaratory relief and or injunction. So tort claims. What about actions in nuisance? The Shoalwater Bay case is about essentially the interference with the reasonable user of land. You can see that provided you've got your evidence base about what a company's actual activities actually are and the effect of it, that's partly evidence for the, in part, their culpability, I suppose, in an action against them, where you can demonstrate harm and or loss. And now, the final bullet point on this, now you're not even just a common lawyer, you're a civil fraud practitioner. You're into fraud and asset tracing, and your professional services, forensic accountant type people are looking at loss. So, you know, here we're bringing in all sorts of other, potentially other professional services, aren't we? Whether along the lines of that Ramirez case or not. Ramirez was actually, interestingly, the lead, is Bob the lead man still here? But I was interested in that because that was a whistleblower case. That was where somebody said, well, actually, it appears that Exxon are pricing their carbon proxies externally differently to the way they were pricing them internally. Is something appears to be wrong with this picture? Could we? And so there's then, you know, there's a case which has been tied up very successfully in the States for many years in various sort of procedural wrangles. But you can, so again, you can see a completely different way of thinking about cases, not outside the company law context, where there's clear scope for litigation, I would suggest. Coming to the end. And back into the more positive, perhaps, area of the development industry and sustainability and ESG, or possibly, you might say, rather a plug. And certainly pulling a plug on this section of the talk. The real advantage of the development industry in the UK, which is something that obviously I've spent a lot of my career dealing with, is that you've got a highly regulated context for environmental assessment. And so people who've been operating within the planning arena will have experience of interrogating and evaluating claims and evidence in relation to environmental impact. And also, from an investment perspective, what you do within a planning case is you're identifying whether it should get development consent for something that's happening in the future. The project is described. If it promises benefits of a social or environmental or an economic sort, like affordable housing or a heritage benefit or education contributions, those are secured by means of a binding agreement, so you know what you're getting. And also, importantly, it's a physical asset capable of monitoring and management. So unlike other less tangible assets, there is a security in that. And interestingly, the more sustainable the project, all other things being equal, the lower the risk that you face through the development process. So in other words, you're more likely to get planning consent, all other things being equal, for a more sustainable project. So you de-risk your planning process by delivering sustainable development. I call that a win-win, and I find that very interesting and actually quite a kind of cool part of my job, that if I can help explain that and that penny then drops, then we deliver things which are actually better. So, all right, I'm a little over time. That was the pudding. Now, if there's any questions, I'm very happy to take them now, or obviously during the coffee. I'll stay around for the coffee break if that's.
Any questions?
Go for it, Paul.
One question.
I don't know if this is on. It is.
All right.
I enjoyed that. It's not so much a question as much as an observation, which is that I agree with your comment around climate litigation not being, in any orthodox way, an area of law.
Yes.
Different areas of law upon which to draw. And the observation is that I think there is a trend throughout a lot of what you were very eloquently saying there, which is that increasingly you see different areas of law being used to then inform and imbue other areas of law. So we've seen that in the Milieu de Foncy litigation, one of the most successful piece of corporate climate litigation, where human rights was used very successfully, soft and hard business and human rights law. We see it increasingly with public law notions, as you rightly identified, coming into corporate litigation cases. There was an interesting legal nuance of our litigation against the Board of Shell, to the extent, for the lawyers in the room, to what extent can irrationality form constitute a breach of Section 172, sort of Wensbury unreasonableness test, coming in from public law to corporate law directors' duties. And as you rightly said, Ms. Justice Lang's decision on our FCA
She wasn't having it. She wasn't having it, was she?
She wasn't having it. But that was, as you rightly said, quite public law focused, or coming at it from a public law angle. So that's quite an interesting trend, I think.
I think it is, and I think it poses a real challenge for lawyers, because over the course of my career, it's been, you know, it really is the done thing to specialise. And yet in this particular context, being a specialist is actually incredibly unhelpful, because it means you're sort of stuck in your silo, you don't see the opportunities. So what you want, you know, I mean, maybe it's an argument in favour of collaboration, actually, rather than just use, you know, use one person, use bigger teams who are have got greater diversity, not just in terms of the people in them, but also in terms of their expertise, which I think is kind of fun anyway, actually, because seeing how other people, how other people think about the same issue I just think is absolutely fascinating, because you've got a lot of insight yourself, but then so you're not kind of blank canvas just learning. You're sparking off one another. So I think that could be, yeah, it can be really fun. I mean, I think the thing is that all of this though is a bit scary for those who are actually disclosing the material, because predicting where the challenges are going to come from requires you to be sort of psychic, and that's obviously quite difficult. But unless there's any other questions or comments, particularly ones which say that I'm eloquent in some way. Any criticisms in writing, please, and will be addressed to the management. Thank you.
Thank you very much, Marisa. Well, after having the set menu and a bit of the a la carte menu, let's have the coffee and tea menu for the next 20 minutes. So let's be back at 35 minutes past. Thank you very much. And please don't forget about the questionnaire. There is a bottle
Everyone, welcome back for the last two sessions of the day. Thank you very much for bearing with us throughout the day. Thanks again for the virtual audience for being patient with us. So two last sessions for the rest of the day, but nevertheless very exciting and very interesting. One of them is very much building on one of the first sessions that we started with Anna Carolina, who was speaking about cost theorem and the fact that there are no transaction costs under an ideal scenario. However, we very much know that there are, and for this we will invite for a session on the rise of litigation funding for environmental damage and climate-related claims, Stephen Friel, who is the Chief Executive of Woodsford. Stephen is a lawyer by background and the CEO of Woodsford, who is a collective redress business. Stephen focuses on situations where multiple parties, often shareholders or consumers, suffer financial loss and following breakdowns in ESG, particularly in corporate governance at major companies. Stephen, thank you very much for joining us today.
Thank you. So thank you for the kind introduction. So to repeat, my name is Stephen Friel. I'm the CEO of Woodsford. And we're described as a collective redress business. And so a lot of people say, well, what does that really mean? Well, we're involved in situations where large groups of people, shareholders, consumers, retailers, communities, are affected by wrongdoing by usually major corporates. And we help them with two main things. The first is our engagement solution. We help identify the wrongdoing and the loss in the first place, bring it to the attention of the affected people, help them come together, collect them together to engage with the wrongdoer, and if necessary, help them litigate by finding the right counsel and the right jurisdiction to litigate against the wrongdoer. And the second way we assist our clients is through financial solutions. Litigation is expensive, as we're going to discuss, and so we provide financial solutions, in short, litigation funding. And so it's the litigation funding of climate litigation in particular that I'm going to discuss today. So a bit of a disclosure first. I'm an environmentally friendly speaker, and I've recycled some of my materials, and I see some people in the audience today from an event where some of the material comes from, so disclosure there. In preparing for today, I have drawn from work that I prepared in advance of a conference at the end of last year at the law faculty at Oxford University, and for this subsequent report that was published earlier this month for that event. The topic of that conference was Climate Litigation in Europe Unleashed, Catalysing Action Against States and Corporations. And I would encourage you to read the report of that. You can find it on the website of the Oxford Law Faculty or email me afterwards, and I'd be happy to send you a copy. So in short, let's get into the litigation funding of climate cases. Most types of litigation, whatever they are, take longer, cost more, and drain more resources than any of the parties to the litigation envisaged before they embarked on the litigation process. And litigation that seeks to change laws or policies that impact the lives of many people, often far beyond the direct parties to the litigation, what you might call impact litigation, is particularly likely to be very expensive. Defendants whose actions are likely to have the ability to affect large groups of people are by definition likely to be very well-resourced defendants and highly motivated by profit or by politics to defend any action brought against them. And as well as being legally complex, climate-related litigation is likely to depend on sophisticated expert evidence, scientific, technical, which again is very expensive. Impact litigations are likely to take longer, have multiple layers of appeal, including on interim and preliminary issues, and have cross-border elements that bring costs. Conflicts of laws, private international and public international law, as well as language issues, translation costs and so on, and even the travel expenses of cross-border litigation. So somebody has to pay for this, right? And questions that are increasingly being asked by defendants, judges, policymakers and the press include who pays for all of this, why do they pay for it, what do they get out of it, and what issues are cause for the procedure and substance of the litigation by the sources of funding. So let's look first at who is funding climate litigation. I'm aware of no authoritative research or statistics on how large numbers of climate litigation is funded. And so I've done my best to guesstimate based on public sources. I've used the two main climate litigation databases for this. I think they've been mentioned earlier today. The first is the Sabin Center for Climate Change Law at Columbia Law School in New York, has a database that includes around 2,000 US litigations and between 1,000 and 2,000 non-US litigations. And I've also looked at the Climate Change Laws of the World database maintained by the Grantham Research Institute at the London School of Economics. And so what a review of those databases tell me are that the largest category of litigants by far, particularly on defendant side, are state or corporate entities, major corporate entities, and they'll have their own significant sources of funding. So for corporate litigants, climate change litigation will usually be defended, sometimes positively pursued, for profit motives. A lot of such litigation will relate to the corporate being sued under or pushing back against environmental regulations and legislation that seek to restrict their activities. For state litigants, climate change is often pursued for political and policy reasons. And the reasons for litigating and the funds available to state entities for doing so will therefore depend largely on the political inclinations of the relevant administration. And that changes dramatically depending on which jurisdiction you're in, even which local jurisdiction you're in. By volume of litigation, the next category of litigants are the NGOs and the charities, and they are usually funded in two main ways. First, many lawyers, legal academics, other professionals provide their time on a pro bono basis, and that's a significant form of funding for these cases. Second, financial donations are often a combination of large amounts of small donations, essentially crowdfunding, and a small amount of large donations, often from philanthropic foundations backed by super wealthy families. So some examples from the public domain, looking first at the type of crowdfunding approach to funding climate-related litigation. In the English litigation, McGahey and Davies versus USS, the claimants were members of an occupational pension scheme, and among other claims, they brought a common law derivative claim against the scheme's directors for breach of their duties in continuing to invest in fossil fuels with no divestment plan, despite a stated ambition to be carbon neutral by 2050. And if you have a look at the crowdfunding website for that litigation, you'll see that as at the end of last year, when the case was settled following a defeat in court, they had raised £473,000 from 12,000 contributors, an average donation of around £40. Another example, the Urgenda Foundation litigation in the Netherlands. It resulted in December 2019 with an order of the Dutch Supreme Court that the Dutch government must reduce emissions immediately in line with its human rights obligations. If you look at the Foundation's website there, it explains that the litigation was possible to donations from all around the world. And if you want to donate more than €57 and you'd like to engage in some virtue signalling when you're on your summer holiday, your donation could result in you being sent a nice beach towel, letting people know that you'd made a donation to that particular litigation. One of the things that strikes me when I look at a lot of the crowdfunding websites for the various litigations around there is I'm a relatively sophisticated observer of litigation. It's my profession. I'm also a sophisticated understanding of how these claims are financed. I'm a litigation funder. And I found a lot of these websites quite opaque about funding structures, quite opaque about what the objectives of the litigation were, what the money was going to be used for, what success looked like. And I think there's room for improvement there. Turning now to the small amount of large donations, and I think that's where we're going to see a real fight over the next 5 years. relating to the money coming from super wealthy families, philanthropic foundations into climate litigation. And so again, I'll give a couple of examples there before looking at some of the legal and political issues associated with them. In October 2021, 2 First Nations leaders from remote islands in Zendath Kes, also known as the Torres Strait in Australia, filed a legal action against the Australian government to challenge its inaction on climate change mitigation. And it was supported by the Grata Fund. It's interesting to look at who the Grata Fund are. They describe themselves as Australia's first specialist non-profit strategic litigation incubator and funder, almost like a non-profit or third sector version of what my business does, I'd say. Grata develops, funds and builds sophisticated campaign architecture around high-impact strategic litigation brought by peoples and communities in Australia. They say that they focus on communities, cases and campaigns that have the potential to break systemic gridlock across human rights, climate action and democratic freedoms. If we look at another example, quite a big case, in May 2018, 10 families, including children, filed a climate change case in the EU General Court against the EU Parliament and Council. The families from Portugal, Germany, France, Italy, Romania, across the European Union, claimed that the EU's 2030 climate target is insufficient to prevent dangerous climate change or to protect the fundamental rights of the claimants to health, occupation and property. If you do a bit of investigation, you'll see that the money behind that includes Bloomberg Philanthropies, Michael Bloomberg's foundation, the former mayor of New York and the man behind the Bloomberg Financial Services Company, and the Laudes Foundation, founded by the Brinkenmeyer family, and also another philanthropic family, the John and Marcy McCall McBean, who I think were behind the Auto Trader magazine. And you see that a lot in some of these more high-profile litigations that are referred to. You have these very wealthy families behind them. So it's clear that we do have the philanthropists in this space. But what about commercial litigation funding? What about businesses like mine? Well, listen, while there are some variations on what commercial litigation funders do on their business models and so on, in essence, what commercial litigation funders look for are cases where there is a reasonable degree of certainty of a positive outcome, and that positive outcome will lead to a significant financial payment from the defendant to the claimants in which the litigation funder can share. It's essentially a contingent revenue model. And so just from that very simple definition of what commercial litigation funding is, you'll see that there are at least 2 major obstacles to commercial litigation funders being involved in climate litigation. So the first is that we must have at least a reasonable degree of certainty on outcome. If you backed a lot of speculative cases, you'd soon run out of business. Businesses like mine in our commercial business, we generally have an 80 to 90% plus success rate on the cases that we back. We look for relatively highly certain cases. And often climate litigation doesn't quite get there with the certainty that is required. Not only are you dealing with very novel legal points, in short, going to whether the defendant owes the duties and has breached the duties alleged by the claimants, but you also, as I said earlier, are often dealing with cases with very uncertain legal, scientific and expert issues that are very difficult to underwrite as a commercial party at the outset. The second hurdle that commercial litigation funders may find it difficult to get over in the climate litigation space is that the need for there to be damages, a transfer of value from the defendant to the claimant in which the litigation funder can share. And often, particularly the big high-profile climate litigation is not about seeking damages, recovery of financial loss from the defendant for historic losses, but is instead about seeking only or largely to change behaviour going forward. And laudable though that is, and supportive though that is, that businesses like mine are, particularly on our philanthropic side, it's difficult to make a commercial case if in fact there isn't a large transfer of value in those cases. And actually, what's been interesting in my journey into the climate side of litigation and litigation funding is that I see a resistance by a lot of the traditional originators and incubators of climate litigation to consider cases where there might be damages and compensation that would make them attractive for commercial litigation funding. I think that there's a philosophical barrier that a lot of the current originators and incubators of climate litigation just aren't able to get over, that stop them from looking for cases that might have damages, and for cases that might have damages, to make that a central part of the litigation strategy. And I think if there is to be more of a commercial side of climate litigation funding, there's going to have to be more of a meeting of minds between the very important NGOs and originators and incubators of these very innovative legal strategies and the commercial side of it, the damages side of it. So for those hurdles are, I think, the primary reasons why there has been relatively little movement by the world's major litigation funders into climate-related litigation to date. I think what we've seen is that a number of the big-name litigation funders out there, including my business Woodsford, on our philanthropic side, in the donations that we make and in the pro bono work that we do, we support these cases. But none of us have yet gone large on climate-related litigation. The magic sauce isn't there yet. The closest examples to date have been the relatively small number of commercially funded litigations that followed from environmental disasters and pollution cases. There have been a number relating to oil spills, particularly that affected impoverished nations, and also the Mariana Dam disaster. I wasn't here for the keynote address this morning, but I understand that the Pogus Goodhead law firm were discussing their Mariana Dam case. And as I understand it, that's backed by a major investment manager based out of the US on a commercial litigation funded basis. But those type of mammoth cases that are appropriate for litigation funding to date are, I think, few and far between. So given that, where then do I see the opportunity in the future for commercial litigation funders in climate-related cases? And in short, I think that is going to be in the greenwashing space. What I mean by that is as simple as claims brought by investors or consumers against the big companies that overpromise and underdeliver on climate-related issues. We're already significantly working at my business on the S and G of ESG, helping major institutional investors into listed companies collect together, organize, and bring claims, bring litigations against defendants that have caused a loss to shareholder value from breakdowns in corporate governance and social issues. So the type of cases that we have been doing to date that haven't yet got to the E include, for example, money laundering or terrorist financing at banks, slave labour in supply chains at manufacturers and retail businesses, bribery and corruption that affects democratic states. But we are hyper alert to the potential for environmental cases. And so I won't talk about the confidential matters that are in our pipeline, but I'll give you three areas that we're actively pursuing, and I think that some of the more alert of you will recognize the situations that I'm talking about. The first, a listed company, let's say it's a FTSE 100 energy company, is investigated and subject to a potentially material financial penalty by one of its regulators in a major jurisdiction. Let's say it's the New York Attorney General, who is alleging that that energy company has been engaged in misrepresentations and non-disclosures relevant to greenwashing issues. In particular, what it's announced to the market, to its investors and to others about the balance of its investment between dirty coal on the one hand and clean energy on the other hand isn't quite right. And so when this investigation comes to light, there's a material decline in the share price of the company. The investors in that company, my pension funds, have suffered a loss to shareholder value. And so I see that squarely as a greenwashing climate-related case that businesses like ours will be involved in very soon. We will be watching for these greenwashing, we'll be watching for the financial loss that they cause investors, and then when we identify it, we will go to the investors, collect them together. That's the engagement part of what we will do. And then if litigation is necessary for accountability and compensation of the wrongdoers, we will provide the litigation funding and the other financial solutions, including the adverse cost coverage for that litigation. Another example that I'll use, an investment manager sells a retail investment product that is branded and described as an ESG product. And so when I'm putting together my SIP or my ISA, I see this ESG branded investment product and say, you know what, I'm a good guy, I'll buy that. But after I've bought it, two things come to light. The first is, turns out it wasn't as ESG as compliant as the market materials provided. It's invested in oil, coal, Russia, non-ESG compliant investment areas. And then second, this goes to the damages part of what I was talking about. We'll be looking for those investment products which have performed less well than their peer investment products have performed. Certainly if they've suffered a loss or they've suffered less, or if they've performed less well than similar peer products that didn't suffer from these misrepresentations. And so we're actively monitoring quite a number of funds that have gone out there and branded themselves as ESG. We're watching their financial performance. And we will soon be in a situation where we will be collecting together the investors who invested in that product. And because those two elements exist, there will have been a misrepresentation about how ESG compliant it was, and there will have been a loss. Our investors will be able to say, our claimants will be able to say, if I'd known that you weren't ESG compliant, I wouldn't have bought your product. I would have put it in this other investment vehicle, which is a peer product, and it performed better, so I require you to pay me the difference. That's the compensation that we will seek. I'll quickly give a third example of what we're looking at. We see this a lot. Companies who sell products with carbon offset associated with it. The big one is in the airlines industry, where you can pay more for your airline seat if you want the flight, the carbon footprint of the flight to be offset. We're looking very clear in depth at whether, in fact, those carbon offset products do what they say they do. Our suspicion is that a number of those carbon offset products are completely illusory. There's no carbon offset at all. Or the airline has, in fact, invested in some sort of carbon offset initiative, but the carbon offset advantages are nowhere as close to what they market it as. And there you have a very clear financial loss. If I could have paid €100 for my flight to Amsterdam, but I paid €120 with carbon offset, I want my €20 back if I didn't get the carbon offset I've paid for. And again, I think you're going to see businesses like mine collect the people together and fund their litigations. So there are a number of legal issues associated with litigation funding of any type, and I think we see them in climate litigation funding in particular. The first is who controls the litigation. The English common law has traditionally been very antagonistic to the idea that somebody funds a third party's litigation. And one of the reasons that there's been this historic resistance to it is the fear that the third party, who has no pre-existing connection with the litigation, would control it. The historic legal doctrines there are champerty and maintenance. And whilst those have been reduced in legal significance, they are still something one watches out for. Closely related to that is lawyer ethics. There's a fear that he who pays the piper plays the tune. And most jurisdictions around the world have some sense of, even though you're funding the litigation, you shouldn't control the lawyers. That's the client. They should be given their instructions to the lawyers. And so lawyer ethics. Disclosure is another legal area that is litigated. When a litigation funder invests in a case, they often want to know the legal advice and other privileged information related to the case. And it becomes relevant to ask whether the sharing of information with a litigation funder has led to a disclosure, a waiver of the privilege in that information. There are other legal issues, including relating to adverse costs and security for costs, but in the short time available to me, I'll quickly turn to some of the political issues associated with litigation funding of climate-related cases. I think in the UK jurisdiction, we've had an interesting ride over the last 9 years in the only class action regime we have in this country, in the Competition Appeal Tribunal. This was a competition class action regime that was set up about 10 years ago, and from the outset it was accepted that it could only exist and thrive if there was litigation funding. And yet we have somehow, through our bad legislation and slow processes, allowed defendants to spend the last 9 years stopping any of the cases getting to resolution, in large part because they are attacking the litigation funding. And we see that a lot now across the world, that defendants who want to put off their day of reckoning when they will actually have to have the substantive litigation resolved in court, they spend more time actually arguing about the claimant's source of funding and slow down and bog down the case on that. And so I think it's very important for those of us involved in climate litigation and the funding thereof to keep an eye on what the politicians are saying about this. And there are a couple of quotes that I'm going to read out in almost verbatim, because they say, they give the two sides of the spectrum better than I could. They come from the US House of Representatives Oversight Committee that met at the end of last year to discuss this very topic on climate litigation funding. And unsurprisingly, in our polarised political world, we had a red Republican from Kentucky on one side and a blue Democrat on the other side. So James Comer, the Republican from Kentucky, said this. He said, "There are some concerning trends in how litigation is funded. The spread of untraceable and undisclosed funding of lawsuits across the country, raising significant ethical and legal questions. For example, many lawsuits are funded by progressive activists seeking to hijack America's legal system to implement their policy desires. Lawsuits that impact the mining of critical minerals, energy production, international security. The lawsuits raise concerns about attorneys' ethical duties. They raise concerns about whether attorneys are acting in the best interests of their clients or those from whom they receive funding. We know that activist groups use funding to push policies that they could not enact through the legislation process. Some left-wing groups funnel millions to law firms to sue companies across the world on questionable legal grounds, and it goes on. And so you'll see one side of the political spectrum identifying that a source of funding for a lot of these cases are these wealthy philanthropic families who perhaps are using litigation as a proxy for legislative reform. On the other side, you have the Maryland Democrat, Jamie Raskin, say, "The Republican Party has gone on a surprising and bizarre tangent. The problem, they say, is not the way the public is harmed when billionaires bankroll the private lives of ethically challenged Supreme Court justices. The real problem is that giant corporations are harmed when Americans injured by toxic torts or environmental crimes receive contributions from donors to help them bring personal injury or class action lawsuits. In other words, while Supreme Court justices are jetting all over the world on fancy private vacations paid for by the right wing, the GOP says the real problem in our legal system is that too many victims of corporate wrongdoing are finding access to the courts in the first place." So there you have it, the political spectrum there and then has set out, and I think it sets the likely legal landscape for the next 5 years on climate litigation funding. So I'll stop there. Welcome to take any questions or comments.
Thank you very much. One question? I have time for one. Go ahead, if you feel.
Thanks, Stephen. That was really interesting. An observation followed by a question this time. The observation is I don't think it's quite right necessarily to say that all NGO inoculators and originators of climate litigation have a principled objection to damages claims. I think it's certainly right to say that those who have suffered most from harms committed by corporates or indeed other parties have a right to financial redress, and certainly litigation funding can be a tool to open up that redress for them. And the question that follows is, and I think you touched on it rather nicely, but I'd be interested to hear a little bit more, is to what extent you or other litigation funders would see a role almost sort of building the field, if you like, because I think it's right to say that there's no silver bullet in terms of the types of damages claims that you're talking about, although the potential exposure is immense. And I wondered to what extent you might consider funding, not I should add with any direct view to a claim that I have in mind, but more broadly, in terms of building the field of a certain type of litigation, is that something that you would consider?
Yeah, absolutely. So I think what my business in particular started out as a litigation funder, and our business model was waiting on law firms to come to us with clients who required funding, and then we reviewed their papers and took a view on whether or not to fund it. And actually, we recognised that that made for slow progress in collective redress. The claimant bar in this country and in most jurisdictions outside the US has been slow to grow, the teeth that I think is required to really make good on the promise of collective redress. And so, in part frustrated by the lack of progress on this, we built another business alongside our litigation funding business, which was to be that originator, to be that incubator, the private sector version of the Grata Fund, to identify large-scale corporate wrongdoing that has caused loss to large groups of people, where we can bring them together, help them engage, and if required, provide their litigation funding. And that's precisely what we're doing. And as I said, we started in the security space, so our clients are institutional investors who have suffered from decline in share price in public equity companies associated with ESG failings. But we are moving into these other spaces, and I gave 3 examples there. Those are not cases that we're sort of passively waiting for law firms to come to us. Those are where we have a team of legal, accounting, economic, and other professionals building those cases. And if the time comes when litigation is required, we'll then invite the law firms to Beauty Parade for the opportunity to run those cases.
Great, thank you so much. Thank you, Steve. Thanks for the questions again. So our final session of today is a panel on the next frontier on nature impact and biodiversity loss-related litigation. We've covered on nature earlier today, and I very much hope this next frontier will very much become present very soon. So for this, I will invite our moderator, Professor Ben Groom. Professor Ben Groom is the Dragon Capital Chair in Biodiversity Economics at the University of Exeter. He's a member of the HM Treasury Biodiversity Working Group and tasked with looking at how to ensure biodiversity is accounted within cost-benefit analysis for public policy and investment. Thank you very much.
Thank you for the introduction. But I know nothing about the law, unfortunately. Which is good because we have some experts here that I want to introduce you to on our panel. First up, so Janeta Zedelakova, she is the director of the climate and biodiversity consultancy firm Planet Law Lab, and she's also appointed as a biodiversity risk advisor to the global think tank Commonwealth Climate and Law Initiative. She does research there, trying to inform companies how to take into account biodiversity risk in their activities, and she's written various papers on this topic. Next we have, is that enough? That's good, isn't it?
Perfect.
I mean, I'm reading these bios. I have to say, I've been thinking about some of my life choices and how I could have done more in my life. But anyhow, next we have Leon Kamhi. Leon reports to the CEO of Federated Hermes, and he's led the firm's responsibility platform since 2014. He heads Federated Hermes Stewardship Service for institutional investors and all the firm's advocacy, stewardship, and ESG integration activities. I could go on, a very extensive CV and bio here, but I think we get the picture.
I'm just old.
Last but not least, we have Jack White, and Jack has trained as a... Oh, sorry, Jake. Yeah, some of my glasses are I was going to say. Jake White, apologies, who trained as in a regional commercial law firm, and then moved to the city to practice intellectual property law. This didn't necessarily go down well with him, so he moved rather quickly to the government and worked in the government legal service for the next 10 years. And from there, he's moved to work in the third sector, starting off at Friends of the Earth and now currently at WWF, and has a particular interest in human rights law, and was instrumental in the network, the WWF network's file to the first UN human rights complaint at COP27, focusing on deforestation in the Amazon. Ladies and gentlemen, our panel for the next 45 minutes. Right, am I doing this right? I don't know. Anyhow, right. The first question that we have up here, so we have three charge questions essentially, and the basic topic of the session is to think about nature impact and biodiversity loss related litigation. So my first question to you is really, how could biodiversity loss and nature impacts lead to liability and litigation, both to companies but also to investors? But before you get into the nuts and bolts of that question, I would like to know what the differences are between climate-related risks and biodiversity-related risks. I don't think that's always clear. Do we have any examples that we can help our audience understand the nature of this discussion?
Yeah, do you want to start?
No.
Janetta, why don't you take the lead?
Yeah, I'm happy to draw some differences from liability perspective. So when we look at litigation and how it has materialized in climate sphere and nature sphere, there are certain aspects, real life aspects, that change the legal practicalities of litigation. And the examples I like to give are the ones of causation. So climate is a global problem. Emissions are generated somewhere, but they enter the global atmosphere, and then the impacts are felt elsewhere. And from a causation perspective, for a lawyer like me, it causes problems because our but-for tests don't apply, and we have to go to attribution science. And that's one of the reasons that attribution science is not, well, I shouldn't say it's not difficult, I don't understand it, so probably it's not simple, but it's not as precise as we would like it to be to prove the causation between the harm caused and then the damages at the end of the day. And with biodiversity, it's very different because biodiversity, so I said climate is global. Biodiversity loss is always localized. You have a point of impact somewhere, usually in a biodiversity-rich country like Colombia or Brazil. And therefore, the causation really becomes it's still not a question of but-for, but what we have seen is a question of tracing. And it's a tracing of the biodiversity impact in a biodiversity-rich country to entity that has profited from that impact, the parent company, or the main supermarket. And when I say tracing, what we have seen is litigants, strategic litigants, tracing through 3 different means. One of them is ownership structures. So we would have tracing of ownership structures from the country of impact to the country of profit and the entity of the profit. Now, there are complications, especially if when you trace the ownership structure, some of the entities are incorporated in secrecy jurisdictions where you can't, literally your tracing stops. That's why some litigants look at supply chains, and they would trace supply chain of usually meat-based products. I'm told that it's much easier to trace meat and animal-based products than plant-based products, and that's simply because of bulking. So if there is a plant-based product, it gets bulked on the journey, and therefore there are so many intervention points in the supply chain that you can actually lose it, whereas meat is simpler and leather is simpler. This is why we see some of the biodiversity cases focusing on leather and beef, because you can trace it more easily. And the third way of tracing, so I mentioned ownership structure tracing, supply chain tracing. The third way of tracing is money. You trace money, and there is one case that was filed late last year in France against 4 banks for holding bonds in companies that have contributed to illegal deforestation. And I think that's quite interesting, and I'm quite curious about how tracing of money can lead to liability, because unlike supply chains or ownership structures that can be complex or obscured by legal structures, anti-money laundering, because of how money laundering financed terrorist activities in the past and probably currently as well, the laws are quite strict and the liability is in place. So actually tracing money from a country of origin to the country of impact and to the main profiteer of the biodiversity loss can be quite a huge, can have potential for a huge liability. I have no data, one case, but legally speaking, I think the structure is in place there.
Jacob, you got anything to add?
Yeah, a couple of things, I suppose. So the first would certainly be, I think generally when we're talking about climate, and we're talking particularly climate in a litigation, from a litigation point of view, we're talking about it as a kind of anthropocentric threat. So in other words, climate change is bad because it's a major risk factor for people. And that's totally understandable, and that's totally right. And the law is, after all, a human construct, and it protects people first and foremost. I think there is definitely an analogy with aspects of nature litigation where nature is we're thinking about nature really essentially as ecosystem services. So nature is the provider of clean air through forests, through sea kelp. Nature is the provider of clean water, food, medicine, construction materials, etc., etc. But I think we have to bear in mind that there are also those other elements of nature which are not necessarily about us or placing us center stage. And whilst those ecosystem services are typically more easy to get at and to protect through the law, because the law fundamentally protects people, those elements of nature which we're trying to protect almost for and of themselves are typically more difficult to get at and typically less well protected. And the super simple example I tend to give, and I were just chatting before, is river pollution. River pollution's got a lot of people in this country up in arms, and rightly so. Totally get it, totally down with it. But there are really two very different drivers which illustrate the distinction I'm trying to draw. One is sewage. Nasty stuff. Comes from us, poses a health risk to us when it's in a river. Not that difficult to get at. The other is agricultural pollution. Doesn't come from us, ends up in the river because of us, but doesn't ultimately emanate from our bodies. Doesn't pose a health risk to us, but is, if anything, a bigger driver of the collapse of England's rivers, and indeed Wales and Scotland and the rest of the UK. It just gives you a sort of flavour, it seems to me, of these sort of two categories of nature and biodiversity litigation, which end up tending to need to be handled in slightly different ways.
Thank you very much. I mean, I work a lot with bird data, and during the 70s, during the mechanisation of agriculture in the UK, you can see the drop-off of populations of birds through the UK. Precisely for these reasons. Yeah. No one's speaking up for the birds at that point. Leon, I don't know whether you have something to contribute to this, but maybe you'd like to address the broader question about liability and litigation on biodiversity and nature.
Okay, so I mean, full disclosure, I'm not a lawyer. Further full disclosure, I'm a bit of a generalist when it comes to sustainability issues and how they drive value. So I work for an investment manager. We manage funds. And the other thing we do, as Ben said, is we engage with the investees to try and get companies to do what's right for the end investor. So we're trying to create lasting, enduring, I could say, sustainable wealth for investors. That's what we're about. And as part of that, energy affordability, food affordability, and the security of both is really important. Job security is really important. And nature is becoming an increasing topic which we're engaging with different companies. A little bit nascent, and I can come back into that. So the question which Ben sort of asked me to answer was, how do we see litigation risk relative to the other risks which there are in nature? And the answer to that, I would say, is no, and then yes. So at the moment, I would say litigation risk isn't that big a risk relative to the systemic and physical risk which there is. So the systemic risk is huge. I think people suggest there's going to be significant reductions in GDP, etc., if we don't address nature. I think UNEP put out some numbers like $11.1 trillion of necessary investment by 2050 to address reforestation, regenerative agriculture, sorting out the peatlands, etc. It's a lot of money. So there's a huge systemic risk to the economy. And as I read somewhere today, someone said quite nicely that biodiversity is something which people talk around the dinner table about, but actually it's much more than a nice thing. It's something which drives the wealth in the economy. Without it, we wouldn't be able to do what we do. And then when you think about physical risk, I can start seeing the impact of extreme weather on supply chains and the like. So from an economy point of view, there's some huge risks here. And as an investor, or representing the investor, that's really important to them because they invest in the whole economy, so it's very important to them. But from a company point of view, right now, it may not be that important. So that's the answer of no. If I then answer, why do I say yes? Because there is the threat of regulation. So we've got the end of 2022, the Kunming-Montreal Global Biodiversity Framework coming in, and then there's my colleagues here will know much more about all these things, nature of rights. The French have come in with legislation, the UK has with its Environment Act and also a net biodiversity gain, and we've also got TNFD coming in. So there is regulation, and when the regulators start, they keep going. They're going to keep going. So there is that threat of regulation. And the reason why that's important to us as an engager with a company is one can point out scenarios where not addressing nature is not going to be good for value. And indeed, last week we had for the Stewardship Service, we had a client advisory council where 50 clients came in together, and we had an independent academic who's done quite a lot of work on our engagement to prove whether engaging on E, S, and G actually leads to risk mitigation or increase in value. And he said he looked at 3 things on nature. He saw us engaging on more disclosure. He saw us engaging on what's the vision for nature to the company. And the third thing he saw us engaging on was on short-term, evidenceable changes to nature, to action of nature solutions by companies. So on the first 2, he didn't see a link to value. But on the third one, he did. He saw a material reduction to systematic risk on those things. So it will impact value. And I believe he's seeing that because of the threat of regulation. Because investors are saying, at least they're doing that. I can breathe a little bit. So I think no and yes.
For sure. Fantastic answer. Yes, very, very interesting. Okay. So there's an opportunity in nature-based solutions because of the regulatory lines that are being drawn in recent years. That's essentially what you're saying.
Yeah, and the regulation that will come,
and will come.
Like we expect to come.
Yeah.
Because we can't afford to destroy the economy.
We cannot. It's true. I'm an economist, so I should know about that, really.
I was an economist once.
Fantastic. Okay, do you have anything else to add before we move on to the next question?
I wanted just to add a couple of things. Sort of slightly flipping your question, if I may, your first question, if I may, I think in broad terms, I see very significant overlaps between climate litigation and biodiversity litigation. I see them as going in a very, very similar direction. They're both systemic risks. They're flip sides of the same coin, it seems to me. They're 2 elements of the environment. One helps tackle the other. It's going to be very difficult to tackle one without tackling the other. And I think, as Leon was saying, you've got that same sort of those 3 categories of risk which you're going to need to juggle. The only other thing I wanted to add to Leon's analysis was perhaps a slightly different one, is the degree to which I think litigation risk can possibly both help to drive transition risk, in the sense, as Leon says, litigation begin, where litigation starts, regulation ends up. And also I think it helps to crystallize the threat of physical risk in decision makers' minds. So in some ways I think litigation risk helps unlock and to spur action in the other 2 categories.
Excellent. I'm seeing the law as an incentive mechanism now through my economic lens. That's terrific. Thank you so much. Right, I'm going to move on to the next question now, which concerns how we can think about greenwashing and misleading disclosures in the context of nature-related litigation risks. Jake, do you want to lead on that?
Yeah, sure. I mean, as we know, certainly in this country, we have a relatively highly developed legislative framework which bites on misleading advertising broadly, which is what we're talking about, isn't it? When we're talking about greenwashing, I see absolutely no reason why this should not apply equally to biodiversity and to nature as it does to climate. At the level of principle, really no reason at all. Here I'm talking about principally instruments like the Consumer Protection from Unfair Trading Regulations 2008, if we really want to get our sort of law hats on. But I think there's that sort of driving role, it seems to me, for the bodies like the Advertising Standards Authority that has this really important soft law role to protect consumers in inverted commas, but offers redress for both for consumers and for NGOs in this space. And they've taken a very proactive, robust position on greenwashing in the climate space to date. So we've seen the HSBC decision, we've seen the Toyota electric vehicles decision, we've seen the Equinor decision, which was perhaps in some ways the most impressive, where there wasn't actually a paid piece of advertising. It still came within scope. It was still held to be objectionable, which was really quite exciting. Obviously, the ASA are not the only regulator in town. You've got the Competition and Markets Authority as well, and in the finance space, you've got the FCA. I think we have to accept that some of the terminology around nature and biodiversity is less well understood than in the climate space. So net zero is obviously a term that we're all banding around, and even that isn't perhaps super well understood by consumers. But nature positive is perhaps even less well understood. So I'm certainly aware the ASA are commissioning research in the food space in particular to look into consumer attitudes. And I think we touched on very briefly beforehand, Ben, but they're also, I think, waking up to the risks around offsets and just how quality, in inverted commas, that market is or is not, and the degree to which claims about offsetting on which corporates obviously frequently heavily rely can be backed up and substantiated.
Just a quick question about whether or not greenwash is actually illegal in any sense. And can I do it? Could I greenwash and not be breaking the law, or how does it work?
I mean, if you're selling something and you're misleading consumers, in particular because your advertising is untrue, then broadly speaking, you're at risk.
Okay. I better not do that then. All right. Jeanette, would you like to follow on from that, please?
Yeah, so a couple of years ago, 2-3 years ago, timeline flies, I was doing 2 pieces of research simultaneously. One of them was on plastic litigation, and the other one was biodiversity. So I was wrapping my head around a relatively new field in terms of the scientific basis. And the big question in both was greenwashing. And I was quite surprised to find out that unlike what I was talking about at the beginning, which is causation question is very different from climate and biodiversity, when I was doing this research, premises greenwashing and law that regulates greenwashing in the UK, there was no difference. There was no difference in terms of how you would formulate a case based on the sustainability subject matter. So whether climate change, biodiversity, plastics, or if you go to ESG disclosures under the Corporate Sustainability Reporting Directive, the legal questions are the same and only the subject matter differs, but there is no difference in causation. There is no difference anywhere else. And that was quite interesting because I was thinking why, and then I was like, probably because this whole thing is a human-made construct. When we have damages-based claim about biodiversity or climate, they touch the ground of the earth, which means there is a different circumstances on the ground. But greenwashing, advertising, disclosures, that's something we made up. So the ground is the same, just subject matter changes. It was quite interesting to see, and the reason why we haven't seen so many, we've seen some plastic-based litigation in the UK and elsewhere, less so in biodiversity, but it's simply because companies are not yet making those high-flying claims about biodiversity, but it will come. And I think with CSRD, I know that there were some opinions voiced about perhaps not having or bringing or increasing liability risks. And from my perspective, I don't necessarily agree with that. When I was reviewing the European Sustainability Reporting Standards, there's a huge part of the standards that actually talks about how you should report in terms of your language, how you should report when you use like estimated data and actually hard data. And that language is a question of liability risk. If you get it wrong and you put out that report, which instead of should says shall, or reports estimates as hard data, that's a huge liability risk you are actually exposing yourself to. And that wouldn't be only, and I want to say, we are beyond biodiversity liability here, because that's massive ESG liability, because CSRD covers ESG. It doesn't only cover biodiversity.
I guess the question I had was that, we struggle in economics because what we want to do is understand the connection between biodiversity, which I mean sort of, number of species, the variation in species, the genetic diversity, that kind of aspect of biodiversity, and economic outcomes, anthropocentric typically, unfortunately, sort of consequential stuff. But the causality there is really very, very difficult to establish. And I was just wondering whether that spills over into issues concerning greenwashing. It makes it very difficult to establish, and it makes also lots of claims potentially plausible and difficult to falsify.
So nature is smarter than people. And because we came up with, marketing, disclosures, advertising, it's simpler because it's what you say that creates your liability. It's not necessarily what happens. So if what you say can be backed by evidence and it's relevant, then you are not greenwashing. So I think I wouldn't say that the same difficulty translates into greenwashing claims, but it's just because they are based on man-made constructs, and those are as simple as we are, whereas nature is much more complex.
All right. I told you I wasn't a lawyer, didn't I? That's very sensible, and you helped me through that. Thanks. Leon, I was wondering what experience you've had at Federated Hermes. Maybe you don't want to answer it this way, but what experience you've had with greenwashing at Federated Hermes? or do you run up against this as a threat to your activities?
Sure. So, big believers in do what you say and say what you do. I mean, that should be the bottom line, really, and there should be nothing more to it. But it has gone further because the regulator and people I don't know how many investors are in the room, but you may have heard that we've been exposed to SFDR in Europe and soon to be exposed to what the SEC is requiring. And when the regulation turns into more of a labeling regime and starts saying what is green and what is not green, and then you start to have to sort of, for commercial purposes, to try and change yourself to what the regulator thinks is green, then you start getting into difficulties. But if you stick with just being able to tell your story, and with TCFD, I felt there are certain things which you need to disclose appropriately, but you're able to tell your story. And I think with TNFD, that's going to be the same. And so that's very positive. I think one must move away from wishy-washy language, but also not to overextend what one's claiming, and to be honest and humble about what goals one might be looking to achieve. And I think if one does that, my compliance department may disagree. I think if one does that, then one should be on strong grounds. And the compliance department does look at what we put out. And this year, for the first time, we've sort of done a TCFD report for 4 or 5 years, but there's never been anyone looking at it from a regulatory point of view. This year, they will be looking at it from a regulatory point of view. So who knows, there may be an I dotted and a T crossed as a result.
And just out of interest, Federated Hermes find the TNFD, the framework that it provides, a useful organising framework, or?
So I think with climate change, we've sort of done disclosure and we've sort of done governance in terms of asking what companies need to do. In fact, we've probably overdone disclosure. I think with nature, we're still trying to work out what the impact of nature is on different companies in different sectors. And so the disclosure phase is really, really important. I hope that we do it in a way where we disclose on what drives decisions, business decisions, and impact rather than disclosure for its own sake. But I think TNFD is going to be really important, and if implemented well, should be really, really valuable, because then we'll understand the overall issue and then know where to push. But ultimately, we're looking for a redress of the nature we're destroying.
Terrific. Anything more to add on that issue? Okay. All right. Then we will move on to the final sort of question. Actually, I wanted to just one more. Just sorry to put you on the spot again, Leon. But so Federated Hermes has a long history of engagement with companies rather than necessarily divestment. Is that a good sort of description of the ethos at Federated Hermes?
Yeah. So first of all, we believe it's our clients' responsibility to decide what they want or don't want in the portfolio. So when you divest, if I'm defining divest, I'm going to define divest as exclusion. So excluding specific activities. And often a client wants to exclude specific activities to be in line with their values or ethics and the ethics and values of their beneficiaries. And therefore, for some, they don't want to be invested in fossil fuels, or they don't want to be invested in tobacco, or they don't want to be invested in arms companies. So that's more that approach. And we can have thematic funds which cater to that. But our overall approach, especially in secondary markets, so a secondary market is where the company already exists, the capital plan already exists, but the investors are buying and selling the same thing, but not really having an impact on the actual capital allocation which is going on within the company. So in that way, the only way we can influence the capital allocation is through engagement. Because otherwise, all you're doing is investing in what's already good, or in other cases, investing in what's already bad. You're not actually having an impact. So we believe the only way you can really have an impact and benefit the end investor is through engagement.
Terrific. Thank you very much for clarifying that. All right, we'll move on to the last question, which concerns litigation against directors' liabilities on nature and biodiversity impacts. We've had a bit of coverage of this already in the conference, I understand. But can you tell us what your experiences are with this? I'll start with Jake, I think.
This is perhaps not so much an area of specialism for me, I have to say, and obviously we've had a session earlier. I'm very happy to pass to Leon or to Janetta to speak first on this.
So yeah, the session earlier was delivered by Thea and Sharif, who are the experts on the opinion that was published. What I often do, I'm much better at the big picture than the nitty-gritty of the law. And what I took out from working and instructing the opinion with Pollination on behalf of the Commonwealth Climate and Law Initiative, and then also reading it afterwards, is the messaging is really important about nature risk being the same as any other risk that a company has to manage. And I think that messaging needs to sink into the minds of directors much more than just on the basic level. Because that also means that, and this is where when I talk to boards, I often have that moment of awe with them when I tell them, you have to internalize your externalities. And they look at me and it was like, what do you mean? And I'm like, you remember the pollution that was permitted and you never cared of? Now you have to consider it. You know your emissions that are brought into the board as something you have to consider. And I think those are, the opinion doesn't only talk about biodiversity, it also talk about not only nature risk, but also climate risk. And when you expand it beyond and you look at disclosure obligation under CSRD, for example, it really brings everything to the board as something they have to consider. I'm not a fan of litigation, and I know it's not a popular thing to say as a lawyer, but I think litigation is useful to a point where it creates liability risk, then at which point the liability risk forces the companies to do the right thing. And when you do the right thing, you don't have to be sued. And that's where I see the place for litigation. So I do agree what Sharif said is essentially that there are other means of penalizing directors, if you will. Things like, reducing their packages, payment packages, which has personal impact. And I'm much more, I don't want to say aligned, but I predict those impacts being much more impactful than litigation itself. And that's simply because of how difficult it is to actually formulate and bring the litigation because of different barriers in the UK system. But the basis of the opinion is that directors need to consider these risks because they are no different from any other risks that companies run. And I think that's quite a powerful messaging there.
Okay. Yeah, in economics we'd say that the credible threats are never really enacted in equilibrium. So yeah, you wouldn't see them enacted, but it's good that you have them.
But like need legal definitions of probably 3 words that you used in that sentence.
Leon, I wonder what you have to make of the director's liability story.
So I started out by saying that the threat of regulation or oncoming regulation could well impact the decisions which companies make in favour of nature, and certainly believe that. But in terms of asking us as shareholders to sue companies or the directors feels a bit uncomfortable. And we often, class action lawyers often come to us and say, well, do you want to form part of this class action and you'll be able to get some money back? And the reason it gives discomfort is because in a sense you've got the existing shareholders paying the previous shareholders for something which happened at the time the previous shareholders were there. And that's not great. And then the lawyer gets, in some cases, 20 or 30% of the proceeds, which is a leakage, shall we say, from the end investor. I'm sure it goes to good places, but it's a leakage, nevertheless. And last year, I think it was, and I don't know if is anyone from Client Earth in the room?
The back.
No, Client Earth. So you did something with Shell last year, and you asked us and others whether, I think there were 3 or 4 options. On one, would we like to be part of the class action? And the second one was whether we just simply wanted to support it. And there was a couple of others. And this was about suing the company for not sort of following what the court in The Hague said. I'm saying there's going to be a lot of value destruction by not having a net zero plan, etc. I think something like that. And
I should just clarify that becoming part of class action was not one of those options, but there were certainly different forms of supported letter presented
okay.
to investors.
Okay.
Thank you.
So at the time, thank you for clarifying. Please clarify anything I say, because this is some time ago and I wasn't right at the coalface on it. So the reason we did share it completely with our clients. So we have clients, and we had a client alert, and we discussed it with them, and it was for each client to decide whether they wanted to do one of the things which Client Earth were asking. But the reason we were uncomfortable with it is we feel that the most appropriate way to try and get the company to change its capital allocation, which is what it was, and get the directors to do. And there wasn't much disagreement with what Client Earth was putting forward with us, with what we felt that Shell should do. We felt that actually the governance structures were in place. And then also the second thing was it was going to be quite hard to prove the investment case as well. So there would have been potentially quite a strong defense, and we'd much prefer to do this, to try and get the change to happen through engagement. So that was the approach we took at the time on it. And it goes back to the type of class action and the reasons why we get uncomfortable with class actions.
Very interesting.
No, fully understood. If I may, just for 1 minute, I think...
Actually, you know what we're going to do now is have some questions, and so maybe we start with you.
Oh, very good. Wonderful.
Comments and questions, yeah.
Yeah, if I may just respond, I think that's really insightful. And of course, there is a spectrum of opinions across the investor pool. And we touched on that this morning in terms of more progressive, perhaps higher ambition investors and those who are lagging behind. And I'm not suggesting for a second that Hermes is one of the laggards in that pack. And I think Hermes has demonstrated that over the years. But certainly there is different appetite and different understanding among the investor community of the extent of climate and nature-related risk. And I think it's right to say that Hermes has a very good understanding, to my mind, of that risk. And that's, to be honest, Leon, I think rather evidenced by the fact that you're sitting on this panel here today.
It was a risk not being a lawyer and not knowing nature.
Yes, but I'll just finalise that observation by saying that we were very, very pleased with the what was really, I think, unprecedented support from institutional investors for the claim. We ended up with a pool of investors explicitly supporting the claim with over 12 million shares in the company, over $500 billion in assets under management cumulatively. And then we had a further pool of around the same amount, supporting in much the way that you described, Leon, supporting the underlying issues in the claim, but not necessarily agreeing that litigation was the right outlet for that frustration. And then quite interestingly, just to finish off, we had a further pool of investors saying, look, we're not actually shareholders in the company anymore. We've divested precisely because of the issues that you, Client Earth, are now raising. But were your claim to be successful, and were the company and the board to be ordered to implement a genuinely Paris-aligned strategy, we would consider this company for reinvestment. Now, legally, those investors are no longer shareholders, and so that carries little legal weight in the action. But I think that sends quite a powerful message to the company in terms of the possible, if there's sufficient momentum, the possible restriction on that access to capital.
That's fascinating, thank you. I've just got one more intervention from one of our panelists first, and then I'll come to you, to our colleague here.
Yeah, I just wanted to offer a slightly different perspective, hence going last, which was to think about the supply chain litigation in this space. It seems to me that supply chain litigation is a sort of equal and opposite litigation strategy, which is going to be hugely relevant in the biodiversity and nature space. We heard from Anna Carolina this morning on the Mariana Dam case, which is a kind of card-carrying, quite the biggest card-carrying example of supply chain litigation one can imagine. And I think, from our perspective at least, whilst I think we applaud and support claims based on directors' duties from the sidelines, I think we do see quite significant hurdles in that space. And I think by contrast, certainly in this jurisdiction, we see supply chain litigation as blossoming. And as I say, from the point of view of taking problems which are frequently, halfway around the world from the end market and the end consumer, and finding a mechanism to put those issues and that environmental degradation center stage in this jurisdiction, and to campaign around that is enormously exciting. And we've seen cases like the Indian shipbreaking case, I don't think anyone's mentioned so far today, Begum, which again is sort of a not dissimilar kind of case to Mariana. We've also obviously seeing steps taken, as Jeanette has mentioned, in the finance space. Also, we're looking along the value chain, all the way down to the deforestation in Brazil, and saying that, that is causing legal liability risk and indeed illegality back in France. So I think this is also a really exciting space, and I wanted to bang the drum for it briefly.
Thank you very much for that. All right, so we'll open the floor to questions for about 5 minutes, and this gentleman here has had his hand up for about half an hour. So please introduce yourself and
the room will understand why. I think there's a very interesting point emerging, which is about capital allocation. The investment industry tends to define stewardship as proxy voting and engagement. So my sharp question to Federated Hermes would be, at what point do you decide that engagement is inadequate, as many investors have, and therefore your business model should begin to withdraw capital from places that are destroying your clients' interests, and you may know that before them? And I sort of flip that into a question for the lawyers, and I say this as a visiting fellow at GSI, so I learned my economics from Jean-François Mercure. At what point do the lawyers regard the finance sector's interpretation of stewardship, which is sort of too low level, and, will engage till the cows come home, and actually regard the finance sector's specification of stewardship as greenwashing?
All right, this sounds like a difficult question, or two difficult questions. Maybe Leon, you go first, and then.
So just on capital allocation, so I was talking, when one is in secondary markets, when one sells say a carbon intensive company, then one isn't changing the level of carbon in the economy.
That depends how much policy engagement you are doing to change the rules.
Sorry, can you go on, explain that, because this is the bit
Yes.
I'm not understanding.
If you're selling it to the Koch brothers, then policy engagement means that the Koch brothers' economic activity is constrained. So beyond capital allocation, you get the rules under which capitalism operates to make some economic activities less attractive than yesterday. So stewardship is initially ownership, then capital allocation, then policy engagement.
So completely understand the policy engagement, which we do a lot of. And the reason we do policy engagement is partly because there's only so far you can go with the companies until the investment mandates change, which if an investment mandate instructed us to buy a coal mine and then close it down, right? They could do, they don't often. Then we can directly impact that in that respect. So completely agree, and policy engagement is really, really important. And to the extent we have influence with governments and others to try and get that change to happen. So that's where I am. I haven't really changed on the capital allocation in secondary markets. The only way you can influence it is, and then do we have the power to do it? Because we will, let's say we represent 1% of the company. That's 1%. To make a decision, instructed decision, you need 51%. And so it's important that one states one's opinion, and then other investors also need to come in with the same, and then the company may eventually change. Or alternatively, the company internalizes what the answer should be. So if I'm an energy company, an energy company might have I'm going to be very simplistic, two types of investors. One wants it to continue to investing in fossil fuels because they know what cash they're going to get. They sort of understand the risk. They can see the scenarios of a 1.5 degree world, of a 3 degree world. They can see those scenarios. So from a fund investment point of view, it's quite a certain outcome for them. More certain than an energy company switching completely or significantly to renewables, where there's a lot of investments in technologies which aren't really there yet. However, a company who sees the future knows that in 2035 there's unlikely to be much fossil fuel left because the transition sort of has to happen. And so they may take a different view. But you've got to understand that companies are facing that. It's not straightforward. It's not obvious that they have to go for the transition. And we should be respectful of that. But we, on behalf of our investors, are encouraging companies to take a strong view on where the transition is and what investments they need to make today.
Janette, can you address the second question, please?
Yes, so I wrote it down as, at what point does law interpret finance sector's specification of engagement as greenwashing? Stewardship as such. So...
And then when do you start suing me?
That was the question I didn't ask.
We were all thinking it, though.
That's circumstantial, that one. But so from legal perspective, a lot of the terms that we use in sustainability space generally don't have legal definitions. So even net zero, when you look at Advertising Standards Authority, the bottom line is you define what it means to you, and then you stick to what you said. And that will go to stewardship, it will go to engagement. So let's say an investor like you would have its stewardship engagement strategy. And you say, we give them 3 chances, right? We tell them what we want them to do, they fail. Okay, second chance, the third chance, and then we disengage. Do you stick to what you have said? If you do, it's not greenwashing. And then the second question, how do you talk about what you have done? So it's about how you define what you perceive as stewardship and engagement. And then have you talked about the actions that you have taken that in a way that aligns with your definitions? So it's a lot of, it's your space to walk, and you have to walk it carefully, but you have a lot of scope to actually avoid greenwashing and mitigate your risk if you just do the right thing and do what you said you would do, very much like Leon said at the very beginning. So it's always circumstantial, but my message is you have so much scope for avoiding or creating your own liability in how you talk and how you define things.
There is a hand. I'll come to you afterwards.
Thank you. Well, I'm Anna Carolina from Pogus Goodhead,
And believe it or not, I also don't like litigation. I think that it's an inefficient way sometimes, but as I spoke this morning, is often the only way to drag corporations to the table. I would like to think about something different and actually invite anyone here in this room that has an idea on this to come and talk with me about it. But I would like to hear your opinion on how could we drag the companies to have this kind of conversation and solve it more efficiently. So less fees spent on litigators, barristers, court fees, translation of documents, discovery sessions, and more on scientific evidence, the experts diving into that, and planning not only to compensate those that suffer the damage, but to change the practice. The difficulty is that if you don't have a good threat that is credible, it will be very difficult to bring the companies and their stakeholders, the investors, the directors, and of course the bondholders and shareholders. Do you have any insights on that? Have you thought about it? I would be willing to hear. Thank you.
I don't know who wants to take this first. My answer as an economist would be just price things properly. You get a very long way down that road. But
so once I did it was a kind of a debate with a class action lawyer, and I did the Peter versus Paul argument. And then they said, you know, we put a lot of effort into suing this company, and we actually achieved something. And got a payment from the company for the shareholders. So if we just forget about the Peter and Paul argument for a moment, that actually, there is a benefit there. Why is there a benefit there? It's because other companies won't misbehave. They'll see what happens, and they're going to be, you know, careful before they do something. So I think there is that benefit, but please not too many.
Janetta. Oh, Jake. Janetta, I think, was poised. Yeah.
Yeah, I'm thinking like out of hundreds of things in my head, which one is the right to say. I think it depends on the sector. So when I work with players in the hospitality sector, for example, or pharmaceuticals, they appreciate their dependency on biodiversity much more than other sectors. And for them, to do the right thing to make them understand what their biodiversity dependencies and impacts are took 15 minutes presentation. It was really quick, and they were so keen to engage. I think we received like 4 pieces of instructions from me speaking for 15 minutes because they understood very clearly if you have a hotel and there is a coral reef and the tourists come for the coral reef, if that disappears, your business disappears. It was quite simple. So I think it depends on the sector. Some of them are more receptive to your messaging than others. And with the difficult sectors, I think that's where you have the scope for the stick, for the litigation to create the liability risk. And in that sense, I like to bring in the example from climate litigation, where we have 2 climate cases in Europe seeking damages from companies for climate harm. So one of them is by Peruvian farmer against RWE in the Netherlands. Another one is by Indonesian fishermen for damages that climate change has caused and is causing, adaptation costs including, to their island, and they're bringing the claim against Swiss cement company Holcim. And both of them are damages-based claims, so a lot of attribution science, and they have been, especially the Peruvian farmer one, has been before courts for years now. And those 2 claims, when they get decided, what we will have is a court-approved formula to calculate damages on the basis of contribution to climate change and then attribution science to the impact. And that's where those cases, there are litigation currently, but they will create a huge liability risk. And when you talk to strategic litigants, the way they want to use those cases is strategically. So once you have the formula, you will write a pre-action letter with the formula to the 30 biggest multinationals in the Netherlands. And essentially the message will be, we have just calculated how much you should pay for your historic contribution to climate change. Pay now or we'll sue you. And by the way, we will sue in a way that all the media outlets will know. You will be all over the papers. So your reputational damage is massive. Maybe directors' duties will come in because this is clearly mismanagement. So pay now and you will avoid all these other costs. And I think that will be the argument that will be used against those who don't see how they should change now. That litigation concluding and creating the liability risk.
Right. I realise I'm keeping you from whatever it is you're doing after this, but I think Jake would like to just intervene one more time, and then I think we're going to have to wrap it up, and we'll take your question up in the common space outside.
Super briefly, it's a great question. It seems to me it's a twin-track strategy. I think I'm more or less saying what Jeanette is saying, but using different words. So at WWF, we have corporate partnerships, as you may know, for better or for worse. And one of the sort of theories of change we're using in our corporate partnerships is about taking the good guys and putting them on a pedestal and encouraging others to come with these good guys and to join them on the good step, so as to highlight and make even more crisp and clear the gap between the good step and the bad step, the naughty step. And that is, much to my surprise, a more effective theory of change than I, for one, had certainly expected, which is where I think the work that you do, Anna Carolina, and others comes in, because you're applying the stick to those on the naughty step. The only other thing I wanted, which is equally valid and important, the only thing I wanted to say was it seems to me there is almost always a dialogue going on in these big institutions, and that what we're both doing, both those of us working with the good guys in a sort of more engaging way and those of us working with the bad guys with more of a stick, is enhancing one of the voices in that internal dialogue. And that's what we're about doing. We're just using different strategies to get there. But in my mind, the truth is we need both.
Terrific. I hesitate to do this, but can you summarise what you've just been saying in 3 words each? Leon, let's start with you, and then we'll really wrap this up.
Hopefully we'll see change, and through whichever approaches, whether it's engagement, or indeed regulation, or in extremis litigation. Let's see if we can redress some of the issues in nature.
Not 3 words, but okay, fine. That's good. I did say sentence before, it's true, so you're good.
I'll have 2 things, because I was asked to say one thing. So for me, let's just get lawyers out of business. Like, if this goes well, if communication and people learn how to communicate clearly and stick to what they say, the world doesn't need lawyers. It would be a beautiful world. And the second thing I was asked to say is to remind everybody from the organizers of the conference to fill in the questionnaires. I was told it will be more impactful from the panel, so I'm sticking to that word.
Indeed. Jake?
My 3 words would be, it's systemic. Sorry, that's 2 words. And my second phrase would be, it's not different. It's really more of the same. It's business planning, it's business risk, it's all the same stuff. And my third would be multi-tracking, building, I think, on what Melissa was saying earlier. It's going to take all of these different tracks to crack and unlock this problem, but it's doable.
Well, thank you very much to our panel. Let's give them a big round.
Excellent. Well, thank you very much to our moderator, to our panelists, and thank you really in general for today to all our wonderful speakers, eloquent speakers, panelists, and thank you for the virtual audience for again sticking with us. I have the job to summarize in a few more than 3 words today's session, and I'll try to be brief because I know you have other things to go to. But what I got from today's discussion is really a few things. So first, I think there is a little bit of a consensus in the UK and Europe at least that ESG, climate, and increasingly nature risks are financially material and they are potentially mispriced. And that's something that organizations need to consider and be aware of. I'm sorry to disappoint you, Janetta, but I think lawyers will continue to be in the business because it sounds like climate litigation will be here to stay and potentially grow, given the diversity of topics. So we have climate, ESG, but increasingly nature, biodiversity, just transition. I would like to flag how many times the word nonsense has been used today in a couple of scenarios, one being climate modeling for financial institutions, giving very unintuitive results that are not decision useful, the ExxonMobil case, the fact that the UK government is asking institutions for an orderly transition from corporates, but is now actually publishing an orderly transition plan themselves, and also within the US, really asking for ESG to be taken out of investment considerations and perhaps to be illegal in some parts of the US. So that word has been used a lot of times, which really puts in context, I guess, the quite polarized environment we are in today. But the positive side of it is that I think we've discussed today a number of tools that we already have. I think we need to double down, one, on the existing infrastructure, through ESG due diligence, which has been discussed, through stewardship, which has been quite a lot elaborated during this last panel, through trusted whistleblowing policies, through strong board governance, structure, accountability, responsibility, and the use of all of these board considerations to really mitigate greenwashing. And a number of times, as we've heard today in a couple of sessions, really through directors' duties, their directors' duties to the companies to really take into account ESG issues, climate issues, and increasingly nature and biodiversity issues, which, although we call them the next frontier, I very much think it's here and it will continue to stay here. There are also new tools that we've discussed today, data-driven. I mean, we are in the world of AI. Perhaps it's not quite AI, but using activist trends to really monitor where the core topics come up, who's doing it, what do they care about, how do they do it from a legal perspective, and also the use of climate finance for climate litigation as a way to really push the agenda towards action, really, and enforcement. Are going to be quite useful. But ultimately, I guess, from what we've all been saying, is really about really not going to the court ultimately. It's not really about going all the way to the litigation. It's really taking the action that you can as an institution today. And that is by being clear, having a robust, transparent action plan, building a really strong qualitative narrative, which perhaps doesn't rely on numbers as the immediate way to go. But that is really clear, transparent, well explained, and really gives a good understanding of what is it that the organizations are taking into account, are doing and planning to do, and by when. So thank you very much for this really insightful discussions, very diverse and rich discussions across a couple of opinions. I'm just going to thank once more to our sponsors, Allen & Overy, Pollination, Slaughter MA, as well as our supporters, General Counsel, Sustainability Forum, and GLG, and of course, CTM Financial Global for really bringing us all together and organizing a really insightful conference. That is all for today. So again, thank you very much for your participation. There will be a recording which will be available and will be sent to you via email. And just final reminder to complete the questionnaire that is in front of you and hand it in to the organizers upstairs. So someone asked me what do you do with it. That's what we do with it. But thank you very much.